What's good with it? What's good with it? Hey, what's good? What's good? What's good? Yes, coming to you in the what? Evening. What's good? What's good? Let me get this chat call out the way. Hey, Gospel Glam Cosmetics and Skincare. Hey, Warrior. Slim, what's good with it? Hey, Karen Johnson. Hey, Stephanie Holloway. Hey, Donovan. DB Wild Wild. Hey, Cool BJ. And everybody that's holding on to the window. Hey, what if I got one of them wonders? Remember they tried to show the back of who was Don Russell house or Don Russell mama house, and looked like the door was up in the the door was up, the back door was up there, and they had no steps and shit or whatever. Like if you went out the door, you was gonna fall on the ground. Did I see the right thing or what? I was like, boy, can anybody point me into the direction of that? Somebody still have that? I want to see that again. It seemed like somebody, like if you went out that motherfucking back door, your ass would have been fucked up. You ain't have no steps or something. I know I saw that. I can remember visions and stuff real well. What's up, Shawty? Hey, Mona Martinez, what's good with it? Welcome, y'all, or welcome back. What's good? What's good? So, listen, it's gonna be. My throat kind of hurt, but I'm gonna try to get through it. I don't know. I hope I ain't coming out with something because I got my throat hurt as well as my damn head. But I'm gonna try to get through it. So the time is here. After the time have been so near for us to read this damn New York appellate brief, right? Submitted by the one and only Jaybo. Yes, Jaybo. We're gonna see what she is appealing, right, for Mr. Kelly, right? Gonna see. I'm very interested to see if any you guys' theory winded up in her brief, right? I haven't read them. So we're looking for the BOP emails. We're looking for text messages and shit. A lot of shit. We're looking for a lot of shit. And it better be in there. Because y'all done kept me up morning, noon, and night arguing the same shit. And y'all said it was the golden ticket. So if it's the golden ticket, it should be in there. Right? We're going to see. Oh, we're going to get to the shit. Hold on. And remember, I said if I say something and you tell me it's wrong, that's fine, but just make sure you have the black and white, right? The evidence, right? And I'll do the same. I used to do that back in the day, right? So somebody asked me a question about I'm sorry, I'm going to my refrigerator. About the of course the damn parents and the text messages. And somebody said that someone said that the defense was able to call them or some nonsense. I don't know, but we're gonna put it up on the screen again. That way we can reference it, and I'll put it in my title, the text and the parents, to make sure y'all know how to. We need to know how to go back and you look at what I'm using to support what I'm saying, right? So we're going to take care of that right now. because I had to do a lot of pulling, had to do some additional pulling. So I always want to make sure that everybody got it right. Well, everybody that I care about get it right. The rest of you motherfuckers, I don't care. The people that's interested in the right, having it right or whatever. And so I'm going to prove what I'm saying just by using, what you should use to back up your argument, black and white. Some things, some habits you'll never break, right? Some of them you'll break, some of them you won't, okay? So this is no different. When you have when they, Lord have mercy, I'm getting the jobs mixed up. Okay, when they use case law and mandatory law, primary law to support their arguments and their briefs and their arguments, whatever, this is no different, right? I'm saying I'm in opposition. I'm opposing what someone said. I don't know who it was. They didn't tell me what someone said, but I'm backing it up with law, right? I'm backing it up with law. I'm backing it up with the decision that was in this particular case with regards to the matter, right? With regards to the text messages and the parents and all that shit, right? So I'm going to go ahead and straighten that out first, all right? If y'all don't mind. What's up, Shawty? I think I said Shawty already. So let me do this. Where is it? Okay, that's that. Okay, let me pull that there. All right. Okay, so when we were going through the, just get an idea of the stuff that we know she was going to argue, just pulling it out based on what she submitted through her appendix. I call it an index, but through her appendix. And we used that to see what she could possibly going to be arguing in her brief, right? What she's appealing. And like I said, she could have added more, she could have took away or whatever. Once we read it, we'll know exactly what it is, right? But we want to go back. I'm going to go back a little bit about this parent, with regards to this parent. And what she submitted when she submitted everything but her brief the other day, right? Yesterday. So she presented a motion that was filed back on 11/4/21. We already looked at this, but since I guess whatever was said confused y'all, let's go over it. So let me put it up here. And hopefully, what's up, Dynamite? We're going to get it. See, I don't put words in people's mouths and things of that nature. I don't try to infer from what they're saying. I don't try to do none of that. You know what I'm saying? And then sit up there and say, I'm 100% sure that's what they meant or that's what they said. If I'm going to try to decipher something or infer something from what somebody said, I'm going to use some paperwork. Okay? And if the parents say some shit, they said it. I just repeated it because they said it. If the judge said some shit, she said it. I just repeated it because she said it. Ain't got shit to do with me. You know what I'm saying? So that's just how I feel about it. And as always, I don't give a fuck. how you feel. Not how y'all feel, but you know what I'm talking about. I will probably be operating under disclaimer number 2. You remember, y'all, disclaimer number 2 does not apply to about 70% of y'all. 30%, yeah, it does. So let me stop shucking and jiving and get to document. Okay, so that's what I want to click on. All right. See, it's not. Well, I take that back. It's not that easy having the luxury of sitting back and going after, doing your shit after someone else does it, right? It's easy and it's not. One, you got to be able to explain what you're talking about. That's number one. Number two, you got to be able to explain what the fuck you're talking about. I got so many goddamn windows pulled up, y'all. I'm just looking for the right doc. Where is it? Should say special. Oh, here it is. Damn, at the top. Okay. Right here. I'm going to read it again. It says evidence about the victim's parents. All right. Now, this was included in Jaybo's appendix, her filings that she did on yesterday, right? Okay. It says evidence about the victim's parents. The government moved to preclude the defendant from introducing evidence that the parents of certain victims permitted them to spend time with the defendant or tried to profit from their child's relationship with them. Okay? Now, it says the government moved to preclude. What that means is that the government apparently, I don't know if it was a motion, I don't know what happened in court or whatever, I'm not sure. But whatever they received from the defendant, whether it was there in discovery somewhere or whatever, whether the government felt based on the evidence that the defense put in discovery or whatever, that they were going to try to come up with some theory about the parents, they were jumping ahead of it or whatever. Okay, I don't know if it was a prior motion to this with the defense. I think it was. Maybe I don't know if Farinello did or whatever. I'm not sure. But let me tell you this. When you see preclude with regards to the law, and I think preclude, this probably is also the Webster Dictionary definition of it. When you use the word preclude, but we're going to talk law based, that means that you are precluding it. Okay? That means you're preventing it. You're not even allowing it to exist nowhere. All right? You don't want it nowhere near the case. I'm trying to translate this in layman's term. Excuse me. So when you think preclude, you mean prevent. Okay? That's prevent it from coming in, prevent it from existing, preventing it is not here. Okay? Because if it's not here, you can't use it. Okay? If it's not here, you can't use it. When you see the word exclude, which is the word you're probably more familiar with, when you see exclude, that means that it exists and you're trying to get it removed from evidence. Okay? Preclude means prevent. Okay, there's two P's. Preclude, prevent, meaning you don't want it to be, they can't even mention it. It's not there. It's no longer a conversation. Okay? Exclude means it's there, it's a conversation, and we want it to not exist. Okay? Meaning you can't use it. It's here. We know it's here, but we don't want it to be used. Okay? It's not admissible as evidence, which is the outcome. It's going to be ruled not admissible. When it's precluded, the admissibility of it doesn't even matter because it wasn't there in the first place. Okay? But when you're trying to exclude it, the admissibility of it matters because they're trying to get it in. It's there. They're trying to get it in. It's going to go through the test with the rules of evidence to see if it's admissible. But when it's precluded, you're not even having to do all of that because it doesn't exist. All right? So let me read that line again. The government moved to preclude the defendant from introducing evidence that the parents of certain victims permitted them to spend time with the defendant or tried to profit from their child's relationship with him. This request was granted in part and reserved in part for trial. Okay. Meaning, she granted the prosecution their objection. She granted it, meaning that particular evidence will be precluded. Okay? Remember, this is pretrial matters and so on and so forth, right? But it was granted in part and reserved in part for trial. Okay? You know what they're talking about? They're talking about when we go back to that pretrial motion about the extortion. I'll show you that when in another piece of paperwork, okay? But when it says reserved in part for trial, that means that, remember when the judge said, well, if it's about extortion and you got direct evidence, then the defense can definitely question the parents about that or question whoever was giving that testimony about the extortion. But if it ain't about that extortion, then that evidence has been precluded. Okay? So that meant that the evidence about the evidence about the parents giving their permission to spend time with the defendant and try to profit from him was precluded. Okay? Let me read the next paragraph. At the August 3rd, 2021 hearing, the government represented that it did not intend to call any of the witnesses' parents because a parent could not consent to the charged conduct. Okay? Meaning the elements. Questions to the victim witnesses about whether their parents consented or permitted the defendant to have sexual contact with them would have been improper, meaning illegal defense. It's prohibited. It's against the law anyway. Okay? It says, however, questioning with good faith basis about a coordinated extortion scheme was permissible, including for impeachment. Okay, so if it was going to be about the extortion scheme and then they had direct evidence, then yeah, she was going to permit it, including using that particular piece of evidence for impeachment, meaning attacking someone's credibility, right? If they, are lying and so on and so forth, right? So that that little bit right there, right? So the parents were not able to be called for anything other than the extortion, if they are a part of that or whatever, or if they are a part of the charged conduct, if they are directly related to the charged conduct, and it's a legal defense to it. Driving her there, waiting outside the Dolphin Hotel, and all of that is not a part of the charged conduct. So it would be improper to put them on the stands for that reason. Okay, let me come around and make sure y'all got the clarity on this particular document, because we got documents today. Hey, Millionaire. Hey, Shaniqua. Hey, Miss Mo. Let me see who else came up in here. Hey, Georgia Girl. Hey, Sonia Davis. Okay, so we have that. Now let me bring up the other document. What's the one before that? I hope this put this shit to bed at some point. Okay. Now let me show you. Now that's her ruling on it. Okay. That was her ruling on it. Let me show you this. Now, this was from the prosecution, right? This was this the emotion and limine? I think this was emotion and limine. I'm sorry, this was a memorandum in law. Okay. I mean, the motion in support of the motion to eliminate. Okay. And anytime, when you get stuck on, you want to know why, they couldn't allow this, that, and third, whatever. Again, just because it came up, I'm trying to show you why it wasn't allowed. Why the defense didn't call the parents ultimately, because they had nothing to do with the charged conduct, the elements. So I'm finding that, hopefully, because I'm using their actual words and I'm not trying to too much translate it in layman's term, maybe you'll get it then. I don't know. But I'm trying to do the best I can to illustrate to you why. All right. So this is the prosecution's pretty much their motion in limine, right? This says the defendant should be precluded, okay, from making legally irrelevant, meaning illegal defense, and prejudicial arguments regarding the parents of certain victims. And in here, they talked about more than just Jane Doe number 5 parents, right? I believe. It says certain racketeering acts and substantive counts allege that the defendant coerced minors, including the individuals identified in the indictment as Jane Doe number 1, 2, and 5, to engage in sexual activity prior to their being old enough to legally consent to such sexual activity. To prove these offenses, the government expects to present evidence showing that Jane Doe number 1 at approximately 15 years old, Jane Doe number 4 at 16 years old, and Jane Doe number 5 at 17 years old spent a substantial amount of time with the defendant despite having not completed high school, and that the defendant may try to deflect the blame for his criminal conduct by offering evidence that the parents of Jane Doe number 1, 4, and 5 knew or should have known about their daughter's sexual relationship with the defendant. The defendant may further assert that to the extent the parents of Jane Doe number 1, 2, and 5 knew or should have known about their respective sexual relationship with the defendant, the parents thereby consented to such relationships. Okay? That pretty much destroys those text messages. Okay? Because we already saw where the judge granted the prosecution request to have this stuff, this evidence precluded. All right? So that already destroys those text messages. And legally it destroys it without this because, one, a parent can't consent to your underage child having sex with with an adult. Okay? Even assuming arguendo means, for the sake of the argument, that there was evidence to support such claims, the evidence would have no legal bearing because it's illegal defense. The conduct is illegal in nature as to the offenses with which the defendant is charged. Indeed, consent by either the parents or the underage victims is not a defense to such charges. Accordingly, the defendant should not be permitted to elicit testimony from the government's witness, including Jane Doe number 4 and 5, during cross-examination, introduce evidence or argue that the parents of the women and girls who the defendant coerced to engage in sexual activity were aware of, consented to, or were otherwise responsible for such activity. Such arguments are legally irrelevant and would only serve as a distraction to the jury. Remember, I said you can't introduce evidence that will confuse the jury. Okay? That's a part of the law. Irrelevant evidence is not admissible. Remember when I said, as Ann Donnelly as well has stated, if the evidence is admissible, it can't be admitted. If it is admissible, it has to be admitted. And this is under Federal Rules of Evidence 403, which I told y'all to go read. All of them. 401, 2, and 3. Evidence is not admissible where the risk of unfair prejudice substantially outweighs any probative value of such defense. Meaning, if it's going to be wildly prejudicial, then it's not allowed, right? Summarily, the defendant should not be permitted to introduce evidence of any schemes by the parents of the victims to profit or otherwise extort the defendant on account of the defendant's relationships with their daughters. Specifically, Jane Doe number 5 has advised that her parents proposed certain business ventures with the defendant whereby they stood to profit if the defendant agreed to such business ventures. And while she was 17 years old, encouraged her to take photographs of the defendant, which could later be used against the defendant, given, in part, her status as a minor. As discussed above, the actions of Jane Doe's number 5 parents have no legal bearing on the defendant's guilt as to the alleged crimes involving Jane Doe number 5. Accordingly, the government respectfully submits that the defendant should not be permitted to elicit any testimony or otherwise introduce evidence regarding any of the parents' involvement in business ventures or other means to profit from the defendant. Listen what it says. The defendant should not be permitted to elicit any testimony, meaning call their ass to the stand, or otherwise introduce evidence, means call their ass to the stand, and any other evidence, whether it be real, documentary, documentary, demonstrative, or testimony, or real. Okay, real documentary, demonstrative, and testimonial. Okay. Can't be any of that. And those just the larger categories of evidence. Can't be any of that. So they were precluded from being called for these reasons. Getting them on the stand to talk about, did your parents drive you to the hotel? Was she there with you? None of that would have been allowed, because that line of questioning could make it seem like you are saying that the parents consented. So going down that line of questioning wouldn't even been allowed. And it was precluded. So the defense couldn't call the parents just to put them on the stand. What they're going to you can't call somebody and put them on the stand and they can just talk about a rainy day or talk about whatever. Just can't put anybody on the stand. Okay? They have to be the 3 R's to the facts and the elements of the case. All right? So, no, the parents could not have been called unless it had something to do with the extortion scheme. And it had to have a direct evidence with regards to that, right? So, pretty much, and this would never happen, the parents would have to get on the stand and say, yeah, we tried to extort him. Or the defense had bulletproof evidence that it was an extortion scheme taking place. So that means if there was I don't know what other kind of scheme could be considered. If they had evidence of another kind of scheme, right? Then maybe the parents could have been called then if they were a part of it. Okay? I'm trying to go as slow as possible with this. So let me take that down. Okay, put this one up. Thank you, T House. Hey, Henny Hen. Hey, Passionately Fine. Hey, Leslie Moves. Hey, Purple. Okay, let me put this one up. And I've shown this one before. So remember, preclude means prevent. The evidence is not there. Exclude means the evidence does exist, but you're trying to get it out of there. Okay? And that's another PR and the EX, preclude, prevent, exclude, exist. That's a good way to remember it. Okay. I've already read this. Okay? But this again was from the prosecution. So I already read what the judge order was. Okay? The judge ordered that this evidence was to be precluded. But if they have evidence regarding the extortion scheme, whatever, then it would have been allowed. Okay? Let me read this again. It says certain text messages by Jane Doe number 5 and relating to Jane Doe number 5 should be admitted. The defendant summarily asserts that from a plain reading of the text messages the government seeks to admit, the messages would open the door to the very same evidence that the government is attempting to preclude, and asks that the court allow the defense latitude in cross-examining to explore the many topics included in the text messages, such as sexual behavior, psychological issues, and certain actions of the witness parents. In so saying, the government assumes that the defendant is referring to the text messages between Jane Doe number 5 and Jane Doe number 5's mother, and not the other text messages the government seeks to admit. Okay? Even if so, the defendant has not explained and cannot explain how those text messages open any door to cross-examination. Okay, so remember, you can only talk about something that the other side has opened the door to when it comes down the line of questioning. Okay, so if they open the door to it, then you can talk about it. Now, this is outside of you putting up your own evidence or whatever. Okay, but I'm talking about when it's the prosecutor's case in chief, meaning they're presenting their case. This is what they're talking about. And then when a defense case in chief is up, then the same would apply to them. You open the door, you get to walk through it. Okay. Rather, the text messages show only that Jane Doe number 5 recounted to her mother nearly in real time statements of the defendant, as Jane Doe number 5 will testify. The defendant suggests that prior consistent statements are admissible only to rebut a recent motive of fabrication and not simply to rehabilitate a witness. Meaning, used to impeach them, okay? Used to make them, make their credibility lessen. Make, a part of reasonable doubt or strategy to win the jury, right? Or to win your case, pretty much, which is the same thing. Says he is wrong. As an initial matter, he ignores that prior consistent statements are expressly permitted to rebut an express or implied charge that the declarant, that's the person who's making a statement, acted from a recent improper influence or motive in so testifying. Moreover, the defendant neglects to mention that Rule 801D1B was amended in 2014, expressly permitting prior consistent statements for the purpose of rehabilitation where a witness's credibility was attacked. Meaning, just say they do a good job on cross to make her look bad. Then, hey, the prosecutor can take the statements up and say, hey, did you say this at this date and time? Was you telling the truth then? Blah, 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 blah. That's to her rehabilitator. Okay? Bring her back. Because she got fucked up on cross-examination. And they using the evidence, which are the statements, to bring her back. All right. It says, adding that prior consistent statements are admissible to rehabilitate the declarant's credibility. What I just said. As a witness when attacked on another ground. And therefore, the case law cited by the defendant all before the amendment is an opposite, meaning it's inaccurate. Okay? Let me come back right here. Y'all don't have to do that. Thank you, Purple. Thank you to y'all again. Okay? So, let me see. Where is it? Is there another place I wanted to show y'all? So let me come around there with y'all real quick before we get into the other stuff. So make sure you understand. The parents could not have been called to get on the stand and to talk about they drove Jane Doe number 5 to the spot, all that inappropriate shit in those text messages between her and her mama, all of that type of stuff. Okay? The judge said no. But she reserved it at trial. And remember why she reserved it at trial. So let me put this up. We're going to go back to this. So to remind you why she reserved it at trial. And I pray this is the last time I have to talk about this. Because I don't know how, no other way to explain it no more. I'm like, all right, Kelly, y'all don't want to know the truth. Shit. Okay. Let me put this up. I can't get this up. Okay. I guess it's tired of coming up on my damn screen. They like, I'm tired of putting this up on your screen. Oh, here we go. Okay. Remember this? This is in the same family we're talking about, right? When I say family, I'm talking about the conversation we're having. It's a part of this whole conversation. Remember this. The next category of evidence, I don't think you all are too far apart on this one either. This has to do with evidence about the victim's parents and the allegations that they may have participated in the scheme to extort the defendant. I don't understand that any of the parents are testifying. Is that correct? That's correct. All right. So the prosecutor had already done their job to get it precluded, right? Now let me check that was 8-3. Let me look at something. That's how I respond. Okay. So that was 8-3. Hold on. Page 46. Hold on. I'm going to even give you the date to make sure. Okay. This was 8-3. Okay. And the prosecutor said that's correct. The judge says, so it's certainly appropriate if with good faith basis to question the witnesses whether the witnesses participated in such a scheme. That's certainly appropriate, but sort of a general question about what their parents did is really not. Meaning, general questions about what their parent did, she said it. That's not appropriate. You know why? Because it has nothing to do with the charged conduct, which is what? The elements. It doesn't have anything to do with the facts. She already ruled that a line of questioning, like to make it seem that the parents gave consent, would not be allowed. Why won't be allowed? Because it's an illegal defense. Why? Because it's already prohibited by law. She says, I mean, there is no direct evidence of it, so I don't know how the witness would know about it. Meaning, they found no evidence that suggests that there was a scheme to extort. They had no evidence, and this would be circumstantial, that you can infer that there was an extortion. So they couldn't get it on defense, meaning, they couldn't get it on direct, meaning they had something to do with it. Somebody had something to do with it. Somebody knew about it directly. There was some evidence, so on and so forth, that would prove there was an extortion. They couldn't get it indirect, which is circumstantial, which means they infer from what they read. They drew a conclusion that an extortion was going on. Didn't have that. So she's saying, how would they know about it? Meaning, if there's another person outside of the parents that's going to come and say, yeah, this extortion, blah, 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 there was nobody there that knew about it. Okay? It says, unless the witness participated in it, okay, meaning that witness, just what I just said, the witness participated in it. If the witness participated in it, then they knew about it. Okay. And then you can certainly cross-examine them about, but just a general question about what the parents are doing, in a case with allegations like this one, hold on, let me get this real quick. I forgot how long this was. In a case with allegations like this one, and the parents couldn't consent to the behavior that's alleged, so it really doesn't have any relevance. Okay, 3 R's. So that's not going to be admissible, just generally about the parents. But if the allegations, which is what I understand it to be, is that the particular Jane Doe witnesses were part of this plan, you can certainly ask them about that. Like I say, I don't think you're that far apart on this, so I think I've got that right. Yes, Your Honor, I would ask that we be, Judge, able to flesh that out. And because I do think, I'm sorry, in what form would it take? That's my question. They're not testifying. Well, in terms of offering a defense, Your Honor, okay, remember, motion in limine, these are all the times, pre-trial, they start to try to shut down defenses. Yes, sir.
Hey, how you doing, Ms. Walker? I just want to pop in real quick. Hey, good afternoon. Or good evening. I just want to pop in real quick because I don't want your audience or you to lose sight of something that you just read. And if you could read it again, I'd appreciate it, because I think this is where most people get a little bit off track. I think you were reading the sidebar. Is that correct?
I'm reading just now.
Yeah, about 2 minutes ago.
This paper right here, I'm reading the pretrial.
Pretrial. Now, when she talks about, I don't think you guys are really at odds too much. If you could start there, when the judge says that, as it pertains to the parents, she said to the prosecution and to the defense. If you go back a couple of pages, I think it starts off saying, "Well, I don't think you." Yeah.
Okay.
I just want to pop in and say this, then I'm gonna go out and listen, and we can discuss it later. But I do want to point something out.
It says the next category of evidence. I don't think you all are too far apart on this one either. This has to do with the evidence about the victim's parents and the allegations that they may have participated in the scheme to extort the defendant. I don't understand that any of the parents are testifying. Is that correct? That's correct. So it's certainly appropriate, if with a good faith basis, to question the witnesses whether the witnesses participated in such a scheme. That's certainly appropriate, but sort of a general question about what their parents did is really not. I mean, there is no direct evidence of it, so I don't know how the witness would know about it.
Stop. Right there. There we have it. Now, this is why for the last year plus, I have been speaking about the inadequacies of his legal defense team. If you listen to what the judge just said, she basically said, and tell me if I'm wrong, she says it would be appropriate if there was evidence to support the fact that the witnesses, referring to Jane Doe number 1, 4, and 5, who were minors, if the witnesses participated in not the scheme of extortion, but participated in a scheme, Meaning, if you are able to show the court or convince me that either Jane Doe number 1, 4, or 5 actually were part of a scheme, then yes, that lane will be open to you, wide open. But the prosecution were very skillful in what they did was they meshed Jane Doe number 1, 4, and 5 together, which had he had adequate legal defense operatives in that court, they would have sought to separate Jane Doe number 5 from Jane Doe number 1 and 4, because Jane Doe number 1 or 4's parents did not have any interactions with Robert Kelly. They had not had any arrangements with Robert Kelly. But more importantly, you have a judge saying, if you can show that either 3 of the witnesses were participants in a scheme, then that would be admissible. That would have been one, had they pursued that lane, had they read the text messages in its entirety, which none of them did from my vantage point, they didn't. They would have been able to show by the text messages themselves, which you respectfully, you minimize, not minimize, but you said it earlier that no, the text messages are not pertinent to the fact that they're not significant, but I'm trying to show you the significance. That is a hell of an accusation to say that a witness, a minor, a child, participated in a scheme with her parents, not just a scheme of extortion, but any scheme. That's a hell of an accusation, and that's a high bar for any attorney to meet in a court of law, as they tried to convince the court and the judge that the daughter of Jane Doe number 5 in particular was complicit. This was a scheme. Well, how do they convince the judge of that? How do they convince the court of this? Well, right there in the text messages. When you have Jane Doe number 5, the daughter, agreeing to not disclose her age. When you have Jane Doe number 5, further down the line, testifying that no, she was not aware that her mother was text messaging the defendant at that time. But as you can look at the text messages from the very day Robert met Jane Doe number 5, Jane Doe number 5 was aware. So I don't want anyone to get the impression that the parents were precluded because there were no evidentiary facts to support anything that would have warranted or allowed the parents to be pulled into this. I believe that those text messages, had they been read, had he had an adequate legal defense team, which I think, I don't want to get off track, but if you remember, Dr. Rice said that one of the attorneys, the female attorney, told him leading up to trial, days before trial, according to Dr. Rice, she told him, I don't know what we're going to do about Jane Doe number 5 or Aaliyah. This is what she told Dr. Rice. I got it recorded. You can play it. He said it. You know why? Because she had not read those text messages. Because I don't know about Greenberg, but I know that they were not prepared in the sense, and I know that the African-American attorney was not prepared in a sense where the smoking gun was right there. There's nowhere in the world any judge or any court would disagree that for this minor child under the age of 18 to say in the text messages, oh shit, we done ran into a brick wall. What happened? We're going, he's invited me to the casino and you have to be a House of Blues or whatever, but you have to be a certain age. I Googled it. And it says you have to be a certain age and I'm 17. Well, the mother responds, well, tell them you left your ID at home. At the room. As a matter of fact, did you get in? Yes, I got in. They must not be able to. I think she took the ID anyway. They must not be able to add up. They don't know. They can't add. They're not good at subtracting and adding. However, the mother says to the daughter, as a matter of fact, not only should you leave your ID at home, make sure that when you get back to the room, you pretend in front of the defendant, Robert Kelly, R. Kelly, you pretend to look for your ID. Meaning what? Trick him. This is a mother and a daughter, a mother advising her daughter or instructing her daughter to trick him. Pretend you're looking for it, have it somewhere in the room, and then as he's looking for it, say, oh, I found it. Now, if that's not being part of a scheme, what is? But the scheme was not only to not disclose her age, but the scheme and the text messages, everything I'm referring to, Ms. Walker, I'm about to get off of here and listen to you. But not only was it to not disclose her age, what's the difference? If you're 17 or you're 18, why would a parent and a child say, I'm not going to tell him I'm 17? If I'm 17 instead of 18, is it impossible or is it unreasonable that he would write a song for me? If I'm 17 and not 18, are you telling me that he still won't invite you and a chaperone to come to the studio to conduct business? If I'm 17 years of age instead of 18, there's nothing that he will not do. People work with 15, 14, 13, 15, 16-year-old artists all the time. But if I tell him I'm 17, I won't be able to lure him into the bed, trap him, and then once he's trapped, guess what? You can play with me if you want, but I was 17 when we had sex. So the fact that she hid her age, I'm talking about Jane Doe number 5. See, I want people to get away, as I've thought about this over the last few days. Get your minds off of the mother. Get your minds off of the father. Put them in the back seat. She's in the same car with them. But she was the point person. And now I am of the belief, after reading what I've read and going over this over and over again in my mind, that she from day one was a part of the scheme, a part of the plan. But what she did in the streets, we refer that to is that she ran out on the plug. It happens every day. She ran out on the plug. The father was the plug. We about to set this thing up. You about to go in there, seduce him. And if you don't get a record deal, at all costs, we're going to get some money out of the deal. Once she got in, just like Donnie Brasco in the movie Donnie Brasco, once he got into the mafia and he started looking at their lifestyle and the fun and the money and the this and the that, he fell in love with the guy, with the damn mafia, and he was a federal agent, but he was sent in for a reason. So once his superiors saw that he was like, you got love for these people, you really into this thing, we're pulling you out. And he didn't want to pull out. The same way, once this young lady was able to travel and see the world through from the life of a celebrity, she fell in love not with Robert. She fell in love with the lifestyle, being a product, a child of a poor fucking household, an impoverished situation. If you listen to her on President, she said if we were at a villa or we were at a 5-star hotel, it's money, money, money. If I would say, well, I'll call you guys back in a month when you calm down. Everything is money. Everything is money. The Father himself has said repeated times, and we've heard the Father say, what did she leave with? Did she leave with a car? Did she leave with money? Did she leave? What the fuck that got to do if your daughter's a victim? Who asked the question, what did my victim daughter leave with? What did the victimizer, what did the child violator do for her? Who even factors that in? If the child is a victim, who gives a damn what they left with? You violated my daughter. So I got off track, but the bottom line, y'all, is that what Angie just read, the judge herself made it clear. And it's kind of murky and it's become convoluted because people in that context, she's referring to 1, 4, and 5. But a skilled attorney, had he had real attorneys, would have said, no, 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 no. We're going to separate 1 and 4 from 5 because 1 and 4 didn't have any interactions with the defendant. 1 and 4's parents did not have any interactions with the defendant. 1 and 4's parents did not have an arrangement and an agreement. They were not involved from day one, from the moment they put her on the stage as bait to lure him. That's a fact. But they couldn't explore none of that. They couldn't explore none of that, Ms. Walker, because his legal defense team was too busy on social media, too busy dealing with terrorists, doing all this foolishness, as opposed to reading every single document thoroughly, sitting around a tape day and night, just reading. It was a frivolous defense. And I'm going to close by saying this, that you cannot get away from the fact that, not you per se, but no one can get away from the fact that those text messages confirm that not only was Jane Doe number 5 aware of the deceit, but she was a part of the plan from day one. And proof of that, as you read the text messages, no one can deny this. She starts off being very polite to his assistant. She starts off, and no one can deny this when they read those text messages. Jane Doe number 5, when it was a Cheryl Mack or the assistant, Mr. Kelly would like for me to arrange for your tickets to such and such. Thank you. Okay, thank you. She was very polite. Then there are, if you listen to the progression of her and her mom's conversations in the text messages, it goes from, okay, do not sleep with him because he will not respect you. You'll just be a groupie. Then it goes from that to Steve Harvey said, wait 3 months before you sleep with him. Well, hell, she was 8 at the time, 8 or 9 months from 18. It goes from that to just watch the progression. How did he react when he saw you at the airport, when you got off the plane? Did he kiss you? Have y'all kissed yet? Then the conversation goes from that to, we just woke up. It's a minor telling her mother, we just woke up. We just woke up. He's packing my bag. So the mother, both she and the mom are basically saying, okay, yeah, now we sleeping together. You need to go give him a back massage. This is all part of the plan. Then you'll see a change in her tone once she gets him in the bed, Jane Doe number 5. You'll see a change in her attitude towards the assistant, Miss Cheryl Mack. It becomes more, do as I say. You didn't do this, you didn't do it. She's dictating to Cheryl Mack. And then I heard that as a result of that, Cheryl Mack was fired because of her. But once she got her foot in the door. Now, give my mother a job. Give my father a job. Now we need things. Now the requests for things are coming in. So y'all got to quit thinking about this separately. All three of them, from my observation and vantage point, and at least another one of their daughters, was all part of the scheme and the plan in the beginning. So the judge says it clearly. If you can show that the witness was a part of the scheme, a part of a scheme, hey, you got an open lane. They could have sat there for 3, 4, 5 days, 10 days with the parents and her, confirming to the jury that it was a plan, that it was a scheme. How did she get, starting with how she got on the goddamn stage. Christy Lights. You will not hear Christy Lights mentioned nowhere in the trial. How is that? That her father allegedly worked for the lighting company where the venue was, where the concert took place. How can the jury not see, had they been able to establish early on, absent of Jane Doe number 1 and Jane Doe number 4, Your Honor, we're not concerned about them. But we know for a fact, due to these text messages and due to our own investigations, which never happened, because that so-called private investigator was too busy investigating Levi and Dana. He was too busy trying to discredit me and so people on YouTube and shit. He wasn't doing no investigating. It was a YouTube investigation that he was conducting. But had they had real, true investigators, they would have had the damn supervisor from Christy Lights there. They would have had the Christy Lights record. They would have had all of his employment records right there, front and center, showing that from its inception all the way to her testifying, it was a plan, it was a plot, and she was placed on that stage to lure him. After he took the bait, thinking she was 18, the plan ensued, and the parents now got him hooked and started to ask for things. And more is more to the story than that. I just can't mention it right now. There's much more to this story, y'all. So that's all I wanted to say, Ms. Walker. Thank you for allowing me to speak so long. But I want people to pay very close attention to what Ms. Walker just read, and that is, if you can show that the witnesses, 1, 4, or 5, were a part of a scheme, you have full reign. And it was right there in that exhibit that she, Jane Doe number 5, was a part of a plan and a scheme, and no one in the world, on Jesus, God, Muhammad, no one will deny. If you are speaking to your parent and your parent is saying, hide your ID, make sure you leave it in the car, that was the beginning of the damn plan. Whatever you do, don't tell him or show him your age. But then when she makes it in the door, when she's more established, the parent says to her right there in the text messages, well, you know there's going to come a time where you're going to have to tell him your real age. That means what? If you told him your real age when you met him at the festival, you wouldn't be with him. We couldn't have worked our plan. But now you're inside. So you know that at some point in time, you're going to have to tell him your real age. Did she say in the text messages, I told him my real age the first time I went to the Dolphin Hotel? I would never tell him I'm 18 when I'm 17. She never objected to it, meaning she was a part of the plan and the scheme. Now I'm going to hang up and listen to your response, Ms. Walker, and let you finish doing your reading. And I'm going to be taking notes, and we can revisit this later after you're done.
Okay, yes.
Thank you.
Okay. So, once again, Levi mistake my words. I did not minimize the text messages. I only said what they were when you put it in a legal form. They're not relevant. Tell you why. And then, I ain't just say that. They already deliberated over those text messages or some portion of them. I don't know, was it all or whatever, but whatever portions of them, because at that time, Farinella was there. He was there the whole time, whatever, but Farinella wrote the motions in limine for, wrote some of them for the defense. He's the one, if I'm not mistaken, he's the one that brought up the actions of the parents. Now, Levi said a whole lot, so I need to unpack what he said. Again, okay. You can't just hone in on one word when there's a whole paragraph. And paragraphs and sentences often form the context. Okay? Let me read what it said. It says, so it's certainly appropriate if you know with a good faith basis to question the witness whether the witnesses participated in such a scheme. Such a scheme, the only scheme she talked about was extortion. But let me help you out. Just say it's any kind of scheme. Because she did say such a scheme. So such a scheme can be extortion and, okay? Can be extortion and. Here's where the problem comes in. Levi has a problem understanding the difference between an illegal scheme, a scheme, and a lie. The interpretation of the text messages how can I say this? The interpretation of the text messages. The text messages are going to have to fall in two main categories of evidence. It's either going to be direct evidence that's supported by testimony, documentary, real evidence, or demonstrative, right? So you're going to have something real, tangible, whatever. Testimony, somebody testifying to a scheme, whatever. Charts, graphs, text, things of that nature. Documents, things of that nature to prove a scheme. We're going to say a scheme of any sort. Or, that's direct, or circumstantial, which is indirect. You could still use those same pieces of evidence, but you're going to have to be able to infer. That's the word they like to use in law. I like to say draw a conclusion for lay people. Draw a conclusion from what you read that a scheme occurred. Does anybody understand what I'm saying? So we can't read. I mean, you can, but it's it's all for just exercise. You can read into those text messages anything you want. I can't say that the defense didn't read them because I'm pretty sure they did read them. Because the prosecution, even if they didn't read them until the prosecution started pointing shit out in these motions that we saw, that would have prompted them to read it. And we do see up in the upper right hand corner, it says Government Exhibit 233. So it was there. When the prosecutors start talking about certain text messages with the mom, schemes and plans and shit, if they hadn't read it, they're going to go and look in discovery to see, well, what the hell the prosecution is talking about. What are they trying to preclude? What are they trying to exclude? What are they talking about? The judge ruled on it. And let's go with this, right? Because, see, now y'all, see, I ain't caused this. So if we get in the weeds with all this legalese and things of that nature, this classroom like bullshit, I got to go back to blame Levi. Hey, and if it's late enough, blame Sky ass. And if it's whatever, you understand what I'm saying? Blame their ass. Don't blame me. So, regardless if it's direct evidence or circumstantial evidence, it's going to fall into four main categories of evidence. Real evidence, which is physical, meaning DNA, things of that nature. The gun, the knife, things of that nature. Demonstrative evidence, which means it demonstrates what the testimony is. It could be charts, diagrams. It's just pretty much evidence that illustrates what your witness is saying. Documentary evidence is going to be documents, photographs, tape recordings, printed materials, videos, or whatever. Videos is digital evidence, but still. And then you got testimony, which is normally the largest piece, and which when you do ratios, that's what make cases more circumstantial. And when it comes to testimony, you got to do the 5 and 5, okay? Whether it's direct evidence or circumstantial evidence. 5 and 5. 5 is what you see, smell, taste, touch, and hear. Your 5 senses. Your other 5 is going to answer who, what, when, where, and why. When it's direct, it's going to be directly linked to your testimony, is going to be directly linked to what you either saw, smelled, taste, touched, or heard. And you're going to answer who, what, when, why, and where. When it's circumstantial, you're going to be based on what you saw, smelled, taste, touch, and heard. You're going to draw a conclusion from it, an inference from it, based on who, what, when, why, and where. You're going to draw an inference on that as well, a conclusion from it. Okay? Now, I'm going to help Judge Donnelly out. Just say, for instance, she mentions in here there's no direct evidence to prove it, meaning there's nothing that can prove someone's testimony about a scheme. If there was circumstantial evidence, and this is more or less because y'all are coming up with theories about what you read in the text messages to say that a scheme took place, right? Apparently, the judge and the prosecutor felt like that there couldn't have been any inference drawn from those text messages. The defense team probably couldn't come up with a scheme or a defense that can draw an inference from those text messages. Because if they could have, pretty sure they would have, and it could have been admissible as circumstantial evidence. But they would not allow circumstantial evidence when it's too weak to prove or disprove the factors or the elements in a case. They're not going to allow it. Okay? So, and from what you infer or draw a conclusion from, if it's too weak, they're not going to allow it because it will not decide the outcome of a case. Meaning it would be insufficient to deliver to a jury to make a reasonable conclusion of the case, whether the person's guilty or innocent. It's not sufficient enough. So that evidence wouldn't even be admissible. And therefore the prosecution, if they had those things that Levi spoke of, okay, the prosecutor is going to move to preclude it, because when you look at what you read in those text messages, and remember I did the live, I did the keywords and all of that, of things that would say whether or not there is a scheme going on to extort, a scheme period, or what have you. At best, I get a lie. But just say if it was a scheme. Just say if it was a scheme. It still is prohibited. Because it's still a legal defense. Because the language that's laid out in that law when dealing with minors is that even if an adult should have known or have a reasonable expectation that they are dealing with a minor. So just say if it wasn't precluded, just based on that alone, just say it slid to and it wound it up in evidence or whatever, just like it did or whatever, right? I'm talking about the text message. I'm not talking about the parents. I'm talking about the text message. They're going to ask for it to be excluded if it makes it through, pre-trial. They're going to ask that it be excluded because it's not relevant, relatable, and reliable to the charged conduct, to the act, to the elements, to the facts in the case. And it's an illegal defense because a parent cannot consent, whether it's a scheme, a plan, or whatever, for her or him to have sex with an adult. At best, if they draw an inference from that, it could have mitigated R. Kelly's criminal liability, and it probably would have created an indictment for the parent. But it's not going to clear him of those charges, because the prosecution, if it played out that way in court, they're going to go in there and say damn near just about what I said, but more eloquently. They're going to elaborate on it, and they're going to put up all those case laws to support what they're talking about. They're going to put out mandatory law and primary law, well, probably mandatory law, that says the act itself was illegal and nobody can consent to it. You cannot consent to an illegal act, meaning you can't consent to it as a child, and your mama can't consent for you to consent to it. And then you run into another block where if that type of testimony and evidence is allowed, which is testimony is evidence, then it could serve to be prejudicial to the jury. Not prejudicial, I'm sorry. It would serve to confuse the jury. Confuse the jury. I'm thinking about the whole line of what that particular law says. But so it could serve to confuse the jury. That's why it's prohibited due to it being an illegal defense. If you allow an illegal defense to come in there, what have you, talking about the parents did this, the parents did that, parents did this, parents did that, it's going to confuse them when you get up and say, well, you cannot have sex with somebody underage. So on one hand, the judge has allowed someone to defend having sex with somebody underage, but on the other hand, the judge have allowed a case to go forward with somebody being charged with having sex with somebody underage. The charge wouldn't even be there. If there was a legal defense to it, the charge wouldn't even, most likely wouldn't even be there. I mean, with it being that direct in language, right? It wouldn't even be there. But it's not something that you got to infer and interpret. That's not one of those laws. It says somebody under the age of 18 is a minor. There's nothing that you have to interpret that by. If you're under 18, you're a minor. That's what the law says. You understand what I'm saying? That is what the law says. There's nothing to interpret about that. That is clear. So the text messages is a good read, but if you try to put it in some kind of whatever, I don't know what to call it. I saw the mother sending the child a lot of money. I saw the mother ask for $5,000 back when she said, you blew off you gonna blow off your own performance. And then the girl later on says it was a joke. I saw the daughter trying to get her mama a job because the mama kept complaining about the, working, and then she loyal and whatever. I went through some other last life. But you're gonna have to distinguish between what's an scheme. When I mean like a scheme that doesn't have and you say, Angela, ain't all schemes, isn't that illegal? No, because it depends on what the benefit is and things of that nature, right? And then there is an illegal schemes like extortion and all of that. And then there's lies. They just lying in those text messages. But you got to have something more substantial than what you think happened and how you read into it. That don't play in court. And ain't no lawyer with good sense, this is probably why they didn't, gonna come up there and say any type of scheme, read a scheme into what we've read, even though the behavior of the parents is poor. It's a misconduct. All them parents questionable to me. If you want to know the truth, except the Rogers. But all those parents are questionable to me. Does it, and check this out. Even if there was a scheme, there was a scheme, right? To take down the king of R&B, or a scheme to get some money, or a scheme to get this, or a scheme to get a record deal, or whatever. Even if it was in thought, that didn't come across unto some any piece of evidence. that didn't come across into any piece of evidence. And that's what you need. I don't know how many ways we can put this. It's just not there. I can look at something 1,000 times. Just say you got a dude, right? And I can say I think he's cheating just by the way he's talking to, texting on his phone to somebody. But if he ain't got in there, I mean, I don't, last night I hit you from the back and the front. If they just got in there last night, I had a good time last night. I'm just thinking they did it. I might be on a borderline with it being circumstantial. I can try to say I drew a conclusion from it, or inference from it. So when it's circumstantial like that, it has to be strong. Can't be weak. It has to be strong enough to be a deciding factor, to be allowed. It still has to be relevant, relatable, or reliable. And although Judge Donnelly did not say, she says, I mean, there is no direct evidence of it, so I don't know how the witness would know about it. Unless the witness participate in it, then you can certainly cross-examine them about. But just a general question about what the parents were doing, in a case with allegations like this one, meaning the charged conduct, the elements, the facts, and the parents couldn't consent, meaning they can't consent, so they can't even put you in a scheme. They ain't put your ass in a scheme. And it involved, sex, or they can even put your ass in an extortion scheme that don't involve sex. Then it says, consent to behavior that's alleged, so it really doesn't have any relevance. That's why I said those text messages wasn't relevant. So that's not going to be admissible. That's not me saying I'm reading it. Just generally about the parents, but if the allegations, which is what I understand it to be, is that the particular Jane Doe witnesses were part of this plan, you can certainly ask them about that. If they were part of the plan. They didn't even feel, they didn't, well, they couldn't have got them up there anyway. They didn't even have enough proof or enough faith in the text messages to even try to put a fight up to say that, it's circumstantial. We can come up with something, a story that we can infer from it. Because here's the thing. Now you're going to have some bulletproof evidence. A bunch of it. That's real strong. That would suggest that, hey, there's a plan or scheme. Just say you got, and I'll just use this because, white collar is my thing, right? Just say you got a scheme, right? And as a part of that scheme, you got a scheme. You didn't state it because guess what? A lot of the smart criminals that we had to come across, they knew not to put shit in writing. They now know not to push it blatant out there and shit like that. They talk on the phone, and you got a tap going and you listening, they using codes and shit. All kinds of shit like that. But they have bank accounts overseas. Their taxes don't match up to their income. You got the same girl catching flights on the same day twice a month going where that money is going overseas. You have, you deal with your while we listen to them phone taps, you got friends that we know are known, schemers and shit. You got money, you got them picking up money from the Western Union in increments that that doesn't raise a flag on the map, or the bank accounts in America is right up under 10,000. All those type of things. You got all of that, then yeah, okay, you can make a little argument that there's evidence of a scheme going. But just the fact that she didn't disclose her age, well, you got somebody else didn't disclose their age, allegedly, or whatever. But again, that gets you nowhere, because you got that particular language in that says an adult's supposed to know when they're dealing with a minor. It stops. Well, it don't stop there, but it can. A minor and the minor parents can't consent to your ass being in no scheme that includes especially if it includes having sex. It stops there. But it doesn't, because if you go to, well, we don't even have enough evidence to say that there was any of that or all of that going on, and it stops. It just stops. It goes nowhere. So I believe that they went over, because I mean, you ain't just ain't gonna tell me that all this long time, and which we know it was government exhibit 233. They're not gonna have an exhibit there and just don't pay attention to it, especially when the government is referencing the exhibits. Ain't nobody that ineffective. Even the lawyers that be on crack and whiskey and heroin, they ain't that ineffective. It was shut down, and they couldn't have made it work anyway. So it has too many roadblocks. Your theories have too many roadblocks. It will not go, and that's why I didn't. But they thought about it though. They thought about it, but it I mean, I don't pulled up all the paperwork regarding that particular situation. I don't know what else to tell you. What is this? I don't know what else to tell you. It was shut down. Levi, did you see the other documents I put up? What them addressing it? And understand this. Just because I know some people saying people get minors getting killed, that kill people, and they get tried as an adult and you get tried as remember, every different penal code comes with its own set of circumstances and elements and sentencing guidelines and so and what you can consider, can this person be tried as an adult and all that. Everyone comes with that different thing, so it's not a blanket thing just like that. I don't know what else to say. They just didn't. They're not going to have no exhibit just sitting there and not read it. They know. And again, do I have to show that language on Nikki's site again? I'm gonna put in the chat again. I mean, this his people. Uh, you got the talks about the mistake of age defense. Do I have to put that back up here? Because I know I done went over that 1,000 times. Do I have to put that back up here? Please tell me I don't. Do I have to put that back up here? Okay, so let me get to reading this thing. Because I don't know how many pages. But wait a minute. Judge Ann. Oh yeah, I want to show you what Judge Ann said. Hold on. I mean, that was her ruling on that. Oh no, that's too much to read back. But respects to. But anyway, I mean, I have how the judge ruled on all that stuff, whatever she had to answer in Jaybo's motion to acquit and motion for a new trial. What she talked about, and that situation she brought up, Jaybo brought up about those text messages and all of that. Okay, it's just, and again, the text messages is not consent. She wasn't using it as a consent to say the mother consented to her to have sex. It was about the coercion to go across state lines. And if Jaybo read the text messages. Not if she read the text messages. Why she didn't allege a plan to extort? Why she didn't come up with nothing like that? And her subsequent motions that was filed after the trial. Why she couldn't find it? So all those sets of lawyers, I don't know how many he done had. She definitely talked about those text messages, Exhibit 233. The part she put in there, if she had something else to use, she could have used it there about him being schemed and whatever. She could have used it there. There was nothing preventing her from using it in her argument. Nothing. So I don't know what to tell you. Only that them people said, uh-uh. Hold on, I'm trying to pull up. So let me get to the reading of this. Levi, what's the rest of your fight before I get in the reading this? What's the rest of your fight? Because I know all that shit I just said then went right out the window because you're coming with something else that I already said that ain't right. And y'all, I need y'all to understand that ain't just me talking. I'm taking it right from the paperwork. Some I said before the paperwork came out, just confirmed that I was telling the truth. And some I'm taking because I'm going back to read, have those text messages where those text messages were ever addressed, were the parents ever addressed, was the circumstances ever addressed, and all of that. And apparently it was. So before I start, hold on, let me now I'm not dropping the link for everybody. So just I'm gonna pin it up there, but y'all know when I get in this type of mode, I don't come this is for, you know, people that's gonna come up here and make sense. Not what I mean is, like I don't try to call nobody name. I'm talking about like Levi, Keller, Sky, and all that. Not just to say hi. You can say hi in the chat. I tell you when we can come up and say hi. But I just don't want to be thrown off. I don't want to talk about nothing that ain't, that y'all say happened in the court and all that. I don't want to talk about none of that. That just sets me back because I already talked about all that. I don't know how long this thing is, so. Okay, well, let me start to read. That many motherfucking pages? God damn. Hold on. Okay. All righty. Now this is the appeal. Your New York appeal for RSK. Okay, she has her statement of jurisdiction up here. All right. Now we're going to start at the issues presented for review. Okay. It says, and it reads, whether the government failed to prove defendant guilty of racketeering where the record is devoid of evidence of an enterprise comprised of members who shared a common illegal or fraudulent purpose and where the defendant and the alleged enterprise was indistinct. Okay. Whether the government failed to prove defendant guilty of violating the Mann Act as to Jane. Whether the government failed to prove defendant guilty of violating Mann Act as to Faith. Whether New York Public Health Law, Section 2307, is unconstitutionally vague, such that defendants' Mann Act convictions predicated on that law must be vacated. Whether defendants' Mann Act convictions predicated on a violation of California Health and Safety Code Section 120290 must be vacated because the government charged defendant with a repealed version of the statute that was unconstitutionally vague. Whether the government failed to prove defendant guilty of forced labor of Geronda and Faith based on an isolated sex act that did not constitute labor or service, and that neither victim alleged was forced. Whether defendant was denied a fair and impartial jury, where 4 of the seated jurors admitted that they prejudged the defendant's guilt, and trial counsel provided ineffective assistance of counsel when he failed to move to disqualify the patently unqualified jurors or otherwise conduct a meaningful voir dire of prospective jurors. Whether defendant was denied a fair trial where the government swamped the jury with excessive other bad act evidence, including testimony from 7 additional witnesses who detailed defendant's unusual and graphic sexual activities, his history of transmitting herpes to his sex partners, his abusive behavior towards his girlfriends, and both audio and video recordings of this conduct with women and men, some of whom never testified. Whether the district court's restitution award for Jane and Stephanie's herpes treatment was unsupported by the government's evidence. Whether the district court lacked authority to order the BOP to turn over monies seized from defendant's trust fund account to the clerk of court for future restitution payments. So already I don't see nothing about no BOP. I don't see nothing got to do with no parents. Statement of case. The defendant is internationally renowned recording artist, was charged with leading a racketeering, influence, and corrupt organization, Rico Enterprise, between 1994 and 2018, comprised of individuals whose objective was to promote defendant's music and to recruit women and girls in illegal sexual activity with defendant and to produce pornography and child pornography. Defendant was separately charged with various Mann Act violations stemming from conduct in 2015 related to Jane and 2018 related to Faith. After a 6-week jury trial, defendant was convicted of all counts of this third superseding indictment. He was later sentenced to 30 years imprisonment. Through new counsel, defendant filed extensive post-trial motions pursuant to Federal Rules of Criminal Procedure 29 and 33. that were denied by the district court in a 103-page memorandum decision and order. Defendant includes a concise statement of the case setting out the facts relevant to the issues raised in this brief, and also refers this court to the district court's detailed factual background presented in light most favorable to the government contained in this order. Okay, so she is out. Hold on. Yes, sir.
What's going on?
What's good with it?
What's good with it? What's good with it? What's going on?
That ain't
I've,
going on.
I've been listening to you now.
What you want
Been
to fight
listening
about?
to you.
What you want to fight about? I guess everybody want to
Okay.
fight.
Okay. I got questions for you. I actually ain't come to fight. Okay. So this is what I've been going over in my head for 3 weeks. I've been kind of quiet about it. I didn't actually read the text messages live. But this is my question. When the defense was asking for the discovery, they kept saying that, well, we don't got all the discovery. We don't got everything. When they gonna send us the 3500 material? When they gonna send us the discovery? They didn't get all of the discovery, all of it, until the judge ruled on whether certain people was gonna be allowed to testify.
Mm-hmm.
And what I also discovered is it wasn't just that the parents was kept out of the trial. It was everybody, it was them, and it was everybody that they was associated with. So let me ask you a question. Because you and me the only two people that talked about exculpatory evidence, right?
Mm-hmm.
So if you have evidence, but the evidence is involving people that's not allowed at trial, and I looked this up, and I asked AI technology, the government don't have to turn over evidence to the defense if the judge rules that the people that the evidence involves is not a part of the trial. Isn't that correct?
The evidence that people that is not involved in the trial, that if they're
Okay, if
not if they're not connected to the elements, right?
right, if they're not connected to the elements.
Right,
So
and the facts in the
when
case.
you extensively research the people that were connected to the parents, such as the kids, such as the manager, such as other people that came into to peripheral view, such as Valerie Payton, even me, for instance, none of those people are allowed to come to trial because you have successfully kept them from being mentioned in the trial at all. So when you rule out that the parents can't be allowed to be at trial because even if they pushed her into a relationship and they are what they are, if they're not allowed to be a part of the trial, then I don't have to turn over things. I don't have to turn over that additional exculpatory evidence, such as things, and this was the defense fault right here. I'm in possession of a police report from the daughter. The story that she told on Surviving R. Kelly. She said that she was attacked in August the 26th, 2015. I'm not the judge. I don't know if she was attacked or not. But if you take a deeper look at that police report, the police report wasn't filed until 2 years later. You see what I'm saying? It's a lot of red flags. I'm not saying that these text messages prove that he's innocent and he's supposed to get out of jail. But the group text message involving those parents, the text messages between the father and R. Kelly, the text message between the father and the manager text message between R. Kelly, the text message between the mother and the father, all of those things are kept out of evidence because the judge ruled that they can't be a part of the trial. And that's
Right.
what that's what. That's what's bothering me. It's not that these text messages alone should substitute that he could get a new trial. But an appeal, I don't think that Bonjean will let those 15 or 16 items plus the police report, because I don't understand how the same thing happened to him happened to me. You can't send all of your kids, because these parents didn't just send one of their kids. If you think about it, they sent all of their kids to R. Kelly. And then they went to R. Kelly. You can't send all of your kids somewhere and then turn around and say, hey, he a monster. You sent all of your kids there. You called the police. You filed a police report. You see what I'm saying? But you still kept that good working relationship with him. I don't agree with that. I think that everything should have been on the table. And it's not just out of my hate for them. I just don't understand how you can tell somebody that somebody is 18 years old, send the rest of your kids, go to a television show 3 times, and then, he's ruled a monster. He got to go 30 years for sexually man act transportation, sexually abusing her for a month. But for 8 months, 9 months, the parents was sex trafficking and man act transportationing her for 9 months. I feel that if he got 30, then they should have got 15. And if they didn't get nothing, then he should have got 15. That's just how I feel about it. Because it's too many things that's coming up. It's too many lies. You can't come out and tell 100 lies about what happened, and then people find out, okay, that's not what happened. But then we don't know what really happened. The only thing you're telling me that happened is that for 30 days that he sexually abused her. But for the other 5 years and the 9 months before he even knew she was 18, we're not supposed to even talk about that. None of that matters. That's fair to you, Angie?
Is it fair to me that you ask me legal? Okay,
Legally, legally,
I'm
legally.
legally. Okay, but let me go back to your original question.
Okay.
If the evidence does not have anything to do with the facts in the case and the elements, which are the charge behavior, the conduct, and all of that, then and it's not so it's not exculpatory, and it's not exculpatory, then they don't have to turn that over.
So you're agreeing that if you can hold on to this evidence and then get these people, basically the parents and anybody associated them, excluded from the trial, you don't have to turn over that exculpatory evidence, right?
That's not exculpatory. It's not exculpatory. Is it
It's not.
because
It's
they
not
not
a.
because it's not hold on because it's not clearing him of those elements. If you
Okay.
got if you got evidence to prove that he's not guilty, mean
Okay.
exculpatory evidence. I'm sorry, exculpatory evidence. You got exculpatory evidence showing that he's not guilty, not
Okay.
that he is not as guilty, that he's not guilty, that somebody else could have committed the crime, that let me see what else,
So
evidence.
hold on.
Go
Let me
ahead.
ask you this. Let me ask you this. What if the evidence doesn't show that he's not guilty, but it could create reasonable doubt? They would have to turn that over, right? Based upon if the judge had allowed, if they could have found certain people and they could have, if they would have let the parents in the trial, they would have had to turn that stuff over, right?
If it could create reasonable doubt, but here's the thing, still reasonable doubt with respect to the element. It's not just reasonable doubt, period. It's reasonable doubt with respect to the elements. Because if they would allow irrelevant stuff in there, then I mean you could a trial will be a whole 2 years or whatever. So it has to be exculpatory to the elements it has to be evidence to disprove the facts in the case that's attached to the elements. Things of that nature. You can't just like the
Oh,
people.
so what could be an element is they could have kept the parents out to keep from charging them, not based upon whether he's innocent or guilty.
No,
Because
the
put
elements is an indictment.
no
What I'm
no. What
talking
I'm
about, the elements are the indictments. I'm talking about if you can't just say you couldn't just say you, right? You would not, even though whatever your role was or whatever with this R. Kelly shit, you
hmm
still wouldn't be relevant, relatable, or reliable to the charged conduct. And
okay.
you didn't have and you don't have you wouldn't be considered circumstantial evidence or direct evidence, especially not direct. You wouldn't be considered circumstantial evidence unless the defendant told you what he did.
So let me ask you a question. So is Miss Rogers? She testified on behalf of her daughter. She never dealt with him. She
But
was at
Miss
home while
Rogers,
she was at home while her grown child. She was at home while her grown child dealt with him about a disease, but she
but
still
Miss
took the trial.
Rogers
We're
was
talking
there
about
with Miss Rogers'
okay.
testimony was about the gun or the not whatever they whatever happened with the when they went to Applebee's or whatever that is. She was like she's an eyewitness to something. She's an eyewitness to something. She's an eyewitness.
She's an eyewitness to something that has something to do with Don Russell. I'm talking about R. Kelly. Because they came out in court and they said that Don Russell acted on his own. They even said that in the paperwork. But she did testify in the trial. It was no effort to keep her away from the trial. That's what I'm asking. It was no effort to keep her away. You got to understand the prosecution wanted these parents. They didn't want them there. They didn't want the manager there. They didn't want nothing to do with them there. And I'm trying to figure out in my head for the last 3 weeks on why is this man's family, siblings, people that was in R. Kelly camp, anybody associated to this man could not be mentioned or brought up or anything. Trying to figure that out because it's
Because
other.
they don't have they're not considered direct evidence or circumstantial evidence that's strong enough to prove or disprove a factor or element in the case, and they cannot, and the evidence is not strong enough to make a decision. I'm trying to because I already went over this about why Ms. Rogers testified, and I read it. What is she under in the transcript? What they
She,
got her?
she,
Is she under her real
they
name?
got her. They got her on the. Yeah, they got her name. She testified.
Keller, what page is Ms. Rogers on? See, I think people get confused that they think that if you know the man, you could be you should be able to be called as a witness, and it don't work like that.
I don't think that anyone is more relatable and reliable than the hell. The parents is the first person that had contact with the man. The father said he dealt with the man. The father even said we had a great working relationship. The son went there and stayed for 2 weeks, went out to dinner and shit. The daughter got attacked and kidnapped at a gun and filed a police report 2 years apart. The manager is on a national television show arguing with other parents, setting up meetings. You see what I'm saying? It was very, very, very close to the father. He even went to go see him out to California. I'm just trying to understand how is Miss Rogers in her daughter's case about catching a venereal disease and the person that initially contacted him went up to go spend the night with him in Jacksonville, text messaged him, met him, went down to the Orange County courthouse and got a written authorization giving guardianship and flew back and forth, sent all of their kids. How are they not relatable and reliable to that situation?
They
I
were
don't
first of all they
understand.
wasn't relevant. I said to elements, the elements in the statute, the elements. They
Uh-huh.
don't have nothing to do with that, and the facts Are they direct evidence to the facts that's relevant, relatable, and reliable? See, until y'all read FRE and FRCP, you ain't gonna understand evidence, how it's admissible and what makes it inadmissible. The parents has nothing to do with the conduct. The parents has nothing to do with the intent. The parents had all they can say is, okay, my daughter went down there, met R. Kelly. The attorneys don't have, or the prosecutor don't have a line of questioning for them that will have anything to do with the facts and the elements. It's just they don't. I don't know what to say, because if that was the
I,
case,
I
do
guess
you
I
think
guess
R.
I'm
Kelly
I'm
would
gonna
have
keep.
more than 5 witnesses at at either trial? He would have more than that.
No. I'm gonna keep reading it. I'm gonna keep reading it. I just, if you part of the scheme to not show your ID when distress comes, if you're part of the reason, you're part of the scheme to not disclose your ID. If the government probably has 10,000 more things to look at more than what I'm just looking at online. If you're trying to conceal something with interviews and television shows, and you're trying to conceal things like R. Kelly, when it's situations that come up to where your daughter could possibly be found out if it's 18. If you're asking her, if you're doing like the judge said, pushing her into a relationship, I don't know what's more relevant than that. Yeah, he did what he did, but he did it based upon, at the time that we reading those text messages, under the assumption that she's 18. You see what
Okay,
I'm saying?
okay, it's under the assumption, but I guess you didn't hear me here to say the other part that
No,
I've been
I know.
saying.
No, I know he can't.
It's
Regardless of,
on Nicole Blank Becker's website. It's just is he was supposed to know as the adult that he was dealing with a minor. That don't matter. It doesn't matter if she lied about her age, if she gift wrapped it and laid it on the bed naked or whatever. The law states that that an adult's supposed to know when they're dealing with a minor. Now I don't agree in getting tricked into no crime either. But that does not
right.
have to do with nothing why you know um the parents wasn't the parents didn't testify and this, that, and the third. Just say for instance, in Illinois, that girl mama testified or whatever because had a direct she was directly relevant to some of the facts in the case, some of the facts what they were talking about, the evidence. She was
I
directly
understand.
related to that. But you're talking about they weren't gonna let no parents on the stand to say, yeah, I drove my child to the Dolphin Hotel. I knew what she was doing, whatever. Even if she was to get on there and say, yeah, I knew what she was doing, whatever. Here's the thing. She can't consent for her underage daughter to have sex.
But she
And that
can't be
line of
charged.
questioning would be
Who?
precluded, wouldn't be allowed anyway, because it serves to only confuse the jury.
So let me ask you a question. Between R. Kelly and between those parents, who was legally responsible for her? The parents, right?
Legally responsible as a parent, right?
Legally responsible for her as a guardian was her parents. Her parents sent her. Her parents took her to flight. They talked to her. They coached her. They sent her. They put her in a situation to be abused. When they found out she was being abused, such as the sweats and other things, did they pull her out? No. They took her out of school week early and signed over papers to go and see him. And not only did they do that, they doubled down and sent their other kids. I just don't get it. You see what I'm saying?
But
And
when
then after they did all of that, they lied about it to us. They lied to the world and gave a different version of events. So if you did something you know you weren't supposed to do, what's the first thing you're gonna do? Attempt to try to cover it up, you know? And I think that the government know all of that, and they was like, hey, we got to keep these motherfuckers out of this trial. We got to keep them out this trial. We got to keep them out of this shit,
it was the
or this shit
judge,
gonna blow them.
but it's the judge decision that kept them out the trial. But let me ask you this: so his defense team, his entire defense team, right? If the parents and see, if I only ask this question, it only confuses.
No. I get it.
No,
Just
because
like people can't
they're not even, they don't even have anything to do with the charge conduct. They don't, which are the elements. They don't have to do with the facts in the case, which is the evidence that supports, you know, the the charges that he got. They don't have nothing to do with that.
I
I
understand.
mean,
And
y'all want to persecute him for lying. Okay.
no. I can understand. I understand. Just like people can't separate the music from the child, I have to be able to separate the victim from the parents. Them hiding behind her pain when they inflicted it, I have a problem with that. I'm not trying to say R. Kelly did not 100% abuse as real. He has a history of abusing minors. He was convicted of abusing her. Of what he actually did, tried in scope. But he should have had co-defendants. He should have had other people sitting up there with him. You know, everybody, marching and saying that help, where's the enterprise? That's the enterprise. Okay? Though that you want to talk about somebody that helped him more than any assistant ever helped him, there you go. That's your evidence. Okay, helped him all the way up until 2019. Up until Tim put the foot on the gas. Then you got to change the story. I got text messages back when people was going on 97 Baby Girl and the daughters in there arguing with them. That's not happening. That didn't happen to my sister. This 2 years after she filed a police report for being popped. So I just I just I just don't like the motherfuckers. You know what I mean? And I think that they should have been sitting up there with him. I don't want to get him like that. Trust me, he need to go to jail, this and that, but I just don't want to get him like that. It seems unfair to me that all
I
these
don't
backhand
think.
shit,
Go ahead.
all that backhand shit was going on, and you know what I mean. You
Well,
know,
I don't think that, um, you know, any of them. Well, not any of them, because I don't really know what the other parents did. But I don't think the Savages or the Clarys. I don't think too highly of their stories. I mean, either or. Because I heard
well,
Mr. Savage say, "Hey, tell Robbie he got a wife for life. I'm gonna make my millions." I'm done right there. What that mean?
okay. That conversation was took out of context from another conversation, which he was recorded by Don Russell and Cash. It's other recordings that they recorded him. They put him in a trick bag. But he never met R. Kelly. He
But
didn't go up
well,
there.
who
He didn't
says
send his
that?
other kids to R. Kelly. You see what I'm
Who?
saying?
No, because who says that? That ain't out of no context. Ain't no break in the breathing.
I'm gonna ask
And
Tim that. I'm gonna ask Tim that. I'm gonna call Tim and I'm gonna have a real conversation with him.
why is everything? Why is everything? Now
I
if
didn't bring up
you
the
are,
savages.
if
I
you
didn't bring up the.
recording, if wait, hold on, if you putting something out there on the media spot, you should begin with, I just want to talk to my daughter. Daughter, please call me whatever. I don't want to hear nothing about no Puff Daddy. I don't want to see none of that goofy shit. I don't want to see no vacations, no house, or none of that. So I mean, our parent totally different from all of that. And
I understand.
I don't know nobody that would do that really wanna talk. And you got a daughter that's coming out that courtroom on a phone distracted, and the only person that's in between you is a little short white lady, and you got all we had a snatch and grab. Like, what is going on? So I don't,
But
the
you
effort.
can't. But you can't. You can't do that. You can't
What
do
you
that shit.
think? If I'm claiming somebody done snatched her, why I can't snatch her back?
Well, you got to understand where that information came from. That information came to them from Ashanti McGee. They went right to the police and went to screaming and hollering.
Right,
They didn't.
as they should.
as they should. Them other
But
parents
why
didn't
I'm
do
not
that.
gonna what I'm saying is I'm not gonna care about breaking the law when it comes to my child. Did you not hear my child get on the phone and we talked about I thought it was just one time I had a what is a standoff with the school and the parents. I'm sorry, it was two. She remember it was two times at that college. Give a fuck about no job, no license, none of that.
No.
If I'm that concerned,
When he tells this story, when he tells this story, when Tim tells this story, his daughter's off at school. She's off in college.
right?
Okay? He's married to his wife. He has other kids. He has a family structure. He has a job. His wife went to college. We're talking about two different kinds of people. And it ain't no playbook on, it's not a playbook because this has never happened before. Okay? His daughter is at school making these transactions with him.
Right.
She's getting calls from her friends that's at school with her. Like, hey, we need to set up an event. We need to do something. She ain't here. She fucking with this dude. And then you got to bring in. See, another thing that's never talked about is how much pressure Joycelyn's boyfriend was putting on R. Kelly. He's riding around Johns Creek. He was a hothead with dreads. He riding around Johns Creek shooting at this nigga. He pulling up. He on bullshit with him. And then a lot of people don't know that a lot of other things happened with this boyfriend. The reason she came home to her daddy in the first place because they hadn't seen her in 3 months. She came home to her daddy. My wife just got home.
Right.
She went home to get with her daddy to go down there because R. Kelly wanted her to put a police report on the kid that was on his ass. You see what I'm saying? That's why she came home and got into that situation where her hair was cut off. She came home to tell that dad to go to the police station, put a police report on him. But he didn't take her to the police station. He bought her home. Because she was 19 and wasn't nothing he could do. He couldn't make her stay. She went back to school, packed all her stuff up, went back to his house. Now, it's a playbook. You can say, hey, I would have did it this way. I would have did it this way. I would have did it this way.
Exactly.
You see what I'm saying? And the same thing goes for those other parents. But I'm just talking about it's too many things that I'm coming across that just doesn't make sense. Why would you get attacked in Chicago in August 2015 and file a police report in 2017, a week after Tim does a press conference in front of R. Kelly house? So you can't make it to the press conference and your daughter's supposed to be in house, but you send your daughter all the way past Atlanta to Chicago to make a police report about some shit that happened in 2015. It doesn't make sense to me. It just doesn't.
I mean, it's a lot of shit that don't make sense. But I'm talking about for my child, just me, and there's no book and there's no right or wrong. Well, there's a right or wrong, but there's no whatever. I don't give a damn about no 14 and a half years. I don't went no school. I don't give a damn about no job, no license, none of that. None of it. My child didn't respond to me for 5 hours. 5 hours, not 5 days, 5 years, 5 months, 5 hours. And I had the people on her ass, and that was 3 years ago, and she's 31. So I don't give a damn about none of that. My thing is, I just think it's both sets, they do some off-putting ass shit. It's not for me to criticize nobody, but I'm not gonna criticize one for this and criticize one for other. Everybody just moves. I mean, that was just some strange movement to me. That's all I'm
So
saying.
Angie, I got a blockbuster for you. I have not seen evidence of Joycelyn getting with her father, conducting a scam to scam R. Kelly out of anything. But I have seen the other parent get with his daughter and scam to take shit from R. Kelly
But
when
what's
she
the
left.
thing?
And she took that
That,
when she left and packed all that shit up and took that motherfucking money out that couch. Did she knew she was doing
okay,
right or
yeah, now
wrong
that's
then?
stealing. That she did something wrong. If she
Oh,
stole money,
but no.
if
She did it in collusion with her parents. They were there. They knew what she was doing. You see what I'm saying? There's no way when R. Kelly came out and made that statement, there's no way that she would have knew where the fuck that money was. Because I'm telling you, what she told me was the reason she contacted her father is because she was sick and didn't have.
But my thing is, all that's well, fine, dandy, whatever.
No,
On
no, no. They
any
want you.
parent,
I don't want to
you
interrupt
got
your
to,
chat.
but you got to understand that one, if all these crimes they committed, whatever, it serves as a possible indictment for the ones who committed it.
I understand. Yo, they want you to get. I guess you finna read the briefing, and I gotta go and get these kids something to eat. So I'll come back on here. I come back. I come back.
Yeah. Okay. I mean,
Okay.
oh,
Bye.
okay. Well, you could have stayed. I mean,
No, 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 no.
oh, okay.
She just got back, and I gotta go get them something to eat. I'll come back on here. You probably gonna be on here for a
Okay.
while, about 30 minutes or
Oh
so.
yeah, I'm
Okay.
gonna be in a minute.
All right. All right.
All right.
All right.
Let me see how many hours I'm on. Oh, just two. Oh, okay, I'm in good time. Okay, so let it go on then. Yeah, but here's the thing, y'all, and I understand the grown daughters and stuff like that, whatever. I am just saying, just me personally. Y'all might not, have friends and family that will get down or whatever, like I would get down about my child. But there is no way in hell that I'm going to do click on any button and not every time I'm airing something, I'm not airing it saying, about my looking for my child, this, that, and third, and whatever, or closing it saying I'm looking for my child, whatever. And there's no way in hell I'm gonna ever know where she is, and I'm not trying 50 different things to get to her. I don't give a damn about breaking no motherfucking law when it comes to that. Y'all got to keep in mind, I went into a burning building to get somebody else's kids. I don't understand where, like, okay, I wouldn't understand the law if I snatch my own kid back and the law come questioning me. Who she gonna press charges on me? Uh-uh. Is she gonna pick up the phone and call the cops and say she being held against her will? We taking her phone. You know, we are. I'm laying the groundwork in court to get some kind of hold, the 5150 something. We're gonna do something. Now that's just how I get down. That's how my family will get down. That's how my friends will get down. We don't do none of that. So that's just me. I just find both, and don't get me wrong now, the savage that mama, them text messages or whatever, I mean, ain't nothing as low as that. You know what I'm saying? That's just out of my conscience. I can't even think about talking to no child like that, and having in some situation like that. But I'm not gonna sit up here and say, okay, who was more concerned about getting a child back. I'm not gonna make no comparisons like that, because didn't the mama try to get on stage and Don Russ got her arrested and shit like that to try to get the child back or whatever? It's just, I don't give a fuck about no kidnapping. I don't give a damn about. Well, okay, so they got me for kidnapping. I don't give a fuck. I don't give a fuck. What's that? And I'm gonna go there and I'm gonna tell my story. And you know what? I mean, I'm a kidnapper and feeder. So you ain't gonna get me for kidnapping and starving, and see, it ain't gonna go down the traditional line of kidnapping. It ain't gonna play out like that in court. Shit, I'm kidnapping her back. Hell, that's what I'm doing, and she know it too. Anybody child know it around me? Shit, fuck that. That's just me. And if I got more kids, they can be watched by somebody, whatever. Hell, yeah, But if I kidnap her, I don't want. They can't be iffy when I show up with the girl now. Shit, they can't be like, oh, how you get her? Don't worry about that. Hell, you got to do the last leg of it. You got to some kind of way board up the goddamn door or something. I don't know what shit. I don't know, but in that type of circumstance, there would be a lot of counseling involved and whatever, because you know it's just not normal to me. It's just me, and I'm not condemning nobody. It's not normal to me for someone, just because you get into a relationship and I ain't did shit to you as a parent, that is that's considered as neglect, or that's considered as bad parenting, for you to not talk to me or your friends or this, that, and third, whatever. That's just not normal. Well, I don't consider that normal. I don't give a damn how old you are. I told y'all I went in labor in my mama bed. I was grown. So yeah, I'm a mama and daddy, baby. I don't give a fuck. Hey, and sometimes as a grown adult, my child used to come and get in the bed right up under me. Shit. And honey, ooh. So, but hey Keller, why you in? Can you tell me what page the Miss Rogers testified on? Right. I'm giving a shit about no guy. That's right, Chanel Lewis. Hey James. Jojo, I want you to tell the people how you know Michael Jackson, how you used to work with Michael Jackson. What's up, Carla Washington? Jojo, tell the people how you used to work with Michael Jackson. Hey Peter. I'm just saying. What you mean you don't have no idea? What the paperwork? Your black ass. So anyway, so is so just let me explain that loaded question that Larry asked earlier. Okay. If the evidence is exculpatory, yeah, they have to turn that over. Okay. The government or the prosecutors have a duty to make sure they got the right suspect. So in their investigation, if they come across anything that's exculpatory, that questions your guilt, they're supposed to turn that over. They're also supposed to turn over the evidence they're using in the case. Okay, they have reciprocal discovery. Right. She testified about a bomb threat or something. I don't know how I forgot exactly how her relation to the case was, whatever, but I forgot damn, because I know I read it because somebody else. Then Levi had asked why she was allowed um to testify, and I found it and read it. So, but let me get on with this. Hold on. Okay. What was that? Okay, this says okay, so the defendant unsuccessfully moved to dismiss the Rico count pretrial, arguing that the government failed to sufficiently plead a Rico enterprise. Defendant also moved to dismiss unconstitutional those Mann Act charges premised on a violation of New York Public Health Law, Section 2307. The district court denied the motion in a written order. On July 23, 2021, the government filed a 55-page motion seeking to admit extensive prior bad act evidence. On July 3, 2021, defense counsel filed a written objection to the government's motion and filed a supplemental response on August 6, 2021. The district court issued a ruling from the bench, followed by a written order largely granting the government's motion. Throughout trial, defense counsel asked the court to reconsider some of its rulings regarding the admission of other bad act evidence, mostly unsuccessful. B. The jury selection. Because of extraordinary pretrial publicity, the district court directed the parties to submit a joint proposed jury questionnaire to be completed by prospective jurors. The parties reviewed the questionnaires to determine whether they could agree to dismissal of some jurors for cause. The district court conducted an oral voir dire as to the remaining prospective jurors, affording the parties the opportunity to submit additional questions to probe their qualifications to serve as jurors. Numerous seated jurors were either familiar with accusations that defendant had a history of sexually abusing underage girls, had previously faced legal problems, and or had seen the highly unflattering docuseries Surviving R. Kelly, in which several government witnesses had appeared. Defense counsel did not move to disqualify jurors who admitted they had prejudged defendant's guilt or had gathered knowledge about the case from other sources. Defendant was largely excluded from the voir dire process. Complainant's testimony. The third superseding indictment charged defendant with various racketeering acts related to sexual misconduct committed against 6 women, inter alia Geronda, gender number 4, Jane, gender number 5, and Faith, gender number 6. Geronda. In 2008, Geronda was a superfan of the defendant and met him as she walked alongside him as he left court. She told him that she was a fan. In May 2009, Geronda and her friend received an invitation to a party at defendant's home by one of the defendant's employees. Geronda spoke with defendant at the party and exchanged phone numbers. She falsely told him she was 19. A few days later, the defendant invited Geronda back to his house where they engaged in sexual contact. And let me let y'all understand something here. This is also a persuading brief, right? So even though these things were ruled on and an explanation and opinion was written, in some occasions, if not all, it doesn't mean that she has to craft her argument based on just those rules. If she still has a belief or some type of information or evidence that the defendant was lied to about their age or they had a fake ID, whatever, she can say that. She's not, crossing the line or anything like that. It says, a few days later, the defendant invited Geronda back to his house where they engaged in sexual contact. According to Geronda, she felt uncomfortable and privately confessed to the defendant that she was actually 16 years old. The defendant told her to continue to tell everyone that she was 19. Geronda did not testify that she told anyone other than the defendant that she was 16. All right, so she's just here recounting what the testimony was and everything, right? And then she pointed out that she did not tell anybody else that she was 16 other than the defendant, right? So which is given, that she could have possibly lied or whatever, right? Like she could have lied to the defendant. She's not calling her a liar in here. She's just, you can make an inference that, hey, she's could be saying that Geronda didn't tell the truth. So, and it's a kind of his word against hers, right? And just remember, this is kind of his words coming through this brief, okay? But it's coming through the representation of Jaybo. Says Geronda continued visiting the defendant and having sex with him for approximately 8 months. On January 23rd, 2010, Geronda testified that the defendant slapped her and choked her for disrespecting him. The defendant went into the VIP room with Geronda where he instructed her to perform oral sex on him, which she did. Geronda left the defendant's studio after this incident and did not return. Thereafter, she sued the defendant. Jane and her parents attended one of the defendant's concerts in Orlando, Florida in April 2015. Jane was 17 years old. Jane claimed that she made eye contact and connected with the defendant while he was performing and danced on the stage during the performance. Someone provided Jane with the defendant's phone number after the show. Jane attempted to call the number but could not reach the defendant. Jane's mother began texting the defendant pretending to be Jane over the course of 2 days. Jane eventually spoke to the defendant and falsely told him she was 18 years of age. Jane met the defendant at his hotel room in Orlando where they engaged in sexual contact. At one point, the police arrived and Jane reassured the defendant that she was 18. After checking Jane's identification and confirming that she was 18, the police left. Thereafter, the defendant invited Jane to meet him in Los Angeles, where he was performing. With her mother's consent and encouragement, Jane met the defendant in California and traveled with him while he was touring. After his final performance in Stockton, they had sexual intercourse for the first time. Jane moved to Chicago the summer of 2015 to stay with the defendant, but when the defendant learned that she was only 17 years old, he sent her home to Florida. With the consent of her parents, Jane returned to Chicago to live with the defendant. In September and October 2015, she toured with him again in the state of California. Jane turned 18 in December 2015. Jane and defendant continued a relationship for 5 years. Defendant had other living girlfriends. Jane characterized the relationship as abusive and at times and detailed that defendant had many rules and would punish her and his other girlfriends with spankings if they broke his rules. Faith met the defendant in March of 2017 at a concert in San Antonio, Texas, where she was 19 years old. She and her sister were invited to an after party where she met the defendant and he gave her his phone number. Faith and defendant began texting regularly. Defendant and Faith met each other in person 5 times and had sexual encounters during those occasions. Defendant arranged for Faith to traveled to New York on 2 occasions in May and February 2018, where they engaged in sexual activity. Faith also traveled to Los Angeles on 1 occasion in January 2018, where, according to Faith, she saw a gun in his studio and saw a gun in his studio that unnerved her. At the defendant's direction, the defendant performed oral sex on the defendant. Wait a minute. At the defendant's direction, the defendant performed oral sex on the defendant. There's an error there. Okay, defendant's former employees. The government presented testimony from roughly 8 former employees of the defendant. None of these individuals were charged as members of the enterprise. One, Demetrius Smith, friend and personal assistant from 1984 to 1994. Smith met defendant as a teenager when he was still attending high school and singing in subways in the mid-1980s. Smith was first a friend and mentor to the defendant and then began working as his personal assistant when the defendant received his first record deal in 1988 or 89. Smith worked off and on for defendant as a personal assistant until around 1994. Smith's responsibilities include assisting the defendant in things he needed and with scheduling. Smith testified that defendant met Aaliyah through his manager, Barry Hankerson, who was Aaliyah's uncle. Smith testified that from his perspective, their relationship was strictly about music, and that he never saw defendant take Aaliyah on by herself. Smith did concede that there were short periods of time when defendant might be alone with Aaliyah. There were times when he thought defendant and Aaliyah were overly playful or too friendly, and he asked defendant if he was messing with Aaliyah, to which defendant always responded no. Smith raised those concerns a few times, but only learned that the relationship was more than platonic in 1994, when it was believed that Aaliyah might be pregnant. 2. Anthony Navarro, runner and sound engineer from 2007 to 2009. Anthony Navarro worked as a sound engineer in defendant's studio for 2.5 years. Navarro understood it was a very entry-level position and would include such duties as cleaning, doing food runs, and driving guests around. Navarro testified that numerous people came through the studio, including different girlfriends of the defendant. One of his responsibilities was to drive the girlfriends where they needed to go. He was instructed not to speak with defendant's guests. Navarro explained that defendant's guests were generally required to ask permission if they wanted things or wanted to order food, and they were not permitted to wander the studio or defendant's home unaccompanied. Sometimes these guests would stay at the studio for an extended time but could leave if they wanted to. Navarro did not know the details of why any female guests visited the defendant. Let me see. This is pretty much rehashing a lot of the testimony. Wait a minute. No, I just want to get to her argument. Because we talked about the women. Okay. All right, let me read this one about other bad act evidence. Over the defendant's objections, the district court permitted the government to admit testimony about defendant's uncharged sexual misbehavior with at least 8 other individuals, including testimony from Angela, Addie, Kate, Alexis, Louis, Alex, and Anna. The district court's order details the testimony of these other bad act witnesses. The district court further permitted testimony from numerous witnesses and through medical documents about defendant's history contracting sexually transmitted diseases, included herpes and his alleged transmission of herpes to women other than any complainants. The district court allowed the introduction of evidence related to defendants' alleged mistreatment of employees, including docking their pay for violating his policies and rules. The district court permitted the jury to hear audio recordings of the defendant's alleged verbal and physical assaults of his girlfriends unrelated to the charged offenses. The district court further permitted several video recordings of graphic sexual encounters, including sexual conduct between Alex, Dominique, and the defendant. The district court further permitted several recordings of graphic sexual encounters, including sexual conduct between Alex, Dominique, and the defendant. Defendant spanking a naked Anna and calling her insulting names, and Anna spreading feces on her own naked body. Oh, okay. Defendant filed a motion for a new trial based inter alia, means amongst all things, other things, on the court's admission of excessive, cumulative, and highly prejudicial other bad act evidence. The district court denied the motion. Verdict and sentencing. The jury returned a verdict finding the defendant guilty on all counts of the indictment. The jury acquitted the defendant of racketeering counts in connection to claims made by Sonia. On June 29, 2022, the district court sentenced the defendant to a term of 30 years imprisonment and imposed court fines and costs. The court deferred a ruling on restitution. Okay, so that's the seizure on defendant's trust fund account. That's about the restitution. Okay, so here's our argument. All right, y'all. So let me I'm gonna pause right there. Y'all hear my nose getting stopped up. So hold on, y'all. What's good with it? No, ma'am, Karen J. I had to go back. Somebody had a question. I guess somebody said something, and they wanted some clarification. Guess you wouldn't know. I guess you can guess what it was about. Them text messages and them parents. So somebody wanted about them being able to be called to the stand. Also, I just thought about this as to Larry's question. Any evidence that may be exculpatory to the defense, and that the defense knew about it, that wouldn't constitute a Brady violation if the prosecutor didn't put that in discovery, because it was discoverable by the defense. Okay? They do their investigation, right? That's different than new evidence that existed but nobody ain't know about it. Talking about evidence that could have been discovered by the defense themselves. Okay, so if there was any questions, and I'm just saying if things about the parents was admissible, there was any question about, you know, the the girl getting there, being there, this, that, and third, and whatever, and there was evidence or a good faith basis to believe something, or believe that a testimony from somebody that would, prove anything like that, then that's discoverable also by the defense. Everything doesn't constitute a Brady violation when it's not, turned over. If the prosecution knew about it and it was exculpatory, and if the defense knew about it and it was exculpatory, then the defense has um, just the same amount of responsibility to turn that over, right? Because that's their client, and you would think that, hey, so everything is not, if the prosecution is withholding the evidence that's only known to them, then that's something different, right? But to be on the safe side, just turn it over. Shit, just try to turn it over. Hell, I don't give them to have it if they got his name on it. On just on a blank piece of paper. Shit, turn it over. and the because you still have to go through the process of getting it admitted or not. That's why I always break up the term discovery and evidence, because it gives you a like a little chart, little flow chart, right? But actually, discovery is evidence. Um, yeah, we had a little Levi came in with his theories. Then Larry came up with his question about evidence and things of that nature. Y'all give me one more minute. Oh, hold on for a minute. Y'all, I'm coming. I'm hungry as hell. Hold on. All right, I'm back. I said I was going to get something to eat. You ain't hear me? Thank you. Lord have mercy. So listen. So can somebody help me understand this? I just want to understand this for once in my life. Why is it that Levi says that I minimize the text messages or whatever it is, whatever he hangs his hat on? I minimize it or I'm back or whatever it is when I not only I start off with my opinion. You know how I do. I start off with my opinion, what my opinion is based in, right? Then when we get facts in to support my opinion, I'm still minimizing it. No, they minimized it. I just know why they minimized it. They minimized it, not me. I just know why they minimized it. You understand what I'm saying? Yeah, they supposed to turn over exculpatory evidence. Anything that could constitute as admissible evidence. Anything that can impeach evidence or person impeach a witness testimony or cast doubt on some evidence, anything like that. Yeah, they're supposed to do that. Yeah. So based on that, how does what you're talking about fit along in the structure of the legal process of this case? It does not. Okay, so, a lot of this was already, like I said, a lot of it was already precluded, excluded, and wasn't admissible. It has nothing to do with the elements of the facts in the case, and there's no way your hypotheticals, it ain't gonna get it. You got to have more than just your hypothetical. And unfortunately, I know y'all don't like the brothers Johnson and whatever, but unfortunately, they had the records, they had the files, along with the attorney from this date going on back. And you ain't gonna tell me everybody missed all these hypotheticals y'all talking about that y'all think is a smoking gun. And that's if I'm just going along with it, which I know this shit ain't admissible and you can't prove it. I'm just going along with it. So you're gonna tell me all of them missed it? That's highly unlikely. That just don't happen. And not only them, all the legal clerks that working now, the paralegals, the motherfuckers that just came out of college, the investigators. Maybe I shouldn't say investigators because y'all go crazy about that. But all of them, it just ain't gonna work. All right, summary of argument. In Fitzgerald versus Chrysler Corp., Chief Judge Posner cautioned that where a statute is broadly worded in order to prevent loopholes from being drilled in it by ingenious lawyers, there's a danger of it being applied to situations absurdly remote from the concerns of the statute's framers. Such is the case here, where the government misused both the racketeer influence and corrupt organization statute Rico and the Mann Act in a manner never previously conceived or carried out. Galvanized by an influential social movement determined to punish centuries of male misbehavior through symbolic prosecutions of high profile men, the government brought a RICO prosecution against the defendant that was absurdly remote from the drafter's intent, stretching the liberal construction. Oh, okay. So let me tell you this. All right. When they say the word liberal construction, They are saying that it's the act of interpreting the statute broadly, right? They're interpreting, they're using the general meaning of the statute instead of using its literal meaning. And the opposite of that would be strict construction, which pretty much means you're using the language of the law exactly like it is. Okay, you're applying it exactly word for word. So if under 18 constitutes a minor, under 18 constitutes a minor. There's really no liberal construction you can, you can draw from that, unless you try to go, out the scope somewhere in the clouds and shit and say, even though they're 18 in age, they're not 18. Even though they're under 18 in age, they're over 18 in mind and spirit and shit. Some weird shit like that. Other than that, when it's a liberal construction, means that you are interpreting the statute in a broad and general type of way, okay, instead of using its literal meaning. And then when it's a strict construction, it means that you are applying the exact meaning of the words to the letter of the law. You applying the law exactly how it's written, right? So one just means pretty much interpretation of it, and the other ones meaning, the literal meaning of the law. Okay, it says, okay, so stretching the liberal construction clause well beyond the intent of Congress, the government constructed a Rico theory designed not to effectuate the purpose of the Rico statute, but to persecute the defendant for alleged misdeeds going back decades without pesky statute of limitation obstacles. Okay. In the end, the government failed to prove the offense of racketeering where evidence of a RICO enterprise was non existent. The government's evidence failed to show a collective of individuals who shared any common purpose other than to promote defendant's music. At best, the government demonstrated that the defendant used unwitting, low level employees to carry out anodyne tasks which arguably facilitate his sexual needs, but who had no knowledge, intent, or objective to promote his illegal sexual activities. So it seems like to me she's probably trying to poke holes in that the RICO, the literal meaning of RICO, and the qualifications it must be in order to be considered a RICO, right? So where in the defendant can't be both the corporation and the individual, or the enterprise and the individual, okay, or the organization and the individual. They can't be both. Then you have to draw a distinction between the two. And the problem with that argument is that most circuits and most in the Congress and everybody, except like a couple districts, states that it has to be. Well, that's not a problem with argument. It's actually a plus that you have to show distinction between the two. A couple districts said have passed and opinions that you don't have to show a distinction between the two and still be charged with a RICO, and it's perfectly fine. So we'll see. We'll see. So it says, adding to its long history of celebrity Mann Act prosecutions, the government charged defendant with violating federal law by arranging Jane and Faith travel to other states, California and New York, to attend his concerts with the purpose of violating public health laws, namely by exposing them to herpes during sexual intercourse. Neither Jane nor Faith were actually infected with herpes during these travels, because the government could not, as a matter of law, prove that a significant and motivating factor for the defendant's transportation of Jane and Faith was to expose them herpes in violation of state public health laws, the convictions cannot be sustained. And she's still trying to strike at the intent. But we saw where that failed in Judge Ann Donnelly's response to that, right? And of course, this is being reviewed by, a higher court. Again, they're going to give heavy weight to her decision, as well as rely on other opinions. Okay, so I cannot get this rib in here. I'm trying to pause so I can get a rib in my mouth, but I don't do it like that. So it says, there are more problems with the government's creative charging approach. For one, the California Public Health Code that the government contends the defendant violated, California Health Safety Code Section 120290, was repealed by the California legislature and was inoperative at the time of the defendant's prosecution. Further, both California Health Safety Code Section 120290, as charged in New York Public Health Law in Section 2307, which intend to criminalize exposure to communicable diseases, are unconstitutionally vague, where a person of ordinary intelligence would have no notice of what the statute prohibits. And as this case so aptly demonstrates, that statutes encourage arbitrary and discriminatory enforcement. Defendant may be the only person in history who has been charged with violating the Federal Mann Act based on alleged misdemeanor infractions of state public health laws. He is decidedly the only person who has been charged with violating these laws without having actually infected the alleged victims with an infectious disease. Now, this is her opinion that they were infected by him, right? But also, we do know that the law and the crime was exposing. And the knowingly part meant that you knew you had it, okay? So by your actions, you knowingly exposed them, allegedly. The government's proof problem extends to its forced labor charges, evincing a clear intent to make federal law coextensive. Can I bite this rib? Hold on 1 minute. Let me just bite this rib real quick. With the state law, the government charged defendant with violating the forced labor statute because on isolated occasions he instructed or directed Deronda and Faith to perform an act of oral sex on him. Where an isolated sex act is neither a labor or service, and neither women testified that defendant forced the sex act, the government failed to prove violations of federal forced labor laws. Sufficiency of the evidence aside, defendant is entitled to a new trial where the record shows that at a minimum, 4 of the seated jurors 3, 4, 5, and 12, were not qualified to serve, 2 of whom had watched the inflammatory tabloid docuseries Surviving R. Kelly. Trial counsel's performance was objectively unreasonable when he failed to move to disqualify patently unqualified jurors and failed to conduct any meaningful voir dire of prospective jurors who expressed their prejudgment of the case. Defendant was prejudiced by his own counsel's substandard performance, where it resulted in the seating of at least 4 jurors who were actually biased and could not actually with impartiality. there's more. Defendant trial was engulfed by irrelevant and excessive bad character evidence that added little to the jury's assessment of whether the defendant committed the charged offenses. Indeed, the 6-week trial was comprised overwhelmingly of uncharged bad act evidence that served no legitimate evidentiary purpose. Okay, wait a minute, something in my mouth. I'm sorry, y'all. This is so ghetto. With the court's blessing, the government smuggled in a mass of repugnant conduct under the guise that the evidence demonstrated the means and method of a non-existent enterprise. This was not about an enterprise. It was about the conduct of one man who the government sought to punish for his alleged history of mistreating women. As such, the mountain of bad act evidence offered in this prosecution was nothing more than inadmissible propensity evidence. And again, propensity evidence isn't allowed because it demonstrates the propensity of someone to break the law, right? It's showing that, they have a propensity based on their prior conduct to break the law. And that's not allowed because it's prejudicial. Because defendant was forced to defend against dozens of uncharged claims of abusive and sexual misbehavior, much of it lawful, albeit unpalatable for some, defendant was stripped of the presumption of innocence and denied a fair trial. Lastly, the district court abused its discretion in granting Jane nearly $300,000 in restitution and Stephanie $50,000 for a lifetime supply of Valtrex for herpes treatment, where the government failed to establish that the women were affected with herpes as a result of any of the charged conduct, that either of them are treated with a suppressive regimen of Valtrex, and or actually treat with Valtrex rather than Valcolor, the generic version of Valtrex, which is a fraction of the cost of Valtrex. The government failed to offer sufficient evidence to justify the exceptional restitution award. In short, the district court abused the purpose of restitution statute and granted Jane a windfall reward for costs she has never incurred or will incur, seemingly to punish the defendant. In its final push to punish the defendant, the district court abused its discretion when it ordered the Bureau of Prisons to turn over $27,000 of seized monies from the defendant's inmate trust account for use against future restitution award without any showing that the defendant had defaulted or failed to live up to his payment obligations. Defendant conviction must be reversed, or in the alternative, a new trial must be granted. Okay. The government failed to prove defendant guilty of racketeering where the record is devoid of evidence of an enterprise comprised of members who shared a common illegal or fraudulent purpose, and where the defendant and the alleged enterprise was indistinct. So she's doing what I told you that she's going to do, right? For racketeering enterprise under Rico, both the defendant and the enterprise has to be distinct, right? Can't be one and the same. She can merely support her argument by saying only one person was charged, as both the defendant, the person that did the illegal acts, by use of the enterprise who carried out the illegal acts. Well, that's one and the same person. But let's see how she makes the argument that they are the same person. Because the government makes the argument that they're different. Okay. Ignoring the distinctively economic legislative history of RICO statute, the government brought a RICO prosecution against defendant, not a remedy widespread criminal activity of an enterprise, but to punish one man whose alleged crimes could no longer be prosecuted by state and local agencies. Under the guise of the liberal construction clause, the government manufactured an ill-fitting RICO theory that was unsupported by the evidence. To be sure, prosecutors have used RICO in a wide variety of circumstances, but the liberal construction clause is not an invitation to apply RICO to new purposes that Congress never intended. In its rush to indict public enemy number one of the #MeToo movement, the government stretched the statute beyond its limits, applying it under circumstances leagues removed from the statute purpose. Accordingly, when the time came to prove its RICO charge, the government failed at the fundamental test of establishing an enterprise. To convict a defendant of racketeering, the government must prove at a minimum the existence of an enterprise and a related pattern of racketeering activity. Viewing the evidence in light most favorable to the government and drawing all inferences in its favor, the court must vacate defendant's conviction for racketeering where the government evidence of a RICO enterprise was insufficient. Meaning insufficient means that the evidence was not strong enough or did not prove the facts or the elements in the case that can be delivered to the jury for them to make a reasonable determination of his innocence or guilt based on what they submitted, right? So the general principles, legal principles. An enterprise includes any individual, partnership, corporation, association, or other legal entity, and any union or group of individuals associated in fact, although not a legal entity. The United States Supreme Court has defined a RICO enterprise as a group of persons associated together for a common purpose of engaging in a course of conduct. An enterprise is demonstrated by evidence of an ongoing organization, formal or informal, and by evidence that the various associates function as a continuing unit. For an association of individuals to constitute an enterprise, the individuals must share a common purpose to engage in a particular fraudulent course of conduct and work together to achieve such purposes. The enterprise purpose must be common to all of its members. The enterprise is neither the individual defendant nor the pattern of racketeering activity. Rather, it is an entity separate and apart from the pattern of activity in which it engaged, and must be alleged and proved separately. However, there must be a nexus between the enterprise and the racketeering activity that is being conducted. Against this legal backdrop, and taking the evidence in the light most favorable to the government failed to prove a RICO enterprise, assuming arguendo, meaning for the sake of the argument, the government's evidence was sufficient to establish that the defendant committed various sex offenses between 1994 and 2018. Its evidence did not show that those offenses were committed as part of an enterprise. Specifically, the government's failure to demonstrate a fraudulent or illegal common purpose of the enterprise distinct from the defendant or his racketeering activities was fatal to its RICO theory, notwithstanding the jury's verdict. Okay, let me explain that a little bit because that can get in the weeds, right? So they have to prove that each person's name is separate from the RICO enterprise. In this case, by her saying that the defendant is the owner operator of the enterprise, as well as the person whose name that had the conduct, that reaped the benefits, whatever. She's saying that it's one and the same. Okay, but there's several different theories, and there's so much, case law and shit that has been done with regards to that, and it doesn't help that when it gets in a higher court, that different courts have different opinions about how do you prove whether or not the Rico, the Rico, the defendant Rico, and the Rico enterprise isn't the same. Well, couple ways, right? The distinction can be met when the defendant reaps the benefits from the acts of the people in the organization. Okay? And by him being the person doing his own activity and reaping the benefits. They can try to show that the enterprise, which does not necessarily mean that everybody that works for him, okay, it could be subsidiaries, it could be like maybe he had a security company, maybe he used an accounting firm, maybe he used this, that, and the third, whatever, that they can operate on its own outside of the defendant. Okay? So, but when they have that word associated in fact, which they did in their indictment, and we talked about this many moons ago, several times. When you have that word associated in fact, that's your nexus. That's the nexus that she's talking about, that she mentioned that must be present. And the connection is the defendant and the people that they allege was a part of his enterprise. And this is when those three B's come into play. It's on the behest, behalf, and the benefit. Behest means that you're instructing somebody to do something. Behalf, you're acting as that person representative. And the benefit means that that person is reaping the benefit. So, I don't know how successful she will be with disproving this Rico, because, like I said, there are several different ways, and there's laws all over the place of that you can prove that the defendant and the enterprise are both distinct, meaning they're not one and the same. Okay, just by the benefiting factor in it. So I just wanted to, so because I'm pretty sure we're gonna get in the weeds with this. So I just want to make sure you understand that she's saying that the defendant and the enterprise is one in the same. So that would disqualify it as a RICO. The government is saying no, they're two separate entities. So during the trial process, they would have had to show evidence that they are two separate entities. I wasn't there, and I didn't read those transcripts, and I don't remember what was read. So we'll keep pushing. Okay. So it says, no common purpose to engage in a fraudulent or illegal course of action. In its third superseding indictment, the government alleged inter alia that the defendant, individuals he employed, and members of his entourage constituted a group of individuals associated in fact who functioned as a continuing unit for the common purpose of promoting defendant's music and brand, and to recruit women and girls in illegal sexual activity with defendant, and to produce pornography and child pornography. Defendant does not dispute that during his 25-year recording career, he maintained a production company that employed dozens of people. Defendant's business was no different than other businesses, both in the music industry and elsewhere. Typical of a hugely famous recording artist, defendant employed managers, accountants, engineers, security personnel, drivers, runners, and personal assistants. Defendant concedes that people on his payroll or in his so-called entourage generally shared a common purpose of promoting his music, but the evidence failed to show that his employees shared a common purpose to recruit women and girls to engage in illegal sexual activity with the defendant or in the production of child pornography. Out of the gate, this Rico prosecution was suspect when the only person named in the indictment was defendant. While the government is under no obligation to indict every member of a Rico enterprise, if the government lacks evidence to indict any other member of the alleged enterprise, it is a good sign that no Rico enterprise ever exists. Now, that is her persuading argument, but we went over the Rico several times reading the meaning, and we do know that one man can be an enterprise, as well as we read what the qualifications are with the predicate acts and all of that. Who is popping up on me? Yes, sir.
So with it,
What's up?
man. So I'm listening. I'm listening to it, right? And is it me or is this a regurgitation of the post-conviction motion? They sound damn near identical.
It probably is. But it's going to somebody else.
It's going to somebody else, right? But so what I'm saying is why did it take so long to get it? Like when you pretty much just copying and pasting everything. Why all the extensions when it's damn near the same shit?
Well, it's not that easy. I'm glad y'all think an attorney's job is that easy. No, it's not that easy.
I'm not saying it's easy. No. I'm not saying it's easy. I'm saying it's the same. I'm not saying it's easy at all. I'm saying that
you're saying it's the same, and I'm saying it's not just that easy. It's copying and pasting. She has to keep talking while I eat. She has to. I'm pretty sure she had to add, something a little more.
I'm pretty sure she did, but the bulk of it. I'm not saying that 100% of it is, but
Right.
it sounds like a good 90% of it is.
But what I was going to say is, she could have, and I'm not saying she did, but she probably did, when the judge wrote her opinion about why she declined it, why she denied it, she could have quite easily went through what the judge said and shored her argument up a little bit, keeping the majority of it the same, but kind of address what the judge said as a rebuttal, and hoping it once it move up the chain, it grants her a different outcome. So she probably keep the heart of it the same. But when you have a judge that gave a very detailed answer,
Yeah,
with regards to her ruling,
now, I think this approach that she's doing will be more applicable to Lyndon Weber, because he wasn't very detailed, like his explanations on his ruling. He wasn't detailed, just it is what it is. But Auntie Anne, she was very detailed. Not only was she detailed, she made it make sense. And it seemed like to me, Bojin is taking elements. For example, the herpes situation, the health, whatever thing that is.
Mm-hmm.
She's taking elements and fucking throwing them in the garbage and putting her own shit in there. And taking jury instructions that was given and reinserting her own shit. Like how?
Right.
If
But you heard me when I said, this is going to be her, her opinion, and not everything is, is going to be what she felt.
But how can the jury give a verdict off of instructions that wasn't given? Those was she saying? The jury wasn't given those instructions that she's given. So how can they make a decision based off instructions that they never was given?
Now, when you say instructions, what part do you?
For example, they give an instruction of it doesn't matter if they had contracted the herpes or not. It's the mere fact of exposure. She's saying no. It's not exposure. They need to get it, and he need to attend to give it to him. His intent need to be that he was going to give it to him. They wasn't given that when they to determine their verdict.
And that's not the statute. So what she's doing, remember I said, and I'm glad she the one brought up liberal construction, the liberal construction clause and all of that. So what she is trying to do is trying to force who's ever reviewing this to make a interpretation.
And just
to look at the law and say that it doesn't.
Interpretation or misinterpretation?
No, she want them to interpret it. Like maybe, and I'll use this word because they like this word, from the human side of it. Like, look at this and tell me if this is fair. How can my client be convicted of exposing someone to herpes when they never got the herpes, they never contracted herpes when the prosecutor said they contracted them? Because I think
so. How she know? How do she know they never contracted herpes? Where's she getting that from?
She don't have to. She don't have to have the evidence.
So I thought the burden of when it comes to appeal, I thought the burden of proof was on her.
It is. But remember, just like the prosecution, right? They had allegations when they started out, right?
And they had to prove those allegations beyond a reasonable doubt.
I mean, an indictment is just a written allegation.
Right. It started off that way.
Right.
It started off that way.
It starts off that way. This is she starting off this way. This is her. And you know what? I mean, there's no evidence to give because they're not relitigating this. So that's what really should let you know that it's really a persuasive argument. Because remember, appeals don't really accept evidence, only in very, 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 rare occasions. So this is a persuaded argument, right? So she's just pretty much saying that she want to take the law as it is stated, as it applies, what the elements were, whatever, and really want someone to draw a common sense answer from this. A common sense answer. Like, how can I give common sense answer? Like, how can I give?
Yeah, I know I got an echo. Hold on.
Common sense answer. Like, how can I?
Fucking dumbass nigga with this dumb shit.
Jojo.
Yes.
So let me finish up. You still got.
Listen. Let me say this. I'm not gonna be up here long. I just want to say this. If we will sit back and allow you to finish reading the briefing, a lot of these people questions will be answered. Real talk. I'm just making a statement. God damn. I mean, you get it. And normally I don't do this shit because I don't want to disrupt this. But this is some of the, this is what I mean by spitball throwing. Spitball throwing in classes happen all the time. Could you please constructively continue to read? And just maybe a lot of people, questions will be answered. I said it earlier. I said debriefing. Debriefing. And I'm quite sure a lot of these people had heard the briefing. What they're trying to do, they're coming trying to marginalize it and minimize it and flip it. But it is what it is. It's in there. And I'm quite sure a lot of these people have read it. They read everything else. So what's the difference now? You dig? Ain't nobody, and I'm going to tell you this, let me say this. No matter what you people think, his support system ain't going nowhere. Okay? So, a lot of y'all running around here saying this and that, it's just talk. You talk, we talk. So, can we get back to the briefing, please? And then we can have an open and constructive dialogue on what we have just heard. I'm out of here.
All right.
I don't know. Sound like he was in drive-through. I don't know what the hell he was saying.
So, well, anyway, so let me say this real quick, and I'll get right back. So this is her persuasive argument on paper, okay? Because remember, they can either grant it, send it back, whatever, deny it or whatever, based on what she's saying. And she's just wanting them to take a common sense look at the law. Sometimes, based on the situation, whatever, they can deem that the law, wasn't applicable. They can deem that the law was unconstitutional. They can deem, a lot of things. So when I spoke about it earlier, that's what I was saying. You just doesn't. This is her persuaded her argument, right? This is her persuading argument, and it doesn't mean that she's going to have the evidence to support it. It doesn't mean, and it definitely doesn't mean that she's going to be in lock and step with the law, exactly how it was written, or what the ruling was on it, or what the evidence was, or whatever. So that's pretty much.
And do you know when the government respond? Is that in there?
Well, if they want to respond, they can, or if they're asked to respond, they can.
Oh, okay. So it's no deadline of when they supposed to respond, or if they so if they choose to respond, do they have to respond by a certain date? Let me say it that way.
They will set the date. So if that's the case, if they need a response from the government, they'll set the date.
So you saying that as of now, the government don't respond unless they tell them to respond? Is that what you're saying?
No, they can. They don't have
okay.
to. No, they the defense now. Put that in your head. Like the theory, that's the defense now.
Right.
They can put on an argument to support it, or if they ask to, or can move the oral argument, or they could. I mean, the judge always is in charge of the imaginary clock in the court. So there might be a date that says you read somewhere in the policies and the procedures, might be 15 days. A judge can always adjust that, and somebody can always request a leave to do something outside of the policy and procedure. So to do it in 20 days instead of 15. So it's just it's no I'm reading Peter, so it's no they said it.
All right. All right. Go ahead. I'm gonna go ahead and yield back, and you can
You gonna yield back. All
get back to
right.
this brief.
Okay. Thank you, sir. Let me see, Karen, how many pages? It's 29. How many pages? Yeah. Oh, it is the whole thing. Okay, yeah, we're gonna be here a minute. Let me go back up. Well, it was 29. What was Okay. Let me put this shit up. But y'all give me one. Let me watch man and go to the bathroom real quick, y'all. I'm sorry. But we're gonna be here a minute. All right, thank y'all. Thank you, Miss Karen. Thank you so much, so much. Sorry. Okay. Okay, let me see, what was alligator. Let me start back here. Okay, out of the gate, this Rico prosecution was suspect where only person named in the indictment was a defendant. While the government is under no obligation to indict every member of a Rico enterprise, if the government lacks evidence to indict any other member of an alleged enterprise, it is a good sign that no Rico enterprise exists. The government bandied about the buzzwords of a legitimate Rico prosecution, quick to label everyone and anyone in the defendant's orbit as part of his inner circle, but came up short on actual evidence of an inner circle of people who carried out the purpose of the so-called enterprise. Of the 45 government witnesses, only 8 former employees testified. None offered testimony establishing personal knowledge of defendants' purported illegal sexual conduct, let alone knowing facilitation of it. Despite repeated references to defendants' inner circle, which connotes excuse me, connotes a small group of individuals close to the leader of a group, the government's enterprise evidence came largely from a handful of low-level employees. These employees were consistent in their account of working for the defendant. They largely just followed rules, some arguably strange but not inherently illegal. They were not privy to defendant's sex life or the details of his relationships. Most importantly, they never agreed to assist or help the defendant engage in illegal sexual conduct of any kind. Quite the opposite. For example, personal assistants Suzette and Alicette expressed concern about how defendant treated some of his live-in girlfriends, and both women worked for a defendant for short periods of time. Cheryl Mack quit her job the very next day after meeting Jane and observing her interactions with the defendant. The district court makes much of testimony that employees would sometimes pass defendant's phone number along to women. Not a single employee testified that they ever knowingly provided defendant's phone number to a minor or were asked. The record fails to show that there was an expectation to recruit underage girls on that any employee received a benefit for doing so. Oh, okay. See how she now trying to say, she threw that word benefit in there because she knows that based on some of the opposition to the whole, both the I can never say this right. I can, but not on the fly. Both the enterprise and the defendant are one and the same. She started talking about a benefit. Remember, I said if the group is getting a benefit, the organization is getting a benefit, and if the defendant is getting a benefit, that can be looked at as two different entities. But when the defendant is also in that group, that's the nexus, and they're getting a benefit, that's still two separate entities, but she could still kind of say it's one because per the government's allegations, I'd be trying to say this right, because I don't want no shit about y'all. Allegations, he's the only one got received the benefit and not any other members of his alleged enterprise, the organization. So this is going to be interesting to see, how they rule on this. Okay. They received a benefit for doing so. Indeed, Both Anthony Navarro and Tom Arnold denied ever providing defendants' phone number to underage girls or driving any women who appeared to be minors. In fact, the government's evidence revealed that employees were prohibited from interacting with defendant's girlfriend or talking about his relationship with them. Geronda testified that the defendant instructed her to continue to tell people that she was 19 after he learned she was 16. In short, the record is devoid of evidence that the members of the enterprise acted with the common objective of ensuring that defendant engaged in illegal sexual activity. Rather, the evidence showed that whatever illegal sexual activity in which the defendant engaged was concealed from his employees, and he took measures to keep his personal sexual life secret. That some employees witnessed concerning or odd conduct by the defendant is not the same as sharing a common purpose to promote his illegal sexual conduct. So she's again ripping into the definition of what they consider a racketeering enterprise, and the all the components it needs to be determined as one, what the government is supposed to prove. So remember, the government is supposed to prove certain aspects, well, all the aspects of a Rico, and she's actually saying that they're not, and they didn't, and that in fact some of it didn't, like the people didn't even know about his sexual history and things of that nature. So how can they have common knowledge, a common purpose to break the law with getting these women or whatever for illegal purposes, right? Meaning sex that wasn't consensual or the herpes thing, right? Almost conceding that evidence of an enterprise was insufficient, the district court held that the government was not required to show a common purpose of illegal or fraudulent activity so long as the persons associating a fact share any common purpose. Damn, if I kept reading, they would have said it better than I did, including the entirely illegal purpose, the entirely legal purpose of promoting defendant's music and brand. Not so as held, not so. Hold on. Oh, Jesus. Oh, thank you, y'all. Oh, I'm rich today, baby. Thank you, JoJo. Thank you. Thank you, Carla Washington, Karen, everybody that's giving me the money. Ooh, I'm going to be on here. I'm going to be reading for 2 or 3 days, y'all. Keep your pocketbooks open. I'm just joking, y'all. Y'all know y'all don't have to do that, but thank you. Woo. Maybe we want to sit up. Okay, it says, not so, as held in Satinwood, for an association of individuals to constitute an enterprise, the individuals must share a common purpose to engage in a particular fraudulent course of conduct and work together to achieve such purposes. And they all the case law. Then it says, all generally holding that to constitute as an enterprise, the association of individuals must share a common purpose to engage in fraudulent or illegal course of conduct. Thus, for the government to prove an enterprise here, it was required to prove that the defendant and all members of the so-called association, in fact, enterprise, came together with the common purpose of recruiting women and girls to engage in illegal sexual activity, not merely the broader purpose of promoting defendant's music or brand. I think she made that argument before, or somebody did. In an instructive case, Moss versus BMO Harris Bank, the plaintiff brought a punitive class action against First Premier Bank, alleging RICO violations. The plaintiff charged that First Premier Bank, a former legal entity, belonged to the Automated Clearinghouse Network, a payment processing system that processed unlawful ACH transactions on behalf of payday lenders. The plaintiff argued in alia that the ACH network constituted an enterprise consisting of originators, various depository financial institutions that receive ACH transaction instructions, ACH operators, and third-party service providers, all of which shared the common lawful purpose of facilitating batch processing of electronic payments for and between participating depository financial institutions. The court concluded that the ACH network described by plaintiff did not constitute an enterprise for RICO purposes because it did not share a common purpose to engage in a particular fraudulent course of conduct and work together to achieve such purposes, which was fatal to its claim. Then here's some other case law. And it stated that particular case law affirming dismissal of association in fact RICO claim where the amended complaint admitted that certain participants in the purported enterprise were not aware of deceptive practices at issue. And then there's more case law. It says, critically, the mass court expressly rejected the plaintiff enterprise theory, finding it implausible that all of the institutions that allegedly made up the enterprise possesses the unlawful intent required to transform that cooperative into an association in fact enterprise for RICO purposes. And there's more case law. And it says the Second Circuit of 2015 dismissing RICO claims that allege that defendants used the mortgage electronic registration systems to conceal unlawful mortgage transfers because plaintiff failed to show coordinated activity to jointly achieve a common fraudulent purpose. The mass court observed that at best the defendant used a legitimate network to advance its own illegitimate business interests and that the alleged illicit ACH transactions did not render the ACH network a RICO enterprise absent a common purpose among the other network participants to violate RICO. And right here, she's showing different examples of when the enterprise wasn't proven in certain cases where both both the defendant and the enterprise was one and the same, which means it was indistinct, okay, instead of distinct, but which means different from each other, and where the nexus there was no nexus in between the two, or where the people that was working in the organization did not know that they were committing a crime, so they didn't have common knowledge, so they couldn't be purposeful in committing a crime together for the benefit of the person that was in that was named in the RICO. So she's showing all these different examples. The mass court's logic applies with full force here. The government's evidence showed at best that defendant used his role with his legitimate music-driven collective to participate in private sexual misconduct. As in Moss, defendant's use of his otherwise legitimate music business to advance his allegedly illegitimate sexual needs does not render defendant's business organization a RICO enterprise absent a common purpose among his associates to violate RICO. That defendant's employees shared an abstract purpose of promoting defendant's music and brand does not satisfy the common purpose requirement. Still must exist a nexus between the objective of the enterprise and the racketeering activity. It is plain that for establishment of a RICO violation, there must also be some kind of relationship between the acts and the enterprise. For each of the substantive RICO subsections prohibit a specific type of interplay between a pattern of racketeering activity and the enterprise. And she has more case law. All right, so the 11th Circuit in 2020, holding that an abstract common purpose, such as a generally shared interest in making money, will not suffice to establish an enterprise. Rather, where the participants' ultimate purpose is to make money for themselves, a RICO plaintiff must plausibly allege that the participants shared the purpose of enriching themselves through a particular criminal course of conduct. More case law. The 11th Circuit of 2016, observing that the common purpose of making money would not be sufficient to find an association, in fact, enterprise between Spirit Airlines and outside vendors who merely provided anodyne services. Anodyne services. I'm sorry. Okay, okay, that's more case law. Ooh. Anyway, she case law heavy with all of this, okay? It's in order the district court claims that Satinwood is at odds with Turcotte because Turcotte mentioned nothing about a fraudulent course of conduct, holding only that the individuals in an enterprise must share a common purpose to engage in a course of conduct. A closer look at Turcotte strong suggests that the Supreme Court presumed illegality in the course of conduct to which it referred. The question presented to the court in Turcotte did not involve a deep dive into the course of conduct language, but addressed whether an enterprise encompasses both legitimate and illegitimate enterprises or is limited in application to the former. The court rejected the argument that an entirely illegal organization was outside the purview of the RICO statute or inconsistent with the statute's purpose. The court wrote, on the contrary, these statements of purpose are in full accord with the proposition that RICO is equally applicable to a criminal enterprise that has no legitimate dimensions or has yet to acquire one. During its discussion of Turcotte, assumed a RICO enterprise would have some criminal objective. The court compared those associations in fact that were entirely criminal in nature with those that were a mixed bag of criminality and legitimacy. Turcotte never suggested that an enterprise could be established by individuals engaging in a course of conduct with an entirely legal purpose that was unrelated to the alleged racketeering act of one person in the enterprise. The RICO statute was never intended to remedy criminal conduct of individuals who carried out their misdeeds through the use of routine services by their unwitting personal assistants. Under the government and the district court's logic, an entirely rogue actor working in an otherwise entirely legal organization could be prosecuted under RICO for merely duping his assistants or associates into facilitating his misdeeds with mundane tasks. One could think of countless duties asked of an unwitting personal assistant, such as making hotel reservations, calling an Uber, throwing out a bag of garbage, or delivering a message that could facilitate a crime perpetrated by an individual working in the context of a business. That does not a RICO enterprise make. Defendant and enterprise are not distinct. Relatedly, the government's evidence of a RICO enterprise was insufficient because defendant is indistinct from the enterprise, meaning they're one and the same. For Section 1962C purposes, the person charged with a RICO violation and the alleged enterprise must be separate and distinct from one another. Case law. It's a 2001 holding that one must prove the existence of two distinct entities, one a person and two an enterprise that is not simply the same person referred to by a different name. This requirement flows from the statutory mandate that a person who engaged in a pattern of racketeering activity must be employed by or associated with the enterprise. Okay, so must be employed by, associated with the enterprise. There's a bunch of case law she used. So it says the 10th Circuit in 1998, an entity cannot simultaneously be the enterprise and the person who conducts its affairs, permitting that would be tantamount to permitting an entity to associate with itself. Okay, making the theory that the defendant and the enterprise can't be one and the same when it comes to RICO. Okay. If, as the government claims, the objective of the enterprise was to promote the defendant and meet his personal needs, including his sexual activities, legal or not, the enterprise had no function unrelated to the defendant. So remember when I said them functioning outside of the the allegations, I'll put it like that. Okay. Were there other functions? So sometimes you might see, like a bus company, a security company, or whatever, okay, that they may say that's an independent company. It had some association in fact, and it did some business type things as an employee would do for an employer. Okay, so if, as the government claims, the objective of the enterprise was to promote the defendant and meet his personal needs, including his sexual activities, legal or not, the enterprise had no function unrelated to the defendant. They are one and the same. The government did not, and seemingly could not, indict a single other member of this enterprise under a RICO theory. Reflects the absence of an enterprise distinct from defendant. Since this RICO prosecution is the first of its kind and likely the last of its kind, this court must look to civil RICO cases for guidance. In Riverwood Supra, the plaintiff claimed that through acts of extortion and mail fraud, the defendant, Marine Midland Bank, coerced Riverwoods to restructure loan agreements between Riverwoods and Westchester Federal Savings, lately acquired by Marine Midland. Riverwood purchased a property in New Castle, New York, to develop residential condominiums and obtain a loan from Westchester Federal Savings for that purpose. Marine Midland later acquired Westchester Federal Savings and inherited the loan agreement. According to Riverwood, shortly after the acquisition, Marine Midland officers communicated an intent to dishonor the loan agreement and engage in extortive behavior to force Riverwoods to enter into a new loan agreement with terms more favorable to Marine Midland. In its complaint, Riverwoods alleged, inter alia, that through a pattern of racketeering activity, Marine Midland and two of its loan officers participated in the affairs of an associated, in fact, enterprise known as the Restructuring Group, in violation of 18 U.S.C. Section 1962C. The Second Circuit reiterated that under the plain language of the statute of RICO, person must conduct the affairs of the RICO enterprise through a pattern of racketeering, and that the person and the enterprise referred to must be distinct. The court emphasized that a corporate entity may not be both the RICO person and the RICO enterprise, acknowledging that the distinctness requirement could be satisfied where there is partial overlap between the RICO person and the Rico enterprise. Distinct requirement could be satisfied. Okay. And that a defendant may be a Rico person and one of a number of members of the Rico enterprise. However, by alleging a Rico enterprise that consists merely of a corporate defendant associated with its own employees or agents carrying on regular affairs of the defendant, the distinctness requirement may not be circumvented. The Riverwoods Court observed that because a corporation can only function through its employees and agents, any act of the corporation can be viewed as an act of such an enterprise, and the enterprise is in reality no more than the defendant itself. Then there was more case law. Third Circuit in 1991, where employees of a corporation associate together to commit a pattern of predicate acts in the course of their employment and on behalf of the corporation, the employees in association with the corporation do not form an enterprise distinct from the corporation. The Second Circuit reached a similar conclusion in Descon. There, Descon Inc. was a New York corporation whose primary business was to provide removal services to telephone companies. Descon argued that the defendant, NYNEX, a holding company that controlled subsidiaries, Mico, NYTEL, collectively the NYNEX defendants, conspired with AT&T Technologies to eliminate Descon from the market removal services by defrauding the public. Descon sued NYNEX defendants for civil RICO, alleging that NYNEX Group, which consisted of NYNEX MECO, and NYTEL, were three separate corporate persons that conducted the affairs of NYNEX Group enterprise through a number of illegal predicate acts. The Second Circuit observed that the distinctiveness requirement could not be circumvented by alleging a RICO enterprise that consists merely of a corporate defendant associated with its own employees or agents carrying on regular affairs of the defendant. Relying on Riverwoods, the Second Circuit stated that where employees of a corporation associate together to commit a pattern of predicate acts in the course of their employment and on behalf of the corporation, the employees in association with the corporation do not form an enterprise distinct from the corporation. The court observed that, like the defendants in Riverwood, NYNEX, MECO, and NYTEL operated within a unified corporate structure, and even though they were legally separate entities, the relationship between NYNEX, MECO, and NYTEL was not substantially different from that between the loan officers in Riverwood in comparison to the bank. In both cases, the individual defendants were acting within the scope of a single corporate structure, guided by a single corporate consciousness. So she's saying that they're still one and the same, and that even though it was association in fact with the bus drivers, the managers, and whatever they have in that indictment to prove on their enterprise, it was a company that had one single scope. They were all together and their actions were together. So it was considered a single structure instead of two separate, it's at least two separate entities. So therefore the RICO would not apply. That's what she's saying. So it says Fifth Circuit of 1987, finding no enterprise distinct from the person where the defendant bank is holding company and 3 employees were not associated in any manner apart from the activities of the bank. Applying the rules of the foregoing cases, the government failed to prove an enterprise distinct from the defendant. By alleging a Rico enterprise that consists of defendant and his own employees, agents carrying on his affairs, namely promoting his brand, his music, and even assuming arguendo, his sexual needs, the government fails to satisfy the distinctness requirement. Put differently, because the government alleged that the defendant employees associated together for no purpose other than to carry out the defendant's needs, including his illegal sexual activity, the employees did not form an enterprise distinct from defendant. Defendant and the alleged enterprise were one and the same. So it's so cool. I just thought about it. I guess that's a lawyer thing. Because she done repeated the same thing different ways by 500 times. I do the same thing. I just thought about it. Because I'm reading like, that. Damn, she done said the same thing different ways, whatever. Yeah. So, again, she's saying, and when you think about it, and I want y'all to think to yourself, because I'm thinking, and I'm probably wrong, but I'm thinking she has a good case. She put up a good argument when it comes to this, the formation of this Rico, as far as saying that the government didn't prove on what they were supposed to. Because when you look at it, and I don't remember all of the people that they considered a part of the enterprise, but if you say the bus driver was hired, you think about his duties. The managers was hired, you think about their duties. Security guard, they were hired, you think about their duties or whatever. It does suggest that they were carrying out duties, one, of a legal nature. That's one, but also in furtherance of his music career, in furtherance to move his company along. And if I remember in the indictment, it was kind of like plain language, where they were saying like she said, to recruit girls and things of that nature. If I'm not mistaken, that was in that indictment. So they put that there, to recruit girls and all that other bullshit. So I don't know. She might have an argument about this. I don't know though. I'm probably wrong, because this is why she can put up a whole lot of case law and things of that nature. They can come back and do the same, as well as revert right back to the actual RICO law itself. And the RICO law itself, talks about what type of entities it could be, and what kind of can be considered that particular type of entity. So I'm not sure about that. What was I? By alleging a RICO enterprise that consists of defendant and his own employees, agents carrying on his affairs, namely promoting his brand, his music, and even assuming arguendo his sexual needs, the government fails to satisfy the distinctiveness requirement. Put differently, because the government alleged that the defendant's employees associated together for no purpose other than to carry out defendant's needs, including his illegal sexual activity, the employees did not form an enterprise distinct from the defendant. Defendant and the alleged enterprise were one and the same. In sum, the government's theory of a RICO enterprise was flawed from the start. The government's evidence, taken in its best light, showed only that the defendant employed a collective of people over his 25-year career who promoted his career and music. So she's saying pretty much what I just said. They did not share an objective to commit sex crimes against women and girls. Accordingly, the government failed to prove an enterprise, and defendant's racketeering conviction must be vacated. Girl, you just said what the hell I just said. Ain't that some shit? Oh, girl, you might be on something. I don't know, but you know. The government's number 2. The government's evidence was insufficient to prove defendant guilty of violating the Mann Act as to Jane. Defendant was convicted of violating the Mann Act in connection with his sexual contact with Jane during 2 separate trips to California in 2015. In its superseding indictment, the government charged that defendant violated the Mann Act pursuant to 18 U.S.C. Section 2421A when he arranged travel for Jane to California first in around April-May 2015 and again in September-October 2015 with the intent of exposing her to herpes. Racketeering Act 8A, 9A, and Count 2. Now, again, she is asking for an interpretation of this, okay? Because we know that that's not the elements. That wasn't what the prosecutors had to prove. Alternatively, the government charged that defendant violated the Mann Act pursuant to 18 U.S.C. Section 2422A when he induced Jane to travel to California for the purpose of exposing her to herpes. Racketeering Act 8B. The government also charged that defendant violated the Mann Act when he enticed Jane, a minor, to travel to California in September and October 2015 for the purpose of violating California Penal Law Section 261.5A and 261.5B, Racketeering Acts 9A and 9D, and Counts 3 and 4. A. Insufficient evidence of intent. See? She's going to intent. Because defendant's motivating purpose in arranging travel for Jane to accompany him on tour in California on both occasions had absolutely to do with exposing her to herpes, the government failed to prove Section 2421A violations of the Mann Act. Summarily, the defendant had no intent to induce or coerce Jane to travel to California to expose her to herpes as required by Section 2422A. Thus, Racketeering Acts 8A, 8B, 9A, and Counts 2 must be vacated. Section 2421A provides that whoever knowingly transports any individual in interstate or foreign commerce or in any territory or possession of the United States with the intent that such individual engages in prostitution or any sexual activity for which the person can be charged with a criminal offense or attempts to do so shall be fined under this title or imprisoned not more than 10 years or both. The government superseding indictment, Racketeering Acts 8A and 9A, and Count 2 charged that the sexual activity for which defendant could be charged was a violation of California Health and Safety Code Section 120290, which prohibits a defendant from willfully exposing someone to a contagious, infectious, or communicable disease. Similarly, in this circuit, like others, to establish intent for Section 2421A purposes, the government must prove a significant or motivating purpose behind the travel was to engage the individual in the charged illegal sexual activity. Hold on. Similarly, in this circuit, like others, to establish intent for Section 2421A purposes, the government must prove that a significant or motivating purpose behind the travel was to engage the individual in the charged illegal sexual activity. Okay, but that's not it. Okay, let me keep reading. Okay, so this case law stated that holding that an intent must be the dominant motive of such interstate movement. The illegal sexual activity must have not been merely incidental to the trip. Okay, so she's saying that the sex had to be the motivating factor, not that the sex had to be the motivating factor and also the crime, not that going across state lines, then subsequent having sex under 18 or over, it doesn't matter, but exposing somebody to herpes is not what the prosecutor was supposed to prove. Okay, she is going to the sex as the motivating factor for her going across state lines to have sex, and she's saying that because you can't prove intent that was the case, then he was wrongly convicted with regards to this. Now, we know that differs from the elements and what they had to prove. They had to prove what the elements are, not particularly what she's stating, okay, here. All right. Under the significant or motivating purpose standard, the government's evidence of intent was insufficient because the record fails to show that defendant intended to transport Jane to California at any time for the purpose of exposing her to herpes, the prohibited sexual activity charge. The government and the district court agreed that the purpose of the travel was not to expose Jane to herpes, but argued that the motivating purpose in bringing Jane to California was to have sex, and that because those sexual activities could not have resulted in defendant being charged for violating the California Health Code for failing to disclose his herpes diagnosis, the government's proof was an act. Wait a minute, hold on. Wait a minute. The government and the district court agree that the purpose of the travel was not to expose Jane to herpes, but argued that the motivating purpose in bringing Jane to California was to have sex, and that because those sexual activities could have resulted in defendant being charged for violating the California Health Code for failing to disclose his herpes diagnosis, the government proofs were inadequate. But that's what they had to prove. Purpose was not to expose Jane to herpes. Agree that the purpose of the travel is not to display. Right, so the government didn't say the intention was to expose her to herpes. The language was knowingly, because if you know you got it, your intent doesn't fall in the line of specific intent, as she's trying to argue here. I know she's not using the word specific, but that's what it is, because there's levels of intent. Kind of falls under general or unintentional, which is still intent. It's not specific, and it's not broken down into a degree like first degree murder would be specific intent, second degree murder could be general intent. They're saying that the government is just saying that you had reasonable knowledge that when you had herpes, you had reasonable knowledge that having sex with someone, you can expose them to herpes. So that's the knowingly. So, you know how Jaybo gets down on the pencil. She gets down on it. I ain't mad at her. This logic is gravely flawed, as it reads the intent element entirely out of the statute. Damn, that girl be reading my mind. I'd be reading hers or something. It said a section 2421A violation of the Mann Act punishes travel plus intent to commit prohibited sexual activities. In this case, that prohibited sexual activity is a violation of the California public health laws. The act is not so broad as to punish travel plus a violation of a state law that results after the fact. Oh, okay, girl. Okay. You see what I was trying to say? Like the subsequent cause and the subsequent effect, right, of what happened. Okay. This is what we're talking about. Causation in such a way. Okay. So damn, that's good how she put that. The act is not so broad to punish travel plus a violation of a state law that results after the fact. Indeed, the United States Supreme Court held long ago in Mortensen versus United States that the intent must be found to exist before the conclusion of the interstate journey. Girl, go ahead on where you dug that up there, girl. And it says the Seventh Circuit of 2017, the crime begins in the state where the defendant set out with the intent to cross the state line and commit the crime. Okay. The Second Circuit of 2017. Wait a minute. The Second Circuit of 2017. Where am I? The crime begins in the state where the defendant set out with the intent to cross the state line to commit the crime. And then it goes on, it says, in this case law, 1917, the purpose of the Mann Act was to punish the movement in interstate commerce of women and girls with a view to the accomplishment of the unlawful purposes prohibited. The district court is simply wrong when it suggests that to satisfy the intent element, a general intent, bam, 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 don't play with your girl. I told you they was the government was probably arguing general intent or unintentional intent. But in this case, it's general intent. And Jaybo is trying to argue that it meant specific intent. Okay? Child, baby, don't fuck with me. Ooh, I'm unfuckable. Okay. It says, let me start over, child. It says the district court is simply wrong when it suggests that to satisfy the intent element, a general intent to engage in legal sex that ultimately could be charged for reasons entirely unrelated to the original intent of the travel satisfied the elements of a Section 2421A violation. Consider the hypothetical. Oh, Levi, she challenging you now. She don't want to challenge me to challenge your ass. Consider the hypothetical where a man arranges to have his adult paramour travel to another state for sexual purposes. But once there, she declines his sexual advances and he sexually assaults her. Under the district court's logic, this would constitute a Mann Act violation, which it decidedly is not. It surely would constitute a crime under California law, but not a Mann Act violation. The Mann Act was never intended to be a tool to punish violations of state law, particularly violations of public health laws. Okay, Jeff, here goes your argument about what probably should have been constituted as a state level crime. Okay, Jeff, tell wherever your ass is. It says the United States Supreme Court has warned courts to refrain from attributing to Congress an exercise of power to displace states in their traditional role of enforcing state criminal laws, which is absolutely correct. I tell y'all that from time to time, where Congress warns the federal about stepping in different instances, right? Especially when it comes to state. All right. There's a case law. It says, with that established, the government simply did not prove that when defendant arranged for Jane to travel to California in either April 2015 or September 2015, He did so with the motivating purpose to expose her to herpes in violation of a California health code. Similarly, the defendant did not, as a matter of law, violate Section 2422A, where even if he induced Jane to travel to California in April 2015, he did it as argued infer. It was not with the intent or purpose to expose her to herpes. Okay. The government's proofs as to Racketeering Act 9D Count 4 suffer from the same illogic, although admittedly at first blush it appears to be a closer call. The government alleged that defendant transported Jane to California in September and October 2015 to engage in prohibited sexual activity, namely violations of California Penal Law Section 261.5A and 261.5B, unlawful sexual intercourse with a person under 18 years old. While defendant's sexual activities with Jane in California arguably could have been charged under California law, the fact remains that defendant's motivating purpose in bringing Jane to California on tour was not to violate the California Penal Code prohibiting sexual activity with individuals under the age of 18. Defendant and Jane had a consensual and legal sexual relationship in Illinois. Defendant's purpose in traveling to California was to perform, and he arranged for his girlfriend to go with him. Jane herself admitted that the reason for their travel was for him to perform his shows. That defendant had his girlfriend with whom he was engaged in consensual sexual relationship in Chicago accompany him does not reflect an intent to violate the prohibited sexual activity. Oh Lord, get off the thing. Defined by California state law. If defendant had sexual relations with Jane in California in September and October, it was purely incidental to the purpose of the trip. Indeed, if the defendant had not brought Jane with him, he likely and perhaps did bring one of his other living girlfriends on the trip as his companion. Sex was likely assumed irrespective of who defendant brought on his travels, which underscores that it was merely incidental to his travels rather than a motivating and significant purpose of it. At bottom, no nexus exists between the transportation of Jane and the alleged illegal sexual activity charged as to any of the charged Mann Act violations. And then she is into insufficient evidence or coercion or enticement. 1 minute, y'all. 1 minute. All right, thank you so much, honey. I done told that goddamn real book. So all through here, she's asking for them to interpret, right? Maybe to go away from, not that you can't stray that far away from the actual language and the law, but she's asking for a lot of interpretations. Now, I don't see where she is using a lot of mandatory law to support her argument, right? That doesn't mean that's good or bad unless the prosecution comes back, and most times, it's, I think it's Florida is 30. I think Feds is 30 days or whatever. But again, the judge can adjust that if they want to. It's usually 30 days. But I don't see where she's doing a lot of using the actual language in the law, and how the going after the indictments and the elements, how it's actually written. It's more of how she's interpreting it. Okay, so just she's interpreting it more, and she keeps speaking as to a matter of law with regards to that, and that just simply means she's asking for an interpretation of the legal language and all of that, right? So that's it is what it is. Let's see. Is this what it was? Okay. One, April, May 2015 trip to California. Was I there? Oh, no. Insufficient evidence of coercion and enticement. Separately, the government failed to prove a Mann Act violation pursuant to 18 U.S.C. Section 2422A, where insufficient evidence exists to show that defendant knowingly persuaded, induced, enticed, coerced Jane to travel to California in April 2015 or September 2015. Did I move the... Okay. All right. One, April, May 2015 trip to California. The government's evidence showed that defendant invited Jane to come see him perform in California after they commenced an intimate relationship in Florida. There was no inducement or enticement to the part of the defendant. Indeed, Jane's testimony and contemporaneous text messages between Jane and her mother reflected, oh God, Government Exhibit 233A, volume 1 of 7. Ooh, y'all, where them text messages at? See, is this up on the top of them text messages? Who got the text messages? Hold on, y'all. I'm going to put it in the chat so we can really see, was that whole thing in that goddamn text message? Shut up. Sorry. Okay. Is that see if that's the is that the number or anything like that on those text messages? If whoever got them, I got them, but shit, y'all want me to read? Okay, let's see. Okay, that at the direction of her mother, Jane deceived defendant about her age and carried out a plan to meet him and engage him in a relationship, not the other way around. To be clear, defendant concedes that neither Jane nor her mother's conduct, no matter how troubling, would be a defense to this charge if defendant did, in fact, induce or entice Jane to travel to California for an illegal sexual activity. But the evidence shows only that defendant invited Jane to travel to California to attend concert, reasonably believing her to be 18 years of age, and she accepted. So right there, Banjin is saying she knows that that's an illegal defense. But again, she is talking about, she's trying to use it to say that the defendant didn't have to entice nobody to go across state lines to then where all the rest of the shit and where the crime started. When with the sex or whatever. That's what she's using. So that's why she said, to be clear, the defendant concedes that neither Jane nor her mother's conduct, no matter how troubling, would be a defense to this charge if the defendant did, in fact, induce, entice, blah, 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 blah. Okay? It wouldn't be a defense if the defendant did. Meaning that wouldn't be a defense if he did induce, entice, or whatever. And remember, the government won this, and they got the conviction because they proved. I'm just going back with the court. I'm not talking about what I think. I'm talking about what the court did. They proved to the jury's satisfaction that he actually did the induce, entice, and blah blah blah. Okay. After attending one of defendant's performances with the parents in Orlando on April 11, 2015, Jane's mother obtained defendant's phone number and began communicating with defendant, posing as her daughter. Jane eventually communicated directly with the defendant via FaceTime and told him she was 18 years of age. Jane did not reveal her true age until months later. On April 20, 2015, Jane's mother, still pretending to be Jane, arranged for Jane to meet defendant ostensibly to audition for the defendant. However, Jane and her mother were aware that defendant, believing Jane to be 18, was also interested in Jane sexual. In one text, Jane's mother texted her daughter stating, "This man trying to screw, but I'm trying to make it business. He knows you're a singer, but he ain't playing. He wants to fuck tonight." Despite that, Jane and her mother were on notice that defendant was interested in Jane sexually. Jane's mother encouraged Jane to entice the defendant and to be prepared to sing 3 songs and all that. I don't think I have to read that over again. After their first encounter, Jane and defendant continued to text at the encouragement of Jane's mother, and defendant eventually invited Jane if she wanted to attend his concert in California. Jane reported back to her mother, "Jane, and I talked to R. Kelly. Mom said, yeah, about what? Jane, LMO, about flying me out. Mom, oh, really, when? Jane, yeah, whenever I tell him he can. Tomorrow if I choose. Mom, oh, yeah." On April 28, 2015, Jane traveled to Los Angeles, California to meet defendant with the knowledge and consent of her parents. At no point did Jane express any apprehensions about being with defendant or ask her mother to arrange for her to come home. When Jane excitedly told her mother that she was riding defendant's tour bus to Stockton to attend his concert, Jane's mother responded, "Oh my God, exciting, you're riding on the tour bus?" On May 1st, 2015, Jane's mother urged Jane to take advantage of defendants texting her, "It won't be star lifestyle if you don't get serious about your music and show this man you want to be famous like him." Wait a minute. On May 1st, Jane's mother urged Jane to take advantage of defendant texting her. Oh, okay, so she's trying to legend here that her mother urged her to take advantage of the defendant. That's why it won't be a star lifestyle if you don't get serious about your music and show this man that you want to be famous like him. Once he tired of you, you'll be like everybody else. You better use this as your opportunity while you got him in spell. Jane's mother then said, "You should text him and be like, you gonna be my boo, and see what he say." To which Jane responded, "Laugh my ass off." Jane, ooh, that's inappropriate as hell. Jane traveled with defendant from Los Angeles to Stockton, California, telling her mother. He asked me, did I want to come to his show? And I said, of course. And he said, okay, then let's pack this stuff up. He was even putting his stuff in my bag. Jane and her mother remained in constant communication before defendant's show. Jane's mother instructed her about what to wear and make suggestions about how she should behave at defendant's show. I would blow him little kisses and wink at him and bite the top of my finger, mess with him real good, do something seductive, then make a silly face. LOL. Jane and her mother continued to text throughout defendant's performance. At one point, Jane's mother suggests that Jane would marry the defendant and that her son-in-law would be older than her, Jane's mother. According to Jane, she and the defendant had sexual intercourse for the first time after this concert. No rational juror would conclude that defendant enticed, persuaded, induced, or coerced Jane to travel to California. Jane's testimony, along with contemporaneous conversations with her mother, showed that defendant invited Jane to join him and she accepted. The government suggested that defendant's mere act of arranging for Jane's travel is sufficient to demonstrate that he induced her to travel to California because he caused her to travel. The law says otherwise. The Second Circuit has made clear that the terms persuade, induce, entice, and coerce are words of common usage that have plain or, well, she probably meant plain, but she says plain, but plain, ordinary meaning. The case law says the Second Circuit of 2007, the court distinguishes this conduct from merely asking, which is not sufficient to demonstrate criminality, recognizing that there might be some uncertainty as to the precise demarcation between persuading, which criminalized, and asking, which is not. Okay, so uncertain as to the precise demarcation between persuading, which is criminalized, and asking, which is not. Okay. Okay, where the government, that's a good point she got, where the government concedes that defendant was operating under a reasonable belief that Jane was 18, Jane and her mother knew that defendant was interested in Jane sexually from Jump Street, and defendant merely invited Jane to meet him in California to attend his concert. The government failed to prove coercion or enticement. An invitation, even from a famous recording artist, is not presumptively enticing or coercing. The government's evidence failed to show that Jane was persuaded, induced, enticed, or coerced into traveling to California. She was invited and accepted at the encouragement of her mother, knowing full well the defendant had a sexual interest in Jane, who he believed to be legally consenting age. Number 2, September-October 2015 trip to California. The government charged defendant with Mann Act's violation pursuant to Section 2422A and B under the separate theory that defendant did knowingly and intentionally persuade, induce, entice, and coerce Jane to engage in prohibited sexual activity under California Penal Law Sections 261.5A and 261.5B. Unlawful sexual intercourse with a person under 18 in September 2015 and October 2015. As already discussed, the government failed to prove an intent to travel for the purpose of violating California statutory rape laws, where he was engaged in a legal sexual relationship with Jane in the state of Illinois. Okay, furthermore, the government simply failed to prove that defendant took any action to induce, persuade, entice, or coerce Jane into traveling to California. Jane did not testify that defendant took any action to persuade, induce, entice, or coerce her to engage in prohibited sexual activity while the two were in California. As a result of his September-October 2000 California, as a result of his in September-October 2015, defendant and Jane were in sexual relationship based primarily in Illinois, where defendant and Jane reside at that point. Although Jane testified that defendant had already started engaging in a controlling fashion, she did not testify that he coerced or enticed her to accompany him on tour. Jane traveled with defendant to numerous states as one of his partners. She went consensually and voluntarily and remained defendant's partner until 2019. Defendant did not have to induce, persuade, entice, or coerce Jane to travel to California for prohibited sexual activity, even if Jane later characterized the relationship as abusive. The government's Mann Act theories were defective from the start, where the government distorted the purpose of the act, stretched its commerce power beyond all limits, making it difficult to imagine a scenario where the federal government could not exert its control into traditional areas of state control. Oh, wait a minute, that's a good point. Wait a minute. Beyond all limits, making it difficult to imagine a scenario where the federal government could not exert control into traditional areas of state control. Wow. The government's proof as a matter of law, then once again, she's asking for interpretation, were insufficient, and this court must vacate defendant's convictions for Racketeering Act 8 and 9, counts 2 through 5. The government's evidence was insufficient to prove defendants guilty of violating the Mann Act as to faith. The government charged defendant with multiple violations of Mann Act in connection with 2 sexual encounters with faith in New York. Specifically, the government charged defendant with violating 18 U.S.C. Section 2421A and Section 2422A, 2421A and 2422A, in connection with a sexual encounter that occurred in New York on May 18, 2017. Racketeering Acts 12A and 12B and count 6 and 7. And another encounter that occurred on February 2, 2018. Racketeering Acts 14A and 14B and counts 8 and 9. A. Insufficient evidence of intent. Racketeering Acts 12A and 14A, count 6 and 8, charge that defendant transported Faith to New York on 2 separate occasions, May 18, 2017 and February 2, 2018, with the intent to engage her in sexual activity that would expose her to herpes in violation of New York Penal Law Section NYPL Section 120.20, Reckless Endangerment and Public Health Law Section 2307, New York PHL Section 2307, non-exposure of infectious venereal disease. Because there is no link connecting defendant's transportation of Faith with an intent to expose her to herpes, defendant cannot, as a matter of law, be guilty of the charge Section 2421A violations. As discussed at length, supra, the government must prove that charge illegal sexual activity as a significant or motivating purpose behind the transportation. Okay, I don't know if that's true, but it says because the defendant purported violations of a New York public health law prohibiting him from exposing a partner to herpes and reckless endangerment was incidental to Faith's trip rather than the motivating purpose in transporting Faith to New York, The intent requirement of the statute cannot be sustained. As previously discussed, defendant possesses an intent to carry out the prohibited sexual conduct prior to the travel. The government misled the jury concerning the law, which would explain why the jury returned guilty verdicts on these counts. When it argued that defendant transported Faith to New York for the purpose of sex, the only remaining issue is whether the sexual activity that he brought her here for was illegal, and it was. This argument falsely suggested that the government only need to show a general intent to transport Faith to New York for sex, irrespective of whether he possessed an intent to engage in illegal sexual activity. As addressed supra, the government proves a section okay, proves a section 2421A by showing transportation plus intent to commit unlawful sexual activity, not intent to commit lawful sexual behavior that may result in illegal conduct. As we just the government proves that section showing transportation plus intent to commit unlawful sexual activity, not intent to commit lawful sexual behavior that may result in illegal conduct. Okay, so she's saying that because she was 18, it could be lawful sexual behavior that resulted in illegal conduct. Thus, the government was required to show the motivating purpose behind the defendant's transportation of Faith was to expose her to a venereal disease in violation of a specific offense charge. The same is true in connection with the Section 2422A offense, where if the government showed that defendant persuaded, induced, enticed, coerced Faith to travel to New York, his motivating purpose in doing so was not an intent to expose her to herpes. B. Insufficient evidence of coercion or enticement. Racketeering Acts 12B, Count 7, and 12B, Count 9 similarly charged that defendant did knowingly and intentionally persuade, induce, entice, and coerce Faith to travel in interstate commerce to engage in sexual activity that would expose her herpes expose her to herpes in violation of New York Public Health Law, Section 120.20, and New York Public Health Law, Section 2307. The government failed to prove that defendant took any action to induce, persuade, entice, or coerce Faith into traveling to New York on May 18, 2017, and again on February 2, 2018. Defendant's mere status as a famous recording artist cannot satisfy the government burden to prove enticement or coercion. Rather, the undisputed evidence shows only that defendant invited an adult woman to meet him in New York, and she accepted. In March 2017, Faith attended one of the defendant's concerts in San Antonio, Texas, with her sister. Faith had an opportunity to meet defendant at an after-party backstage along with other individuals. Defendant and Faith had a conversation during the after-party, and defendant provided her with his phone number. After that encounter, Faith and defendant kept in touch via text and FaceTime. The conversations were normal, appropriate, and pleasant. Defendant complimented her appearance. Faith testified that defendant referred to himself as daddy during those conversations. According to Faith, defendant asked to be called by daddy, and she agreed. Faith did not testify that defendant forced her to call him daddy. Indeed, defendant and Faith had met exactly one time when Faith began calling him daddy. On the issue of travel, Faith had this to say. Okay, on the issue of travel, Faith had this to say, question. In your communications with the defendant, how, if all, did the topic of traveling to see him come up? He had informed me that he was on tour right now, or excuse me, at the time. He was on tour, so he was just saying his schedule was kind of crazy. But whenever I wanted to come see him, I could. And he just said that he could arrange the days or just let him know when I wanted to come hang out. But that it would be fun. I would get to see, how it is, how he's on tour and things like that. Defendant told Faith that if she wanted to come to his shows, she could contact his assistant and he would arrange it for her. Faith then contacted defendant's assistant who made travel arrangements for her. Originally, Faith was going to travel to Chicago, but ultimately traveled to New York for one of defendant's performances. According to Faith, defendant informed her that he was having a show in New York and that he would like for her, that he would like for, wait a minute, that he was having a show in New York and that he would like for me to come to hang out. It was going to be fun, so I said yes. Defendant assistant arranged her travel, and Faith traveled to New York to attend defendant's performance and hang out. The Second Circuit has made clear that the terms of persuade, induce, entice, and coerce are words of common usage that have plain ordinary meanings. The court distinguishes this conduct from merely asking, which is not sufficient to demonstrate criminality, recognizing that there might be some uncertainty as to the precise demarcation between persuading, which is criminalized, and asking, which is not. No rational juror could conclude from Faith's testimony that the defendant coerced or enticed her to travel to New York for the purpose of giving her herpes, no less. By Faith's account, defendant was polite, generous, and appropriate, leaving it entirely at her discretion to come to New York to attend a concert. Defendant's invitation does not equate to inducement or persuasion. Maybe she meant persuasion. Inducement or persuasion. Okay. C. New York Penal Law 120.20, reckless endangerment. To the extent defendants' Mann Act convictions rest on violations of NYPL 120.20, the government failed to sustain its burden because unprotected sex with a person who carries the herpes virus does not establish a substantial risk of physical injury. No New York court has ever found such. Oh, okay. Indeed, as best as defendant can tell, no one has ever been prosecuted in the state of New York for reckless endangerment for exposing a sexual partner to herpes who was not infected with herpes. Needless to say, the law on this issue is lacking. Okay, so now they're not saying that she's not infected with herpes. Okay, I'm gonna stop and get this straight because this is gonna be some shit. She's saying, and kind of repeating her same argument, that he did not affect her with herpes when she met him in New York. Now, unless she go on to say that this girl don't have herpes, then again, that's just a matter maybe of her opinion. I don't know. But, she said, needless to say, the law on this issue is lacking. At outset, Faith did not contract genital herpes. And she's talking about genital herpes. Now, remember, I think Faith's mom said she got it in her mouth. I don't know. Faith claimed that at some point in time after she visited New York, she was diagnosed with herpes type 1 after getting a cold sore on her mouth. She did not testify that she contracted genital herpes, and there is no evidence that she did. Okay, so that's what I just said about the mouth situation. I don't know nothing about no herpes. So I really can't tell you what the herpes 1 is and all of that. I really don't try to sit up there and read about no herpes. But this is all about the herpes. Okay, so she said she did not testify that she contracted genital herpes, and there is no evidence that she did. Presumably, even the government would concede that cold sores caused by herpes type 1 and carried by 50% of the population, I told you we all got it, does not cause a substantial risk of serious physical injury. Furthermore, as a matter of law, unprotected sex with someone who has genital herpes does not establish a substantial risk of serious physical injury. According to the City Health Department, 1 in 4 New Yorkers has genital herpes. Oh my God. If sexual intercourse with individuals who merely carry the genital herpes virus carries the substantial risk of serious physical injury, New York City would have astronomical hospitalization and death rates from the transmission of herpes. Although Dr. Hoskin, the government's expert witness, identified some serious but unusual health risks associated with the contraction of genital herpes, the offense of reckless endangerment requires a showing of a substantial risk of serious physical injury. To be clear, defendant accepts that in rare circumstances, someone afflicted with herpes could suffer serious physical injury. But here, the government did not prove that Faith faced substantial risk of being infected with herpes, or that a substantial risk that would suffer the rare complications that would satisfy the serious physical injury element. Dr. Hopkins estimated that there exists a 10% to 20% chance of a risk of transmission when someone is managing their infections with Valtrex, as defendant was. Also, they saying the defendant had the herpes because he was managing it by the Valtrex. It says this hardly qualifies as a high risk of transmitting the disease, nor does it consider the even lower risk that someone who contracts the disease will suffer the rare complications that could qualify as serious physical injury. Now, if the serious physical injury is one of the elements or effect in the case or whatever that the prosecution was supposed to prove, then she might have a point. Herpes is not deadly, is treatable if not curable, and rarely causes any serious protracted health impairments. Complications associated with herpes carry a low, rather substantial risk of serious physical injury as defined by the statute. The government cannot, as a matter of law, sustain this claim. In short, merely having unprotected sex with someone who carries the virus cannot, as a matter of law, create a substantial risk of being infected with the disease and suffering the rare complications that qualify as a serious physical injury. The government cannot point to a single case that supports the prosecution's expansive reading of this statute. D. New York Public Health Law, Section 2307. To the extent defendants' Mann Act convictions rest on violations of NYPHL Section 2307, the government failed to sustain its burden because there was no evidence presented at trial demonstrating that the defendant was infected with a venereal disease during his sexual interactions with Faith, which explains why she never contracted genital herpes from the defendant. New York Public Health Law Section 2307 reads, Section 2307, venereal disease, person knowing himself to be infected. Any person who knowing himself or herself to be infected with an infectious venereal disease has sexual intercourse with another shall be guilty of a misdemeanor. By the plain terms of this antiquated provision, a defendant must know himself to be infected with an infectious venereal disease to violate the provision. Remember, I was talking about a defense such as that. Like, how did he, if he didn't know he had it, how did he violate that particular law? Thus, the government not being able to prove on those elements, right? The government and district court interpret infected to mean merely carrying an infectious disease rather than having a herpes-related infection. The statute is silent as to the definition of infected, meaning she's asking for an interpretation. The word infected in the statute must be interpreted, damn, she beat me to it, to mean active infection to avoid constitutional concerns. It is axiomatic that most courts, state and federal, will generally interpret statutes so as to avoid constitutional difficulties. There's a case law, and it says the Second Circuit in 2015, as the evidence at trial show herpes is a virus that may constitute a venereal disease, but it does not follow that having the virus equates to having an infection. That said, an active outbreak of herpes where someone experiences blistering and open sores that would give them notice that they are contagious would qualify as an infection. The only logical and constitutional reading of the statute requires the government to show that the defendant was experiencing a herpes infection at the time of his sexual encounter with Faith, which would have put the defendant on notice of the possibility of transmitting the disease to a sexual partner. So she's trying to just center in and narrow it down, saying that you could only pass the shit when you have an outbreak, and the only way that he would know that he could possibly infect somebody is if he's having an outbreak, which will put him on notice, which would tell him to inform his sexual partners. But she's saying it because he didn't have all that going on, he didn't know. So how could he inform somebody that he didn't know that he could at that time be infectious and infect somebody else? Okay. If this is not the case, then New Yorkers are violating the public health law every minute of every day without any consequence. The government presented no evidence that the defendant was experiencing a herpes-related infection. Damn, I'm good. During his sexual encounters with Faith, and Faith admitted that she did not contract genital herpes from the defendant. Accordingly, the government failed to prove a violation of NYPHL Section 2307. Because New York Public Health Law Section 2307 is unconstitutionally vague, defendant's Mann Act convictions predicated on that law must be vacated. The government's Mann Act convictions to Faith are predicated in part on his alleged violation of NYPHL Section 2307, and she refers back to an appendix. Discussed above, prior to his trial, defendant unsuccessfully challenged the constitutionality of the law on due process grounds. She must have meant due to process grounds. Defendant unsuccessful challenge the constitution of the law on due process grounds. Okay, Lord have mercy. What's wrong with me? So now she's due process. Okay, now she's coming with the constitutional violations. Right? Remember I said we're going to look to see if she hit at the constitutional violations. We couldn't tell by the appendix that she it wasn't plainly stated in the appendix that she had, but based on me pulling them out and reading them, I saw where some of the objections she had before we got the brief could be based on constitutional violation. So she's talking about his due process grounds, right? The Fifth Amendment provides that no person shall be deprived of life, liberty, or property without due process of law. The Supreme Court observed that our cases establish the government violates the guarantee by taking away someone's life, liberty, or property under a criminal law so vague that it fails to give ordinary people fair notice of the conduct it punishes, or so standardless that it invites arbitrary enforcement. Meaning, like, if you don't, it should be against the law that if you don't know that you're violating the law, then how could you intentionally violate the law? One, and then how could you intentionally violate the law? And it's it's unfair if you don't. Well, I lost my train of thought. What was the other second one? But it's unfair. Oh, you take away a person's a defendant's choice. If they're not sure whether they violating the law or not, maybe if you know the law, maybe you would decide that day not to violate the law. You heard me say that several times, but let me see what she said. Okay, it says the prohibition of vagueness in criminal statute is a well-recognized requirement consonant alike with ordinary notions of fair play and the settled rules of the law, and a statute that flouts it violates the first essential of due process, which is what I kind of said. These Fifth Amendment principles apply to state laws through the 14th Amendment. The Due Process Clause of the 14th Amendment requires that every criminal statute give the person of ordinary intelligence. You see I'm right there with that word. And this is what she's trying to point out, what I just said, but she's going to say a lot nicer. And she's reading right from statute. Gives the person of ordinary intelligence a reasonable opportunity to know what is prohibited. Bam, what I said. And provide explicit standards for those who apply the statute. The Second Circuit of 2010, a plaintiff making an as-applied challenge must show that the statute in question provided insufficient notice that his or her behavior at issue was prohibited. Meaning what I just said, you don't know you're breaking the damn law. So how can that be constitutional, right? Even if a person of ordinary intelligence has notice of what a statute prohibits, the statute nonetheless may be unconstitutionally vague if it authorizes or even encourages arbitrary and discriminatory enforcement. New York Public Health Law Section 2307 fails both prongs of the Dickerson test by failing to define infection or including a mental state other than knowledge. The statute fails to put people of ordinary intelligence on notice of what conduct is prohibited. Furthermore, this court needs to look at further than this case to see that the statute authorizes or encourages arbitrary or discriminatory enforcement. As best as defendant can tell, he is the only person in New York history who has been prosecuted for violating this statute where the victim was not infected with the venereal disease. 1 in 6 Americans, 1 in 4 New Yorkers suffer from genital herpes. So I know at least 4 New Yorkers in this YouTube sector. One of y'all got the herpes. Raise your hand if you got the herpes. Put it in the chat. Okay, I can't see it anyway, but put it in the chat. So as discussed previously, although herpes is not curable, there are highly effective treatments for herpes that prevent infection. Under the plain reading of the statute, even a person who carries the virus but who has been asymptomatic for decades would commit a crime by having sexual intercourse with another, irrespective of whether he disclosed his status to his partner. I don't know if it says that, Jaybo. Wait a minute now. Oh, she said, okay, somebody's asymptomatic. Got it. Asymptomatic. That's not really how it went, but okay. In the absence of a definition of infected, the statute is unconstitutionally vague. The government and the district court's interpretation of the statute is highly stigmatizing to the millions of individuals who have been diagnosed with herpes simplex 2. The disease is easily treated with a suppressive drug regimen, and people often experience complete remission from infection. While the district court assumed that infected meant having the virus rather than having the ability to transmit it, no authorities support this application, and such an interpretation not only fails to appreciate how many people carry the virus, but would also lead to arbitrary and discriminatory enforcement. Indeed, under government's interpretation of the statute, it seems likely that every sexually active person in the statute of New York is routinely violating the statute. She must have been in the state of New York is routinely violating the statute. Human papillomavirus, HPV, is a sexually transmitted disease that, according to the Centers for Disease Control and Prevention, the CDC, is so common that nearly all sexually active men and women get the virus at some point in their lives. Y'all, oh Lord, we all got the human papillomavirus. Y'all didn't know I'm a hypochondriac, right? Oh Lord. A person of ordinary intelligence would have no idea that they are prohibited from having sex in the state of New York if they have HPV, which would probably constitute 90% of the sexually active population. Oh Lord, the people in New York, not only 1 in 4 of y'all got them herpes, but all y'all on here got the HPV. Oh, y'all must stop having sex immediately. In some, NYPHL Section 2307 is unconstitutionally vague. Oh Lord, they got it in New York. And this court must vacate defendants' Mann Act convictions to the extent that they rely on this unconstitutionality vague statute. Defendants' Mann Act convictions predicated on a violation of California Health and Safety Code Section 120290 must be vacated because the government charged defendant with a repealed version of the statute that was unconstitutionally vague. So that pretty much says it what it is. The government charged defendant with several Mann Act violations predicated on defendant's alleged violation of California Health Code Safety Code Section 120290. However, the government charged defendant under a repealed version of the statute no longer in effect. Prior to the jury charge in this case, defendant notified the court that the jury instruction did not reflect the elements of California Health and Safety Code Section 120290. The government acknowledged as so much, but argued that it charged defendant under the statute that was in effect in 2015, not the current statute. The government had no authority to charge defendant with a statute that was repealed or inoperative at the time of prosecution. In that case, the statute is repealed or rendered inoperative. So I don't know if the government shit. Hold on. My mind gone. Y'all don't have to excuse me. What the fuck I was gonna say. Well, if she said I get to an operative, no further proceedings can be had to enforce it in pending prosecutions unless competent authority has kept the statute alive for that purpose. In 2015, Section 120290 of the California Health and Safety Code provided, except in provided in sections 120291, or in the case of the removal of an afflicted person in a manner the least dangerous to the public health, any person afflicted with any contagious, infectious, or communicable disease who willfully exposes himself or herself to another person, and any person who willfully exposes another person afflicted with the disease to someone else is guilty of a misdemeanor. And willfully exposes, it's that thing like knowingly exposing yourself, right? The statute was overhauled entirely in 2018 after the California legislature determined that it was antiquated, having been passed during an era of discrimination toward those afflicted with HIV. The current statute bears little to no resemblance to the repealed 2015 version, least of all because it now requires a showing of a specific intent to transmit the disease. Oh, she might got them. Now, I remember her arguing this before, so I don't know how it came back. Although repealed, the government proposed a jury instruction that reflected the elements of the statute in effect in 2015, apparently recognizing that the 2015 statute was unconstitutionally vague. The government included elements in its jury instruction that were not included in the statute as written by the California legislature. Thus, the government not only charged defendant with a repealed statute, but wrote it in clear violation of various constitutional provisions, including the separations of power clause and principles of comity. Principles of comity. Defendant's jury was instructed pursuant to a statute that never existed. A California court has no authority to rewrite a California statute, and neither did a district court sitting in New York. Even if the government had the authority to charge defendant under the 2015 version of Section 120-290 of the California Health and Safety Code, the statute did not pass constitutional muster. Most obviously, the statute is void of vagueness both on its face and as applied to the defendant because it simply did not give a person of ordinary intelligence a reasonable opportunity to know what is prohibited, nor did it provide explicit standards to those who apply the statute. Hey, I got to admit, this area where she is tearing down these herpes and shit, this ain't bad. This ain't bad. I got to tell you that. I'm going to tell you anyway. But this ain't bad. Where was I? Okay. The statute also lends itself to arbitrary and discriminatory application. Again, the defendant appears to be the first person in California's history to be charged under this statute where the alleged victim was not actually infected with the disease during the conduct that occurred in California. So remember, I remember. So when I told you, when she just stopped there, said the person did not get herpes, and then she says, here she completed the thought, right? She says, the alleged victim was not actually infected with the disease during the conduct that occurred. Okay. Well, wait a minute. She may be talking about Azrael at this time, but when she said it before, she was talking about Faith. So erase that, take that back. I'm not sure exactly who she's talking about because I don't know where Faith was allegedly affected at. So, as written, the 2015 law failed to provide adequate definitions about what diseases the statute meant to address when it criminalized willful exposure of all allegedly communicable diseases, including those not sexually transmitted. The statute is silent on what is meant by willful exposure and makes no mention of whether the defendant could willfully expose someone to a disease without possessing the knowledge of his ability to transmit the disease or without even knowing he or she had the disease. I remember I had this I came up with this defense a while ago when we first read it, and I was kind of doing the defense side. I remember this. Because if he don't know, y'all remember me saying that? I ain't running with y'all. Like, if he don't know he got it, how can he say, how can he honestly know he's transmitted? Indeed, it seemed likely that the California legislature repealed this statute in part because of its constitutional vagueness. Just by way of example, this statute would criminalize passing along cold sores. Nearly 50% of the population have herpes simplex 1, a communicable disease. Under the 2015 statute, anyone with herpes simplex 1, also known as cold sores, who kisses another person would be guilty of a misdemeanor even if the afflicted person had no active infection, outbreak, and did not pass the disease along to the recipient of the kiss. Under this statute, parents with herpes simplex 1, again 50% of the population, would be prohibited from kissing their children. One cannot imagine how many arbitrary prosecutions could take place in this current era of a pandemic if this law was in effect today. The examples of how this statute could be misused for arbitrary and discriminatory purposes. In its order, the government faults defendants through his trial counsel for failing to challenge the indictment or the constitutionality of the statute early. Remember, this was supposed to be on a Rule 12B. The reason is simply, trial counsel had no idea that the government intended to charge the defendant pursuant to a repealed and inoperative statute. Although the indictment cites the statute and notes effective 1998, this language did put defendant on notice that the government intended to charge him pursuant to the repealed version of the statute. Indeed, the first time trial counsel recognized the issue was prior to the finalization of the jury instructions, when he objected to the government's proposed instruction that did not track the language of the current statute. That's that motion that the brothers Johnsons put in. Contrary to the district court's view, the government cite to the California statute with the words effective 1998 did not alert the defense of an intent to charge a repeal statute. Indeed, it was entirely reasonable to assume that the government would not be charging a repeal statute that was clearly unconstitutional, as the California legislator understands, but EDNY does not. Defendant has shown good cause for failing to raise the issue earlier. In sum, the Racketeering Act premised on a violation of this repealed and otherwise unconstitutional statute cannot stand. The government failed to prove defendant guilty of forced labor of Geronda and Faith based on an isolated sex act that neither victim alleged was forced. The government alleged that defendant committed the crimes of forced labor when he directed Geronda and Faith to perform an act of oral sex on him on January 23rd, 2010 and January 13th, 2018, respectively. Where neither Geronda nor Faith characterized the isolated sex as forced, no rational juror could conclude that defendant knowingly obtained or agreed to obtain any labor or services from them. These charges are yet another example of the government's transparent effort to stretch a statute far beyond its intended purpose to reach conduct that can no longer be reached by state authorities. A conviction of forced labor under 18 U.S.C. Section 1589 requires the government to prove beyond a reasonable doubt that 1. The defendant obtained the labor or services of another person, 2. Through inter alia, threats of serious harm, and the defendant acted knowingly. There's a case law there. EDNY 2007. The statute does not define labor or services, but is given its ordinary meaning, i.e., labor means the expenditure of physical or mental effort, especially when fatiguing, difficult, or compulsory, while service is defined as the performance of work commanded or paid for by another. Additionally, the government must establish a causal link between the labor and services provided by the person and the threat of serious harm. Section 1589 is intended to address serious trafficking or cases where traffickers threaten harm to third persons to restrain their victims without physical violence or injury or threaten dire consequences by means other than overt violence. The harm or threats of harm considered from the vantage point of a reasonable person in the place of the victim must be sufficiently serious to compel that person to remain in her condition of servitude when she otherwise would have left. According to the government, on January 2010, defendant violated the forced labor statute by using threats of violence to obtain labor and active oral sex from Geronda. Accepting the government's evidence in its best light, Geronda described an isolated incident in which the defendant assaulted her because he was angry that she disrespected him. Geronda testified that after the assault, she sat down with the defendant in the VIP room and he instructed her to perform oral sex on him. Geronda complied. Geronda did not testify that the defendant threatened her, forced her, or even demanded that she give him oral sex. Geronda did not claim that she feared the defendant would assault her again if she declined the request. Geronda did not even testify that she did not want to provide defendant oral sex. After the incident, Geronda left defendant's home of her own free will. Accepting Geronda's account as true, it simply does not establish an act of forced labor. An isolated act of oral sex does not qualify as labor or services where there is no commercial aspect to the incident and the victims never testified that they were expecting any type of benefit from the act. Moreover, the record does not show that Geronda gave oral sex to the defendant out of fear or threats of violence, notwithstanding the prior assaultive behavior. It would not have taken much for Geronda to make the causal link between the act of oral sex and her fear of physical assault by the defendant, but she simply didn't. The jury was not free to jump such conclusion in the absence of Geronda's testimony, particularly where this event was an isolated one. Similarly, no rational jury could conclude based on the evidence adduced at trial that defendant knowingly obtained or agreed to obtain any labor or services from Faith on January 13, 2018, who testified that she traveled to Los Angeles to see the defendant with whom she had been having a romantic relationship. She described an incident where she and the defendant were in a small room in his hotel. So it could have been Faith she was talking about, because this is Los Angeles. So it could have been Faith about this herpes thing that I said take back, because I didn't know if it was Faith or Azrael. Faith claimed there was a gun in the room that made her intimidated, but conceded that defendant never threatened her with it or made any gestures that he intended to use it. Faith was simply uncomfortable by its presence. After an intense conversation during which Faith described defendant as being serious but not threatening, defendant directed her to give him in oral sex. Okay, she must have been to give him oral sex and grabbed her neck before placing his penis inside her mouth. Without objection, Faith provided oral sex to defendant, although she testified that she did not want to. Faith herself refuses to identify as someone who was forced to do anything. On cross-examination, Faith admitted that she was not a victim and had made a choice to be with the defendant. Question: in one of the podcasts we spoke about this morning, the paper route. On what show did you say? On that show, you said that during that interview, I don't like the word victim because I don't feel like I'm a victim. I'm a young woman. And let's be clear, I made a choice to be involved with that person. Do I feel like everything he did was right? Hell no. But I had a choice. And that's why I walked away. I did not move in with him. I did not live with him. I did not take any money from him. There is a choice that you have to make. You said that. Correct. You made a choice. Correct. And you're not a victim. Correct. The forced labor statute was not enacted to remedy isolated occurrences like the one described by Faith. Indeed, it is not even clear from Faith's testimony that she communicated to the defense that she did not want to give him oral sex. She certainly did not end her relationship with the defendant after this episode. The record fails to reflect a usual link between the isolated act of oral sex and any threat of physical violence. Absent clear expression of congressional intent, courts should resist the urge to transform the forced labor statute to cover the circumstances alleged in Racketeering Act 6, which bear virtually no resemblance to those paradigmatic forced labor cases and their victims. Fifth Circuit 2014 describing prostitution, forced sweatshop work, and forced domestic service as paradigmatic forced labor cases. Geronda and Faith each described an isolated sex act with the defendant. They knew now defendant that they now view as assaultive. The district court contends that the jury was free to see these specific incidences as forced labor in light of other evidence it heard about the defendant's conduct toward other women. But the government was not free to bootstrap testimony from other alleged victims to bolster their forced labor theories as to verify specific acts charged in the indictment. Geronda and Faith were not living in a condition of servitude through threats of physical force. They each described a discrete act that at best might have been charged as some type of sexual assault, and even that seems unlikely. To construe these events as of forced labor would render the purpose of the statute meaningless and afford the federal government free rein to charge any sex act accompanied by harsh or unkind words as forced labor. Yeah, she is getting down on this part right here. Defendant was denied a fair and impartial jury, where several of the seated jurors admitted that they prejudged the defendant's guilt, and trial counsel provided ineffective assistance of counsel when he failed to move to disqualify patently unqualified jurors. As United States Supreme Court Justice Black stated in regarding Michael 326 U.S. 224 228 in 1945, it's difficult to conceive of a more effective obstruction to the judicial process than a juror who has prejudged the case. That is because due process means a jury capable and willing to decide the case solely on the evidence before it, and a trial court ever watchful to prevent prejudicial occurrences and to determine the effect of such occurrences when they happen. Let's see, there's a case law in 1961. The United States Supreme Court observed the right to a jury trial guarantees to the criminal accused a fair trial by a panel of impartial and indifferent jurors. This is true regardless of the heinous of the crime charged, the apparent guilty of the offender, or the station in life which he occupied. A juror who has formed an opinion cannot be impartial. In this case, the record shows that at a minimum, 4 of the seated jurors, jurors 3, 4, 5, and 12, were not qualified to serve. There were several other seated jurors who likely should have been struck for cause, but trial counsel failed to conduct any meaningful voir dire during these of these jurors to determine whether they could put aside their expressed biases and prejudices. Trial counsel's performance was objectively unreasonable when he failed to move to disqualify and patently unqualified jurors and failed to conduct any meaningful voir dire of prospective jurors who expressed their prejudgment of the case. Defendant was prejudiced by his counsel's substandard performance, where it resulted in the seating of at least 4 seated jurors who were actually biased and could not act with impartiality. Because of extraordinary pretrial publicity, the district court directed the parties to jointly prepare a juror questionnaire to probe an area of prospective jurors' exposure to pretrial publicity. The court invited the parties to review the questionnaires in advance of jury selection and determine whether they could agree that certain individuals should be excluded for cause. After completing that process, the parties were left with a set of potential jurors for oral voir dire procedures. The court gave both sides the opportunity to pose additional questions to prospective jurors. Inexplicably, defendant counsel failed to challenge several jurors who ultimately sat on defendant's jury, who was plainly incapable of serving as fair and impartial jurors. Now, if I believe when she did this in her post-conviction motion, I thought they had sub-questions, and they got down to the final question, which, even though given whatever you know about the defendant, I'm just paraphrasing, can you be impartial and be a non-biased juror? Okay, juror number 4 revealed in the questionnaire, question 39, to charge in this case involves allegations regarding exposure to one or more sexually transmitted diseases. Is there anything about such an allegation that you believe would affect your ability to serve as a fair and impartial juror? Answer: yes. I find transmission of STDs in a non-consensual act to be particularly repulsive. They said yes. Question 79. Which publicly known person do you least admire? Jeffrey Epstein. Okay. Okay. Well, unless they got some more to go up under that, she got a good point. Unless they was asking more questions, right? Because you make your decision based on how they answer the pool of questions, but in the end, if you answer that you can be impartial, they feel that you can, that you would show no bias, you can be allowed to be seated. Although the court generally asks this juror whether anything he or she has read would affect his or her ability to be fair and impartial. Damn, I just said that. In the case, and the juror replied, "Not that I know of." The defense counsel failed to ask the court to question the juror whether his feelings of repulsion about the transmission of STD in a non-consensual scenario would interfere with his and her ability to serve as a fair and impartial juror. Okay, that's a nice catch right there. Go on, Jaybo. Did she catch that before? I don't remember reading that, but she probably did. A juror who expressly admitted that his or her feelings about non-consensual transmission of STD would affect his ability to fair and impartial should have been struck for cause out of the gate. Let me see what this is. I am when I get finished. Hold on. Let me come right in and check on y'all. Well, let me get finished reading. Hold on. Inexplicably, the juror was not challenged or even questioned about his repulsion for the precise act for which the defendant was charged. That this same juror named Jeffrey Epstein, an accused pedophile, as the person he least admires, is yet further support that juror number 4 was not a juror who could serve with impartiality. Oh, child, she make a good point. Oh, dang. Juror number 5 disclosed the following in his or her questionnaire. Question 31. Have you watched or heard any interviews of Robert Kelly or any TV shows featuring him or any specials or documentaries about him? Yes. What were your general impressions? He loves underage girls. From what you have seen or heard, do you have a general impression of the defendant? Somewhat negative. Why do you feel that way? The allegation that related he was sleeping with underage minors. Oh, she got a point. Although the court asked the prospective juror general questions about his ability to put aside other things she might have heard. So right there, she's kind of, I don't want to say covering her ass, but no, I'm not. I'm trying to read. What she have heard, asked juror could it be fair. The juror indicated that she would give it a shot. Okay, hold on for a minute, y'all. Give me 1 minute. All right, sorry about that. Okay. Okay, although the court asked the prospective juror general questions about her ability to put aside other things she might have heard, when asked if she could be fair, the juror indicated that she would give it a shot. The court reminded the juror that she had to be certain that she would consider only evidence offered at trial, and the juror begrudgingly acquiesced. Even the district court expressed concern about juror number 5 ability to serve. Observing, so I don't know about you, but when someone says they think they can do something in this context, I don't think that's an unqualified assurance. And I don't know what the party's position is on that. I think I pushed her pretty hard on it, and we will still end when we still ended up with I think so. Let me hear from the government. If you have a position on that, not surprisingly, the government was confident that the juror could be fair. The court still expressed doubts. Inexplicably, trial counsel agreed with the government and the juror was seated. Trial counsel's performance was objectively unreasonable where he agreed to the seating of juror number 5, who not only watched Surviving R. Kelly but concluded that the defendant loves underage girls. There can be no trial strategy for failing to excuse this juror for a cause. Had trial counsel challenged this juror, the court would have undeniably struck her for cause. Trial counsel not only failed to move to disqualify the juror, he did not even ask the court to probe more deeply into the juror's statement on the questionnaire, the defendant loves underage girls, or her statement that she had negative feelings about the defendant because of allegations that he engaged in sex with minors. Okay, you see where now this is she's raising these type of questions based on constitutionality, right? Was this constitutional? Now, this is going to have a little bit more weight when it comes to deciding whether or not he could have had a fair trial or not. This is a little different than when they're talking about was the evidence sufficient enough, to to be delivered to the jury for them to make a decision. You're talking about somebody's constitutional rights, their due process. This is a little different. The weight is a little more, okay? I'm just saying. Okay, it says, juror number 3 provide the following information in the questionnaire. Question 29. The case for which you are summoned involved the defendant, Robert Sylvester Kelly, also known as R. Kelly. Have you read, seen, or heard anything about the case, alleged crimes, or people involved? I watched a documentary, but I forgot the name of it. Have you read, seen, or heard about Robert Kelly, also known as R. Kelly? Yes, the entertainer. I heard that he's been sleeping with underage girls. Have you watched or heard any interviews of Robert Kelly or any TV shows featuring him or any specials or documentaries about him? Yes. What were your general impressions? I saw a documentary about him and his legal troubles. I don't know the full story, so I have no feelings and remain impartial. Trial counsel did not ask the court to question the juror further about his responses to these questions or to determine whether the juror could truly serve as impartial and unbiased juror in light of having watched the salacious and highly prejudicial docuseries. Not a single question was asked of the juror about his impressions of the documentary, nor did the counsel ask the court to inquire about what information he learned about defendant prior's legal issues on reputation for sleeping with underage girls. Juror number 12 offered several alarming answers in response to the questionnaire that justified disqualifications. Question 29. Have you read or seen or heard anything about the case. The alleged crimes or people involved. Yes. Describe in detail what you recall reading, seeing, or hearing about, etc. Question. Sex with minors. Specific details do not come to mind. Parodies on TV regarding details of defendant's personal life. SNL Dave Chappelle was in jail prior, then released. Question 32. From what you have seen, read, or heard, do you have a general impression of the defendant? Somewhat negative. Why? I really never cared one way or the other regarding the defendant. The somewhat negative impression is an emotion, one impacted by the nature of the charges against him. The jury was asked about her ability to be fair, and the court obtained assurances from the juror that he or she could, but trial counsel did not bother to ask the court to inquire about the juror's reference to defendant personal life, sex with minors, or Dave Chappelle's SNL skit, which referenced prior allegations about defendants of videotaping a sexual encounter that depicted him urinating on a minor, a crime for which he was prosecuted. It is beyond comprehension that trial counsel would not have moved to strike this juror who had seen damning pretrial publicity, known or thought defendant had already been in jail for these offenses, and felt emotional by nature of the charges against him. The record reveals that these jurors, 3, 4, 5, and 12, were not capable of deciding the case solely on the evidence before it or acting with impartiality. Beyond these 4 jurors, at least 4 other jurors likely were incapable of acting as indifferent, far, and impartial triers of the fact. And triers of the fact, in this case, is the juror. Trial of the fact can also be the judge. So it says, however, the defense counsel did virtually nothing to probe the attitudes of these prospective jurors. I mean, it kind of seemed like the defense counsel was setting you up for a pretty good appeal. Juror number 7, 8, 9, and 11 all revealed that they had heard about the case and that alleged crimes and expressed knowledge about defendants' prior issues with the law. Without exception, trial counsel failed to probe what precisely the prospective jurors had heard or conduct a meaningful inquiry into whether they could be fair given what they heard or seen. An attorney cannot make an intelligent decision about whether to challenge a potential juror for cause or whether to exercise defendant's preemptory challenges without properly questioning potential jurors to learn of potential biases. There's a bunch of case law. It says 1895 holding that an adequate voir dire is essential to ensure that prospective jurors will be free of bias or prejudice and will perform their duties impartially. Holding that voir dire plays a critical function in assuring the criminal defendant that his Sixth Amendment right to an impartial juror will be honored. Sixth Circuit of 1978 holding the primary purpose of voir dire is to make possible the impaneling of an impartial jury through questions that permit the intelligent exercise of challenges by counsel. Under the standard promulgated by Strickland Supra, trial counsel failed to provide ineffective assistance of counsel to defendant when he failed to move to strike unqualified jurors 3, 4, 5, and 12, and overall failed to conduct a reasonable voir dire to probe the stated biases of several other seated jurors. To prove a successful claim for ineffective assistance of counsel, defendant must demonstrate that 1, counsel's reputation fell below an objective standard of reasonableness, and 2, there is a reasonable probability that, but for the counsel's unprofessional errors, the result of proceeding would have been different. Tell me why. There is a reasonable probability that for the counsel's unprofessional errors, the result of proceeding would have been different. Now, that's that's questionable, okay? Because the Supreme Court not recently, but recently enough, stated that a lawyer doesn't have to overperform or perform exceptionally well or whatever. They could just have to perform reasonably well. Okay. So I don't know if this is enough, but so all of that is gonna, the whole thing is gonna be a factor whether or not it was prejudicial enough, whether or not it was ineffective assistance of counsel. All of that is going to, you know, weigh in. Okay, let me see. But okay, okay. In this context, the prejudice prong of Strickland is satisfied by showing that the juror was actually biased. And it says define an actual bias as bias in fact or the existence of a state of mind that leads to an inference that a person will not act with entire impartiality. Now, here's the thing about this section, whatever. Judge, and this was all in Bonjean's acquittal and new trial. And the judge gave a very detailed opinion of her rulings, right? So, this is a toss. This is a toss up. Probably nodded more in the direction of who is that? More in the direction of the prosecution, but anything can anything can happen. Defendant has satisfied both prongs of Strickland analysis. As set out above, juror 3, 4, 5, 12 expressed views that led to the inference, indeed, the certainty that they would not and could not act with entire impartiality. Trial counsel failure to move to disqualify them was substandard. Hey, tell me who that was, because I don't know who that is. Apart from their own words, that two of those seated jurors had seen Surviving R. Kelly is evidence of bias in fact, where no human being could act as a fair and impartial juror after seeing a docuseries that painted defendant as a serial predator. The docuseries was 11 episodes and consisted mostly of interviews with alleged victims who graphically detailed their claims of sexual abuse. Some of the information communicated in the docuseries was presented at defendant's trial, but much of it was not, meaning that at least two jurors had highly prejudicial information untested by the adversarial process to consider in addition to what was presented at trial. The docuseries highlighted the stories of scores of women who claimed to have been victims of sexual abuse and offered no countervailing viewpoint. A large part of the documentary detailed defendant's prior criminal case that involved allegations of sexual abuse of a 14-year-old, which included allegations that he videotaped himself urinating on the 14-year-old and which was the subject of the Northern District of Illinois prosecution. It is nothing short of mind-blowing that defense counsel acquiesced to the seating of jurors who came to the case with this highly prejudicial information that no human being could have put aside. Let me come and check on the time because I don't. Oh, okay, I got enough time. For his part, defendant explains that he was effectively absent throughout the voir dire process, even though jury selection is a critical stage of the trial at which defendant had every right to participate. So she put that in there because they can come back and say, or maybe they've already come back and say, he was there and he was involved in the choosing of the jury selection process, which is voir dire, okay? In a sworn declaration attached to post-trial motions, defendant explained that he played no role in picking his jury. Damn, if I would have just scrolled up, I would have read it. He had no access to the questionnaires, which he could not read in any event. He did not participate in any sidebars where prospective jurors were questioned and did not consent to any juror who had seen inflammatory docuseries. Defendant had the constitutional right to be present and participate throughout his voir dire process. His declaration demonstrates that he was a spectator as his attorneys picked a jury without his input, including individuals who should have been struck for cause. Because defendant's jury was comprised of several jurors who could not discharge their constitutional duty to be fair and impartial, defendant did not have a chance at defending against the charges. Defendant was denied his constitutional guarantee of a fair and impartial jury and the Sixth Amendment guarantee of effective assistance of counsel when his attorney failed to move to strike jurors number 3, 4, 5, and 12, or otherwise conduct any meaningful voir dire of the remaining jurors. Defendant was denied a fair trial where the government swamped the jury with excessive other bad act evidence, including testimony from 7 additional witnesses who detailed defendant's unusual and graphic sexual activities, his history of transmitting herpes to his sex partners, his abusive conduct towards his girlfriends, and even audio and video recordings of this conduct with women and men, some of whom never testified. So she is creating a great case for this jury was overwhelmingly prejudiced by all this other activity, by the jury, by not this bad act evidence and all that other shit. Okay, with virtually no limitation, the district court permitted the prosecution to inundate the jury with excessive bad act evidence, mostly under the theory that the evidence was relevant to the means and method of the enterprise. The means and method justification of the introduction of copious amounts of bad act evidence is gravely flawed because the government theory of an enterprise is flawed. Whether the enterprise consisted of nothing more than the purported sexual misbehavior of the defendant, unconnected to the activities of a discrete enterprise, the means and methods of an enterprise cannot justify the admission of copious amounts of bad act evidence. As argued supra, the government failed to prove a Rico enterprise. No matter how much repellent evidence of sexual indiscretions or abusive behavior the government accumulated against the defendant, the fact remains that it was the defendant, and the defendant alone, who engaged in those affairs, wholly disconnected to the affairs of a distinct enterprise. Okay, so she's going back to make the point that the defendant was both the Rico person and the Rico enterprise. That's actually how you say it. The Rico person, the Rico enterprise. But I'll be trying to simplify it for y'all so it can make sense. But so she's trying to say they were one and the same, and to prove the elements of Rico, they cannot be the same. They got to be two separate entities, at least two separate. It says unwitting assistance of underlings who carried bags, picked up defendant's prescriptions, and drove defendant female guests from one location to another is not proof of an enterprise. By characterizing defendant's purported decades-long history of abusive conduct toward women as an enterprise, the government not only avoided statutes of limitations but was free to introduce any unkind or abusive act of a sexual or non-sexual nature as evidence of the enterprise, conveniently avoiding the rule against the admission of propensity evidence. Notwithstanding, the district court still obligated to conduct a meaningful Rule 403 analysis, which it failed to do. Rule 403 authorizes, so I told you she's going to hit at the judge, right? And, she is. Rule 403 authorizes the exclusion of relevant evidence when its probative value is substantially outweighed by the danger of unfair prejudice as to criminal defendant. Unfair prejudice, confusion of the issue, or misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. The United States Supreme Court held in Old Chief that unfair prejudice as to a criminal defendant speaks to the capacity of some conceitedly relevant evidence to lure the fact finder into declaration of guilt on a ground different from proof specific to the offenses charged. Old Chief versus United States. Okay, the committee notes to Rule 403 explain unfair prejudice within its context means an undue tendency to suggest decision on an improper basis, commonly through not necessarily an emotional one. And it says the notes on the Federal Rules of Evidence. Okay, courts that have followed common law tradition almost unanimously have come to disallow resort by the prosecution to any kind of evidence of a defendant's evil character to establish a probability of his guilt. Not that the law invests in the defendant with a presumption of good character, but it simply closes the whole matter of character, disposition, and reputation on the prosecution case in chief. The state may not show defendants prior trouble with the law, specific criminal acts, or ill name among his neighbors, even though such facts might logically be persuasive that he is by propensity is probable perpetrator of the crime. The inquiry is not rejected because character is irrelevant. On the contrary, it is said to weigh too much crime with the jury and to so overpersuade them as to prejudge one with a bad general record and deny him a fair opportunity to defend against a particular charge. The overriding policy of excluding such evidence, despite its admitted probative value, is the practical experience that its disallowance tends to prevent confusion of issues, unfair surprise, and undue prejudice. Probative value is also informed by the availability of alternative means to present similar evidence. Specifically, the Supreme Court has advised that the Rule 403 probative value of an item of evidence may be calculated by comparing evidentiary alternatives. And the probative value is pretty much evidence used to prove something, right? The elements or the facts in the case. The district court is afforded wide discretion to exclude evidence that is on balance unduly prejudicial, so long as the district court has conscientiously balance the proffered evidence, probative value with the risk of prejudice, its conclusion will be disturbed only if it is arbitrary or irrational. Getting together. As set out below, this court did not conscientiously balance the probative value of certain proffered government evidence that carried an extraordinary risk of prejudice. Excessive STD evidence. The government charged the defendant with committing several racketeering acts based on his transportation of Jane and Faith to California and New York with an intent to expose them to herpes in violation of local public health laws. The district court repeatedly noted that under its interpretation of the statute, the government was not required to show that defendant transmitted herpes to Jane and Faith. Mere exposure was sufficient. Even if the district court was correct, there was little justification for allowing massive amounts of evidence that defendant purportedly spent decades receiving and transmitting sexually transmitted diseases. Oh, that's a good hit right there. That's a good comeback right there. Through defendant's personal physician, Dr. McGrath, the government presented evidence of defendant's entire medical history concerning the contraction of sexually transmitted disease dating back to the 1990s, including his prior diagnosis with such sexually transmitted diseases as gonorrhea and chlamydia. So she's probably talking about that should have been enough evidence instead of all this extra shit that the prosecutors introduced, right? Let's see what she says. Dr. McGrath further testified at length about this treatment of defendant for herpes. In addition to Dr. McGrath's testimony, the prosecution elicited testimony from every person who testified about sexual contact with the defendant, about whether defendant disclosed his herpes diagnosis with them. The prosecution also presented testimony from 3 additional witnesses, Geronda, Kate, and Anna, that defendant infected the women with herpes, eliciting descriptions of herpes infection symptoms. And if that wasn't enough, the prosecution offered extensive documentary evidence regarding defendant herpes treatment and elicit graphic details from multiple witnesses about the symptoms of herpes. The prosecutors uttered the word herpes hundreds of times throughout this trial. There was no legitimate basis to bombard the jury with excessive evidence. See what I said? This is where she was going. About the defendant's herpes diagnosis or the fact that he had allegedly transmitted disease to a number of different women. The only issue in dispute related to the defendant's herpes diagnosis was 1, whether he had herpes in 2015 and 2018 when he had sexual relations with Jane and Faith. 2, whether he knew he had herpes, and 3, whether he disclosed it to the women before he had intercourse. Ooh, that's a good motherfucking strike at the elements, because she just incorporated the elements and what they just basically had to prove on, right? And she's saying that's all, and they did enough with the testimony, with his history, with the bad trucks, with saying the herpes 100 times, and all of this excessive bad act evidence was not needed. Ooh, how would they answer that? Because she's forcing them to answer, was it needed or not? You know what I'm saying? Was that extra stuff needed to get a guilty conviction, or was just what they had to prove. Was that enough, right? That's pretty good. Go on, Jaybo. Dr. McGrath testified unequivocally that as of 2015, defendant was diagnosed with herpes and was being treated for herpes. Both women testified that they had unprotected sex with defendant and that defendant did not disclose that he suffered from herpes. This evidence went unrefuted. Accordingly, any additional evidence related to defendant's herpes diagnosis and transmission of herpes to other women was unnecessary. I just said that. Cumulative and unduly prejudicial. B. Evidence concerning sexual relations with Aaliyah. The prosecution charged defendant with one racketeering act of bribery for the sole purpose of getting evidence before the jury about his marriage and relationship with Aaliyah. I said that a long time ago. Over defense counsel's objection, this court permitted the prosecution to introduce testimony from Angela, Jada number 7, that she allegedly observed sexual interactions between defendant and Aaliyah in 1992 on defendant's tour bus. This court erred by allowing this highly prejudicial testimony into evidence after initially denying the government's request. Angela's testimony was not relevant under the means and methods theory since it purportedly occurred pre-enterprise, which the district court concedes in its order. Instead, the district court defended the ruling on the grounds that the evidence was necessary to show defendant's motive for bribery, particularly since defendant would not confess to having sex with Aaliyah. Whether the defendant had a motive for committing bribery did not justify putting this inflammatory evidence before the jury. Okay, well, I think Judge Ann won on that, because unless you can say it didn't even need to be included, period, if you go that route, because there's enough still not to even have to go back to 1994 to withstand the Rico, based on the two predicate in 10 years. Okay. So even if the government believed that it needed to present some evidence of motive, it did through the testimony of Demetrius Smith, who assisted in obtaining a false identification card for Aaliyah so she could marry the defendant. Testified that in 1994, the defendant told him that Aaliyah was in trouble and thought she was pregnant. Smith further testified that the decision to marry Aaliyah was made so that the defendant could avoid legal issues. The government had plenty of motive evidence to present and had no need for the widely prejudicial testimony of Angela that was not corroborated by anyone. As such, it was error to allow Angela to testify about her alleged observation on the bus in 1992. So again, it wasn't needed. Testimony from Addie, Alex, Kate, Anna, Angela, Lewis, and Alexis. The court permitted the government to present a whopping 7 additional witnesses to testify about graphic, uncharged bad act evidence concerning dozens of sexual encounters with the defendant. In this order, the district court set out a detailed accounting of the testimony of Addie, Alexis, Kate, Anna, Angela, Lewis, and Alex. Apart from Angela's testimony, which concerned sexual conduct pre-enterprise, the prosecution defended the introduction of this evidence under the catch-all means and method of enterprise theory. As argued above, where the defendant and the defendant alone was the enterprise, the means and method justification for the introduction of copious amounts of bad act evidence is simply a free pass at introducing unlimited bad act evidence related to defendant's alleged sexual misdeeds and abusive conduct. This circular logic returns us to the overreaching defect in this prosecution, namely that it was a prosecution of defendant's bad character and unpunished sexual misdeeds, it had nothing to do with punishing or preventing the conduct of an enterprise. I ain't got that much to go, people. The district court suggests that Addie's testimony about her sexual acts with the defendant was probative of the enterprise, but fails to explain how or why. Addie testified that when she was 17 years, she went one of defendants. Okay, she must be meant she went to she went one of defendant's concerts. Defendant announced from the stage that only women over 18 could go backstage, and she did not go backstage because she had no identification. According to Addie, two bouncers asked them if they wanted to get defendant's autograph, but did not ask their age before bringing them backstage to defendant's dressing room. According to Addie, defendant provided her autograph and engaged her and her friend in sexual activity. Indeed, the way Addie tells it, defendant forcibly assaulted her in the dressing room. No one was present for the sexual activity other than defendant and her friend. This testimony added nothing to the government's theory of an enterprise, particularly where it is unclear that the mysterious bouncers even worked for the defendant. And Addie admitted that they would have had no idea she was 17 years old rather than 18. Indeed, all the other bad act testimony came from Alexis, Angela Lewis, and Alex was designed to put before the jury evidence of defendant's propensity to engage in prohibited sexual activities with minors. It shed no light on the existence of an enterprise, while there was some vague testimony that nameless bouncers or associates invited young women backstage or passed along defendant's phone number. There was no testimony that these nameless individuals had any knowledge that these young people were minors rather than 18 years old. If an enterprise is formed simply because members of a rock star or rapper's entourage invite teenagers backstage to meet an artist, the government should be overloaded with Rico prosecutions against recording artists. That a bouncer allows a 17-year-old backstage after a R&B concert is not evidence. He or she is recruiting minors for the defendant's illegal sexual conduct. Through these other bad act witnesses, the jury was inundated with one jarring story after the next of unconventional graphic sex acts, including sexual conduct with many, perhaps most, were considered deviant. The government presented detailed testimony about defendant's sexual activities with men, group sex, and even illicit testimony from Anna about defendant's penchant for sex involving corpophilia, which she described as demeaning and humiliating. When considering this massive prior bad act evidence cumulatively, its probative value is diminished exponentially as compared to its prejudicial effect. There can be little doubt that defendant's jury was inclined to rectify past injustice by punishing defendant even if it harbored doubt about his guilt on the charged offenses. The risk of prejudice and confusion was particularly acute when the trial divulged into a live rendition of surviving R. Kelly docuseries, replete with reviewings of sexually explicit videos. Omission of graphic videos and audio recordings. If days upon days of testimony of other bad act witnesses was not enough, the government was further permitted to introduce private videos of graphic sex acts, some of which had BDSM elements. Government Exhibits 341 through 343. were group sex acts between Alex, Dominique, and the defendant, which reflected nothing but group sex involving two men and a woman who did not even testify. The district court barely defends the introduction of these videos for a legitimate non-propensity purpose. Government Exhibit 328A is a lengthy video of defendant spanking Anna, who was naked and crying, walking back and forth, calling herself a slut and stupid while defendant looked on. This video was offered for no other purpose than to show defendant's sexual perversions and mistreatment of Anna. It shed no light on whether an enterprise existed and had no bearing on the charged offenses. Lastly, and most problematic, the government admitted a video of Anna spreading feces on her naked body and calling the defendant daddy, although defendant was not depicted in the video. This video, like the others, added nothing to the equation as it relates to proving an enterprise and did not breed contempt and prejudice for the defendant. Defendant was entitled to a fair trial on the charged offenses. Instead, with the district court's blessing, the prosecution put him on trial for a lifetime of bad behavior. Ooh, she coming at Donnelly. With a jury already biased against him, and the admission of a mountain of uncharged bad conduct, defendant was denied his guarantee of a fair trial. The district court's restitution award of Jane and Stephanie's herpes treatment was unsupported by the government's evidence. Okay, I shouldn't have to read that. That's just about the money. I ain't finna get no weeds about no goddamn money. Let me see. Yeah, if y'all want to read about the money, BOP to turn over the money. We already read about that. Okay. All right, conclusion. Okay, for the foregoing reason, defendant conviction must be reversed. Alternatively, defendant is entitled to a new trial. Separately, the restitution award must be vacated and the defendant's trust fund monies should be promptly returned to his own trust account. All right, now y'all can debate. I'll have to read that money part at a later date if y'all just want to talk about the money, but it's pure and simple. She want Mr. Kelly's money back. It's probably the argument is probably no that much different what she put in the motions about the money. And with that being said, the forum is open. The forum is open. The forum is open. You know. Hold on. Thank you so much. Oh, thank you, Karen. So, what y'all think? What do y'all think? My hands are sitting up here smelling like barbecue. You know I'm about to go crazy. I mean, she you can tell she is she specialized. There's one in appeals, but she really specializes when it comes to constitutional violations because she she worded that up just because it seemed like how she wrote that up. It can kind of mean like you have no choice but to at least grant him a new trial. You understand what I'm saying, y'all? I'm gonna wash my hands. If anybody ain't got nothing to say, I'm going on. Hold on. You know. Well, one thing I ain't see. Oh, you know what? I need to look at them those text messages because I want to know, is she quoting from net? Hold on. Is that my mail already open? No, that's not it. Them establish her argument with the Rico. I'll probably give that nod slightly to the the prosecution winning that. The jury, I don't know. The jury issued a bad X evidence. I don't know about that either. Let's see. Sometimes the how can I say this? The power is in how you word it, right? And all through you asking them to make an interpretation of it because I didn't see the only mandatory law that she really cited when she got down to the bad acts and the jury and all of that, right? But the rest of it, it was saturated with case law, right? And no doubt from the higher courts too, you know. I So sometimes it's in the beauty of how you wrote stuff. Because when you write it like she wrote it, it made it seem like all that evidence they submitted wasn't even necessary to establish the elements, right? Because she's right. I don't know if she said it this way, but she's right. The testimony from the victim witnesses kind of establish those elements and the facts in the case. The other people that they brought on, it didn't fill out the RICO because they weren't charged that, so it wasn't needed there. And she makes she didn't say that. She could have said that because they didn't. Go. She did say it wasn't that the evidence that was needed that the additional evidence wasn't used to prove and that the enterprise existed, and that the racketeering legal behavior went on exists through there. because one, they didn't even charge those acts and made them, plug them in, and that 30-year expansion they did with regards to that Rico, right? I mean, all they need is 10, but I'm just saying they went back all the way back to 1994. So that wasn't even used to substantiate the Rico. And she's saying it wasn't used to substantiate an enterprise, as she said the government claimed they used it for. So I'm not really sure. Yeah, it would. Hey, Linda Alexander. Hey, Classified Private. Shawty Cookie. Markin. Hey, Henny Hen. How long? It could take, it could take sometimes up to a year. So it really can. Yeah, Karen. She made some good arguments. Some real good arguments. I don't know what to tell you. You can't really um argue with this thing she brought up, especially with that jury, because and here's the thing, right? Where you kind of get in trouble. It could be. I mean, it's another way to look at it. They had a bunch of jurors, and I'm pretty sure out of the pools, they could have found 4 or 8. I don't know how many that she said they had problems with, but at least 4 we know that she mentioned by number to replace them that didn't have all of those, all of those question marks, right? And that's what I say. Let me go wash my hands real quick, and I'll come see. Then I'm come on. If not, then I'll shut it down. Well, okay. So, okay, I'm here. I just came back. Oh, thank you, Linda. Y'all so sweet. Oh, thank you, Henny. Y'all so sweet to me. I sure appreciate y'all. I like y'all. I'll make changes to my thing for y'all, cause y'all don't give me no problems, honey. And I'm happy. Happy. I'm happy. But mm, you know, but they will. They're gonna, give the judge. They're gonna give Judge Donnelly the benefit of the doubt. You know, they're gonna give her the benefit of the doubt, and they're gonna look at why. What was the reason why she allowed all that bad evidence? And all that other stuff, right? But I told y'all from what I was looked in her briefing, just what she had submitted through the appendix, and it kind of told me that Judge Donnelly gonna be on her list, constitutionality is gonna be on her list, stuff being unconstitutional, unfair to her client, and and pretty much the stuff that she raised in her brief. I see then she didn't mess with the Curcio situation. Oh, love you, Shawty. She didn't mess with the Curcio situation, which I can understand. Oh, thank you, Warrior. I do though. I like, I like this group. You know what I'm saying? I like y'all. Y'all make it easy. I don't have no problems. I don't get no crazy bitch text messages or some controlling idiot trying to tell me what doing on this channel. Any of that. You know what I'm saying? I don't get all that. Ooh, amen. Praise the Lord. But you see, there was no text messages. Of course, and I mean not text me, Lord. The BLP email situation that wasn't there. Wow, she couldn't have made an argument on it, what have you, but in her writing, where she did mention, what she mentioned something about what happened in Illinois. She didn't mention what was that she said about Illinois. Oh, she was talking about the videotape was prejudicial, about like asking the jurors about did they see the stuff about him back in the day about urinate on the girl and stuff like that. She could have, if she wanted to. I don't think it would have been too improper or out of line to, hey, and there's some other, and as part as making my client, the face of hashtag me too. My client's shit was leaked to people or whatever. Stuff like that, but she makes, but I guess she won't really want to stick to the facts in her argument, and maybe there wasn't a way to kind of tie that in or whatever. It could be actually be improper, but I don't know. I would have tried it since you're already talking about the Constitution. and hate Courtney Love. So are we all? But see, I know I didn't, but I'm just not gonna understand if somebody asks another question about why the parents wouldn't want to stand, why they couldn't get up there and talk, why nobody can get up there and talk about no scheme, extortion or not, and whatever, that I covered in the beginning of this video. I'm not going to understand additional questions because you got to take it from me. I took it right from the paperwork because I told y'all, I said, listen, if somebody say I'm wrong about it, whatever, not a problem. I'm going to supply you with black and white. What they said. If it just ain't there, it's just not there. I'm talking about on a legal. I mean, that's almost saying I could take anything I read and craft my own theory behind it. But if I don't have something to support it, especially if it's circumstantial, and she ain't gonna allow it anyway if it's too weak, if it ain't proven nothing, and you don't have nothing to prove it. Like, where are we? I'm not gonna understand this if y'all keep talking. I'm not gonna get it. I'm just because now I'm looking like, what the fuck is going on? We going back over this stuff that I thought we cleared up, but we'd be right back to now the questioner. Earlier somebody said that the parents could that she did allow the parents to be called to the stand, and I told you by their own documentation and by the judge ruling, that's not what it was, that they can be just called. You cannot put people on the stand just to give your general information or your general relationship or just talking about your relation to somebody or what you experience, if it wasn't to show like not propensity, right, but maybe a motive and intent and things of that nature. You can't show that somebody has propensity to do something because that bleeds over into character evidence, right? So we're not talking about that, but the evidence, and meaning testimony is evidence, has to be related to the conduct, the charged acts. I don't know how plain. I don't even know how to put it, unless you just, I don't know, because I gave you the document. I gave y'all the documents. You can take it and put it in sequence, and maybe it'll make sense that way. Well, see, Ken, you coming in talking about what I'm just trying to stop talking about. Or not trying to stop talking about. If we can get to the point where anybody tell me I understand why They couldn't get on the stand. Why this couldn't be used? Why this? Why that? Why that? Once you get somebody to tell me that, and just say you don't agree with it, then I can ride off in the sunset with you on that. But to still try to circumvent the process, I don't get it. You just think about it. If you can just put people on the stand that know you, that has some type of relation with you, when I say relation, I ain't talking about sexual, I'm talking about friend, business, sexual, I'm talking about know you, encountered you, or encountered you through the victim witness, hell, you can load it up. And I remember that reading about Miss the Rogers, why she testified. And I think we got into it. It was solely because of, I think that was that in Don's testimony? Was that in Don's transcript? No, we talking about her testifying with. Did she testify in New York? Can somebody tell me, did she testify in New York? What is that? Acting like I'm cutting the phone on the screen. Okay, right. It was because of the threat and the release of faith pictures. Right, but the mama bared witness to whatever had, the mama was with faith or something. Oh yeah, that's right. It had something to do with the threat. It was that part of the indictment. That's right. It had something to do with that threat, and the mama witnessed it or something. Oh, and I wish I had somebody to tell me what the number was. Yeah, she was with her. When the threat was made. Right. So she served as direct evidence. I'm trying to find it. Oh, I'm trying to find it. Oh, okay, wait a minute. There we go. And her name Kelly? Mm-hmm. Name is Kelly. All right. Name is Kelly. Let me see how many pages I got with Miss Kelly. What page is this? But they'll come back and say, well, read it again. We'll read it again. Okay, hold on. Kelly, Miss Rogers, 2395. Good afternoon. Where did you grow up? San Antonio. Is that where you live now? Yes. Are you employed? Yes. What kind of work do you do? Childcare business. Are you married? Yes. How long have you been married? 29 years. Wait, What, if anything, does your husband do? He works for Northside Independent School District. Is he an administrator there? Yes. Does he do anything else? He's a pastor. Do you have any children with your husband? Yes. How many do you have? 2. I'm showing you what is in evidence as Government's Exhibit 79. Is this your daughter? I'm so used to saying, I'm showing you what's in evidence marked as Government Exhibit 79. Is this your daughter, Faith? Yes. Without saying your last name, do you and Faith have the same last name? Yes. When was Faith born? 97. I want to direct your attention. Withdrawn. Are you familiar with a docuseries called Surviving R. Kelly? Yes. Did Faith appear in Surviving R. Kelly? Yes. I want to direct your attention to early December 2018. Did you travel to New York City at that time? Yes. Who, if anyone, did you travel with? Faith. What were you going to New York to do? Watch the premiere of Surviving R. Kelly. Did you stay at a hotel in Manhattan? Yes. Did you attend the premiere? Yes. At some point after you arrived at the premiere, were you evacuated? Yes. Where did you go after you evacuated? Back to the hotel. Showing you in the evidence as Government's Exhibit 80. Do you recognize this person? Yes. Have you met this person? Yes. Who is this person? Cash. Where did you first meet Cash? At the hotel. Was that after you were evacuated from the premiere? Yes. Where did you see her at? The hotel, in the downstairs lobby. What, if any, conversation did you have with her at that time? She, as I was coming out of the elevator, she said hello. Objection overruled. I would remind you not to use your last name. Go ahead. She said, hello, Kelly. When she said it to you, did she say Mrs. and your last name? Yes. You can go ahead. Yes, I looked over to my right at her and asked her who she was, and she proceeded to tell me that she was Cash. Did she tell you anything else at this time? No. Did you see Cash again at some point? Yes. Where did you see Cash again? At the Applebee's. Was that same night? Yes. Who, if anyone, did you go to the Applebee's with that night? Faith. And anyone else? Yes. Who, Summer? Was that a friend of Faith's? Yes. When you got to the Applebee's, was Cash there? Yes. Was she with anyone else? Yes. Do you recall that she was with? Do you recall that I don't know why I said like that. A gentleman and another female. What, if anything, did you notice about the man with her? He was in the corner to my left, stand up against the wall, and he was in a suit. He proceeded to move his jacket over where I could see that he had a gun. You were at a table at this point? I was headed to the table. Did you eventually get to a table? Yes. Did you meet with Cash? Yes. What happened? What, if anything, do you recall Cash doing or saying at this table? She proceeded to tell Faith that she had a file, and Faith asked her what file. She handed Faith the telephone, and Faith looked at it briefly, slid it back to her, and told her she wasn't worried about that. And that time, did you see what was on the phone? No. I want to direct your attention to December 21st, 2018 and January 3rd, 2019. On those dates, did you receive a series of text messages related to Faith and others on your phone? Yes. Do you recall what your phone number was at the time? Yes. Without saying it, is it still your phone number now? Yes. I'm showing the witness only what is marked for identification as Government Exhibit 958. So now they said it right. Identification as Government 958. Do you recognize this phone number? Yes. What phone number is it? My phone number. I move to admit Government's Exhibit 958. No objection. That's in evidence. Exhibit 958 was received in evidence. Maybe we publish it to the jury. Publish it to the jury only. When you received these texts, did you recognize that number that was that sent them? No. Sent him today. Do you recall the phone number that sent the text to you? Yes. Do you recall the precise number? Not the precise number. No. I'm showing you the witness only what is marked for identification as Government Exhibit 230A. Did you recognize this exhibit? Yes. It's a 3-page exhibit. I'll just show you the pages. Are these certain of the texts that you received from the that number that you didn't recognize? Yes. I moved to admit Government Exhibit 230A. No objection. Those are in evidence. Government Exhibit 230A was received in evidence. May we publish it? Both. To the jury only. Okay. The text in green was that from you to the person who is sending the text. Yes. And at the very top it says 2 people. Do you see that? Yes. Do you know who these texts were sent to? Yes. Who was that? Who received the text from the unknown number? Gloria Allred. Who were the texts? You received the text, correct? I received them, yeah. Were they also sent to your daughter Faith? Yes. Have Faith recently changed her number at that time? Yes. The phone number that sent you the text, I'm going to turn to the second page. Do you see that phone number here? Yes. Can you read it aloud? And there's the answer. Do you see a date, January 3rd, 2019, then additional text from that phone number? Yes. At the time you received the text from this number, was it fair to say that number was not saved in your phone? Correct? Correct. In fact, it shows up as the number here. Correct? Correct. Did you later provide screenshots of some text that you received from this number on your attorney's office? Yes. After you did that, did your phone associate the number that sent those texts with your attorney? Yes. At some point, did a federal agent travel to Texas to take photos of all the texts you received from that number? Yes. I'm going to show the witness only was marked for identification as Government Exhibit 230B. If I may approach, Your Honor, yes. Can you take a quick look at the document I just handed you? Having reviewed Government Exhibit 230B, are those photographs of the text you received from that number from your phone number? Yes. I'll move to admit Government Exhibit 230B. No objection. That's an evidence, jury only. First page can be to everyone. Okay. The date on the top, does that say December 21st, 2018? Yes. At the time these photographs were taken, was this when after you had sent certain of the text to your attorney? Yes. You testified earlier that your iPhone, was this an iPhone, by the way? Did somebody just pop up? No. By the way, yes. Did your iPhone start associated with your attorney? Yes. So where it says maybe and it's redacted, was that your attorney's name? Yes. The first 2, was this an image that was sent to your phone by that number? Yes. Do you see there it is, survivor number 3, Geronda Pace Johnson? Yes. Below that, did the text you say just a sample? We will seek criminal charges. You've been warned. Yes. Was there another image that was sent to you? Yes. Were there various images that were sent to you after that from that number? Yes. I'm going to turn to page 3 of the Government's Exhibit 230B. This is for a jury only. Looking towards the bottom of the page, were you sent by this 312 number an image that said survivor number 7 Faith? The Faith last name? Yes. I'm going to turn to page 4 of the exhibit again for the jury only. Were you sent certain images of your daughter Faith and certain photographs or text messages? Yes. These are the images you were sent? Yes. Does it appear to have some text below each line of images? Yes. Then these are the text messages, photographs of messages you were sent? Yes. Below that, does it say to be continued? Yes. In green, was that a message you sent back to the person who sent you these texts? Yes. You wrote, who sent this? Yes. Then turning to page 5 of the exhibit, after you sent Who sent this? Did the person respond? Criminal charges to follow? Yes. Then sent you some additional images of other people? Yes. I want to turn to page 15 of the exhibit. This can be to everyone. Did the person who was sending you these texts write publishing soon? Yes. Then how did you respond? Who is this texting? Cash? Were you referring there to Cash that you had met at the Applebee's? Yes. What did you write after that? You are stupid and you were a real man. It said, you are stupid and you a real man. Just call and let's talk about this. It's Faith's mom. Was there a typo in what you wrote? Yeah, yes. When you said if you were a real man, who are you referring to when you sent that? Or Robert Kelly. Was that based on the content of the text that you had received? Yes. Did you then receive a response from the sender saying, no, this is Cologne. My investigation will soon be done soon enough. Yes, there is a response from you in green, correct? Yes, it says, no, seriously, call me back. I have another question. Yes, between the text where the sender said, no, this is Cologne, my investigation will be done soon enough, and the text from you that follows, did you receive a phone call? Yes. And what happened on that phone call? I don't recall. Did you receive a phone call from the same number that was texting you? Yes. And did you recall anything about what transpired on that phone call? I do recall him saying that he was investigated for Robert Kelly. And did he say what he wanted you to do? He wanted me to drop the case. Now, after you sent that text, did you receive text again from the same number on January 3rd, 2019? Yes. And did the text say, pull the plug or you will be exposed? Yes. And we went over just a moment the text you have received, photographs of your daughter, photograph text message you received from this number. Yes. Am I now showing the witness only 18 Government Exhibit 230? This is now just for the jury only. Again, this is the actual images that were sent to you. Yes. And again, it was followed with to be continued. Yes. No further questions. All right. Cross-examination map, please. See that? This is on Cannon. Good afternoon, ma'am. Good afternoon. You testified. You told us that you have received a text from someone by the name of Cologne Don. Yes. And that person told you that he was an investigator. Yes. And you testified and told us that an investigator, Robert Kelly. Yes. Do you remember? So I really don't have to go through that. I really, in the redirect, just one more down. Okay, no further question. Thank you. Be careful. Yeah. Okay. So she testified about seeing a man with the gun, about the Applebee's situation. Did her daughter testify to that too? Yeah, I'm pretty sure her daughter testified to that because that would be corroboration. Okay, pretrial, but the parents pushed her into a relationship with him. Okay. Oh, I'm glad I did land on page 102, 109 too. Look what I found. Okay. This is a sidebar. And this is who? This is Jane. Check this out. This is page 1092 in the what? Transcripts. Okay. The judge says, the judge had a sidebar, okay? She comes back and say, I just want to clarify where we're going here. Okay, let me go up a little bit. Okay. I think I know, but I ruled pretrial that even if the parents had pushed her into a relationship with him, that is obviously not a defense. I mean, they are what they are. But I think that I'm right that the focus on the parents right now is to support your theory that they and she conspired to get money out of him. The judge said that was not a defense. It is on look at the lower, I don't even know how I got to that page. I promise you. I typed in the word faith and it took me to 109 too. I swear for God. Koenig said, so he was trying to try this y'all theory on this stand. Brothers Johnson. Hold on. Where everybody at now? Where everybody at? Huh? Koenig said, get money out of him, yeah. The court extort him. Koenig said, yes. Court, I don't know. I'm sure you have a good faith basis for that. I'm not questioning that, but Koenig said basically, Your Honor, is that she had no interest in music at this time. None. The prosecutors opened up yesterday saying that she was only interested in pursuing her music and Mr. Kelly wanted sex. Judge say, but I precluded inquiry into that. Koenig said, right, I'm not asking that. The judge says, right. Koenig says, I'm trying to be very careful in asking it in such a way to show that basically her parents put great pressure on her and they were really invested in the music career and really interested to try to get her together with him. The judge, I don't think there's anything wrong. I mean, first of all, the jurors are going to have a natural curiosity about where the parents are. But I am going to give them an instruction at the end that even if the parents didn't have a problem with this, they can't consent for a 17-year-old. So I mean, there is hold on. Wait a minute. Hold on, my Facebook just popped out. Now when it's getting good. So I mean, there is going to be some kind of instruction about the limit. So which is called limiting instruction, right? That she will instruct them what they can consider and what they can't with regards to the evidence and testimony's evidence, right? About the limit to which they can consider the parents' involvement. So now I'm at another block for you. Not only she's saying, if you go down this road or whatever with Jane on this stand, because now he was trying to get it out of Jane about some theory with extortion. She said she's going to block it and give the jury a limited instruction. Let me roll it back. So I mean, there is going to be some kind of an instruction about the limit to which they can consider the parents' involvement. Mr. Koenig, I understand that. The judge, but I don't know. I am guessing. I want to give you some latitude here, and I am doing that, but I just want to make sure we are not crossing over into what I've precluded. So I think you need to get to the point where you say there is an extortion, which that's legitimate. Whether her parents were abusive to her, I don't think it's consistent. Just let me finish. It's consistent with that, and I am not sure how relevant it is. So you don't know until you get to the line of questioning. And when you start talking about, and then he goes to talking about extortion, what do you think the prosecution gonna do What do you think the judge is going to say? Where's the motherfucking proof? Hold on. Let me just hear from the prosecutors, and then I'll hear from you. Ms. Geddes, first of all, the witness has now established that she was, in fact, beaten by her parents. That's now out there. There is no basis to go further back into her childhood and make her relive any abuse that she suffered by her parents in front of everybody today. Okay, that's the prosecuting trying to, get the shit, the wheels back on track. This is not a trial of the witness parents, and that is what they are making this out to be. You can go forward with your extortion theory in a different way without, she lived in Baltimore years earlier. It's just not relevant when the abuse began or, frankly, the nature of the abuse is. The judge, I don't see that you're going into an exploration of her childhood, are you? Canic, far from that. Prosecutor, but when did she? Judge, but let me just finish. Prosecutor, I'm sorry. The judge say, calm down, bitch. If you have evidence, told you. Oh, baby, you good when you're good, you're good, you're good. Oh, don't play with your mama. I'm gonna put this on up here. Don't ever play with your mama, baby. I'm gonna go on up with my form up on the 3-point line, and I'm gonna back up, and then I'm gonna run backwards. Hold on, wait a minute. Let me put this up. I don't want to hear shit about this theory. No motherfucking more. Put hashtag in there. No motherfucking more. Hold on. Child, see, I told you, the Lord loves me. He took me right to it. Now, didn't I tell you she was gonna, if they were gonna go down that road, what you think was gonna be the next goddamn question? Where's the evidence? Hold on. Roll it back. Hold the line. Hold the line. Just say, calm down. If you have evidence that, and I'm going to say this because you have to say you have good faith basis that they wanted to get money out of him, that's certainly an appropriate area, but only to the extent that she's aware of it. So she got to have evidence. Either she's aware of it, either you got some kind of paperwork, you got some kind of text messages that confirms that, you got something. And so, if there is some evidence, that she's aware of what her parents' motives are, that's fine. But I think there's been enough about whether her parents beat her. I thought she testified that she was in the choir and all these other things. Are you saying that wasn't her own choice? No. The judge says she was in 2 choirs. Can it right? And what's the basis for that? Is that material? Meaning, is that relevant to the case? Is that important to the case? Is that going to prove something? I haven't read all the materials. That's what the judge said. The prosecutor says, what is in the materials is that her parents put pressure on her to succeed in the music world. There's nothing in there saying that she didn't want to do Patriot Singers or the other activities that they did. But I still don't think we need to go any further into any physical abuse that the witness, that the VIC, I don't know what it is, judge say, to the extent that it's relevant. I don't know. It seems marginally relevant at best to this extortion business, unless you are saying they forced her into it, which I don't take that to be your argument. Kenneth said no. Judge says, I take it your argument is that they are basically stage parents that don't really care about their child's welfare and have turned sort of a blind eye to what's happening to her, but I don't know how helpful that is to your case. Meaning, is it relevant to his defense? Because I told you, the evidence got to be relevant to the defense. Going down the line of questions, all this, that, and the third. We already went over that all the time, right? Tell you that all the time. But that's not my point. Mr. Cannon, right. Judge say, but if you have evidence that there's a line of inquiry that she conspired with her parents to get money out of him, perfectly fine. Baby, Lord have mercy. Can I moonwalk? Ooh, can I moonwalk? Ooh, 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 ooh. Yes. And it says, yes, we do. Okay. The court said, well, let's go to that and stay away from okay, her childhood, okay? So are we moving past any questions? The judge said, why don't you let me stay in your lane? I'll take care of it. She talking, she telling the prosecutor stay in her goddamn lane. Go ahead on, AD and Donnelly, go ahead on. Mr. Kennedy said, absolutely, because I am not going to listen to you. Huh? Oh, he was talking to the prosecutor. Okay. The judge say, all right, let's move on. Ken said, thank you. He talking about black panties. Word pit. Person received the black panties. Black panties. Black panty. Black panty. Evidence. So I don't know. I can't perform no miracles. I don't know. But the Lord was tired of me not explaining this, pulling the document, displaying it 200 different kind of ways. The Lord say, my child, type in the word faith, and it came on up to 1092. Yes. And it said, what? Niggas, she's been right, and it's been right. Oh, she's been right. She tried to tell you in 101 different ways, and it even vindicate the brothers Johnson. The brothers Johnsons tried to get it in. The brothers Johnsons tried to get it in. They tried. Almost got in trouble in court trying to get it in. Yes, they tried. Oh, they tried. Brothers Johnsons, I done redeemed you. You're coming back like a big dog now. Oh, Brothers Johnsons, you get cheese on your burgers now. I done brought you back. Back. Oh, yes. Ooh, yes. Honey, they don't come on back. Yes, he tried. What else did you want the man to do? He even tried to bring in Martin Luther King. Oh, the man did all he could do. What else do you want from a brother? Does anybody know? Oh, yes, indeed. What else could the man do? He couldn't come in there and put a gun to the judge's head and say, bitch, allow this evidence. He couldn't do that. What did he have? What did he do? He was probably wearing pointed-toed shoes, looking crazy and like, what? I gotta get it in some kind of way. I tried to slide it in under the guise that your parents make you do all kinds of shit and beat you down and make you sing and all that type of stuff. And I was gonna slide it on in by the, well, since your parents was stage parents and they do all this type of stuff to you, did it make you go and try to get the money from the Kales? Did it try to get the money from the Kales? Did it get the money from the Kales? And the judge said, wait a minute. I done already went over that in pre-trial. And here you come again now. Now, I know. Was he there in pre-trial? Yeah. You was there in pre-trial when I told you. In pre-trial when I told you. But maybe he wasn't there then. I don't know, but he was there now. And the judge said, Yes. I done brought him back. I done gave him CPR. Brothers Johnson's, I done gave him CPR. Now you can put this on your website or put this page number on your website and show them. I tried to get it in. Oh, Lord. So he tried. Ain't that ending on a good note? Woo, child. Do you think that'll be the last of us hearing about this him? Lord have mercy. So when I said them text messages ain't shit. Text messages ain't shit. Not per me, but per Ann Donnelly. Oh, per Ann Donnelly. She don't want to hear it. Unless you got evidence. Told you. Yeah. I tried to get in law group. Get Stephanie, I just died. That girl said that I tried to get it in law group. I'm done. I try to get it in. What y'all want from my brother? I reduced my rate and everything. What you want from my brother? I tried to get it in. So, that says what? Yeah. But ain't that crazy? I just went to it. Now, how y'all gonna argue with me over that? How you gonna dispute that? Yeah, everybody sleep now. Child, let me get on off here, y'all. So, but we ended on a positive note tonight. So I don't know when I'll be able to go back on. But I sure appreciate everybody for coming on through. I sure appreciate y'all for buying my lunch for the next month. Showing appreciate you so much. Coming through, listening and chilling and vibing and arguing and coursing and all of that. And if Miss Henny was in here, she was praying. I sure enough appreciate that, y'all. So, with that being said, so when y'all see the extra tall man from Detroit, and he's over there talking that shit, said you saw it in black and white. You saw it in black and white. So again, I'm going to advise y'all. Champion the defenses, the fucking objections that Jaybo is putting up through her appeals. Run around the streets with that. Unless you just want to, keep calling the parents bad and whatever, which we already, I think that's been confirmed, But the parents as evidence, that ain't gonna work out. Yeah, and if Cause put it on the cause they put on the damn community wall so they won't actually read it. Carly, baby, they're gonna ask me to read it again. They're gonna ask me, baby. It's inevitable. I done pulled out every damn document to show. We had been asked, deliberated on, out everything. The lady done. If they don't never understand the rules of evidence and the rules of for the rules of criminal procedure, I don't know. They ain't gonna get it. So you tell him. When he start dating Sky and all them start talking that shit. Says in black and white. They done talked about it. Yeah. Mm-hmm. Well, anyway, y'all, I sure appreciate y'all. You know what? If y'all get a chance, when I think Atmos is gonna read it at some point, because he probably read it all through, whatever. Now, Courtney, why did you come up and I'm getting ready to go? Why is that? Why is that?
I love you, Miss Angie. Oh, Lord. Nothing. I just want to say hi. Bye. That's
Hey,
all.
okay, honey. Girl, don't y'all better not ask me no more about them goddamn parents. I don't want to hear about no BOP. I don't want to hear about no motherfucking text messages. I just want to hear what Bonjean is talking about. That's what I want to hear about. Don't ask me about. Don't tell me shit I did.
I ain't gonna ask you no more.
Yeah, because he like to say, gee, Miss Walker likes to marginalize the I ain't got to marginalize shit. Ann Donnelly said she did more than marginalize it. She had like the motherfuckers wasn't there.
Well, sometimes when you read it, we hear you. We hear you. But why the fuck we can't call protective services?
Protective services now?
It's too late.
Yeah.
How's it too late and it's small kids running around under the influence of that lady?
Under the influence of who?
Alice ass.
Not no small kids. All her kids grown, ain't they?
Well,
unless she got a daycare, do she got a daycare?
yeah.
Shit, they some hustlers now. They know how to make $1.
Them niggas, you ain't God. You can't.
Them niggas know how to make $1. When I tell you how in the hell you get connected up with R. Kelly, how you do that?
No. But goddamn, Ann Donnelly said they were stage moms, stage parents. I missed that part. Stage parents. Okay, so they got laws for that. Don't they got laws against stage parents trying to hustle their kids?
No, oh my God, no, they do not.
Yes, they do. I thought they did, Miss
Angie. I guess certain things would have to qualify. Would have to come under some type of abuse.
That's why we said, as a last resort, can't we call protective services?
Okay, no. So once again, that will only serve to get her an indictment. Is that gonna get out of R. Kelly?
She need to be indicted too, Miss Angie. Well, but I know you was about to get off. I've been listening to you all on and off at work. I just want to come in and pop at you.
Oh,
and
you
tell you I appreciate you, for opening up my eyes, but it ain't right. This is not right. This ain't right. That's just my personal opinion.
Yeah.
Because you broke the law down. You broke it down like a goddamn double-barrel shotgun, each and every way you could.
I don't know how else to tell you, honey. I don't know what else to tell you.
But that's reckless endangerment of a child. Since they said she was a child.
Yeah, I mean, yeah,
But you know
you
what?
know,
On a more serious note, if it's any people in here, these were some hell of a motherfucking charges they charged this man with. Them was some hell of a charges.
yeah.
Ooh, I ain't never seen nothing like this ever in my life. So moving forward, you know, in the history books, what kind of precedents do you think this sets in the
Well,
case
you
law
know,
by you being a lawyer? What do you
well,
think?
based on the opinions, what they write or what have you, right?
Right.
And they could some case law could have already been generated, right? Every case doesn't result in having case law, but some
Oh,
case law
okay.
yeah, some case law could have already been generated due to this, and it's probably going to serve. And to keep in mind now, case law does not have to be like applicable. It doesn't have to be like the same type of charges or things like that. It has to be the same type of circumstance, same type of
Oh, the
circumstance.
same type of yeah. Yeah.
Yeah,
Okay.
so it could be any, but it just like what the hang up is, it has to be like dealing with that, right? Somebody's trying to get a definition of what a enterprise is with regards to Rico. You can use case law. This is about sex crimes, but you can use case law of a bank or case law of a murdering company, murder people. What I'm talking about, like murderers and stuff like that.
Yeah.
Those
Yeah.
circumstances are similar.
Okay. I got another question. Now, what can we do, or what can after this appeal? I know we waiting on this. I
After
don't
this,
know how to
after
ask the question, but what I'm asking is, like, how can he get out for good behavior? Get at least just do half of the time.
they have so many programs, and I think you get 56 days off a year, and so they be having all them different little programs. Now
Right.
that
So
I
like if
don't
so he the king of R&B, right? So if he start writing some hits up in there, can he get out of there for that? Like that's his job.
no, he can't get out there from writing those hits. He gonna have to do more than that to
More
get
than
out
that.
of it.
Like what? But
Well,
can't
he can take classes. I don't know if they got if he be qualified for any type of first offender program. Hell, I don't know.
damn.
Yeah, that once you get to the BOP portion of it, whatever, that's when I'm out of it.
Mm,
And,
mm, mm.
I was a deal maker.
Yeah.
So
Well, I
my people,
I thank you. I thank you a lot. I really do. You really much appreciated for, giving me a little voice to come on here and say what I wanted to say.
oh no problem. I like
But
my
now
heroes.
in my opinion, in can I ask you this?
Go
In your
ahead.
opinion, do you think he had a good chance with Jennifer Bongini in the beginning?
I believe he would have had a better chance.
A better chance.
Yeah,
So she could have got some of them charges broke down.
it's quite possible, um, but now her going up against Ann Donnelly. Ann Donnelly is very thorough, and she's going to do her own, pretty much her own investigation, because in her response, her order with regards to the new trial and acquittal, how she paraphrased and understood that evidence was was pretty. It was a difference than what the old dude did. You know what I'm saying? But how she understood it and explained how she ruled and all that type of stuff.
Yeah.
Explained, if you read it, she kind of capsulized each of the victim witnesses' testimony as well as the other witnesses. And
Right.
so she was very detailed in what she said.
Yeah, because you keep on finding little nooks and crannies. I don't understand how you keep on finding little nooks and crannies.
Yeah, because y'all be leading me to it. It's due to y'all. Y'all the one that make me think. You know what I'm saying? Make me,
every
put
time
it
we
in the head. That's
every
why I be
time we turn
appreciating y'all.
every time we turn the goddamn wheel to the right, to the left, you just say, you got to go straight. I'm like, well, goddamn. Well, how much language was in this goddamn shit? You be don't pull up nothing else.
Girl, no. Because that Levi, he knows to attack your ass and then ride off in the damn sunset. Your
Yeah.
ass up.
No, he got something for you.
He ain't got shit for me until he go back and listen to this live
You better
all
you.
hours of
I when I popped up in there, you was like, "Where the ball head man
yeah.
from
Man, bald
Detroit?"
head man. I done found this here paper. I promise you. I just typed in the word fake because I wanted to go to her testimony to see what her mother was
Mm-hmm.
corroborating, right? And it
Mm-hmm.
come up. I'm like, wait a minute.
Yeah,
They
cause
talking
she's
about they talking about Jane Doe #5 and the mama and the extortion.
right.
So
But
they brought it up in court.
I already know you went over this. But now you said something that was interesting. You said this was earlier. This was a couple hours ago. You said that with the intent. Why he can't say? I mean, why? Okay, when it comes to the herpes, when it comes to that, fuck it. I said it ain't nothing. I don't
What?
understand what you meant by he in. Did you say he intentionally gave these people these
Um,
girls?
wait a minute, hold on a minute. Let me ask her real quick. Peace and love. I think the parts of her argument that deals with the constitutional violations with regards to the bad acts evidence, the jurors. I don't know how it's gonna work on herpes, and don't know with regards to those charges related to that. But I think she got a pretty good chance with regards to the jurors and the bad acts evidence. If that's the case, then that's a new trial.
Mm,
So it wouldn't only just overturn a particular count. It would pretty much grant a new trial. You know what I'm saying? So
yeah. All right. Well, it's 1 o'clock my time. Shit.
also let me tell you about you
Them
said
herpes.
what was your question? You said
The intent. I thought you said that he had the intent to give it to him. Maybe I
okay.
misunderstood what you were
No,
saying.
right. Jaybo is saying, per her interpretation of the law,
Hmm.
is that his intent was not there. Furthermore, and this is so crazy because I said this when I was doing just playing around with defenses, and I said, he could say, hell, he didn't even know he had it. And if he don't know he had it, how could he intentionally um, infect someone, or how can he disclose his STD status to someone if he doesn't know that he has it?
Right.
Jaybo,
So
right?
also, I didn't mean to cut you off.
Yeah.
Also in the new research for that, you so you saying that a person has to tell a person that they have an STD, but when it comes to herpes, that motherfucker, excuse my language, the way I read up on that, that's a finicky virus. You can give it without an outbreak, and then some researchers say that you can't. Some of the research in the data now states that you can't give it to a person without an outbreak.
Um, I don't know nothing about the herpes like that,
Me neither,
but
but
what she's
I,
saying is that he couldn't have intent, and she's playing with the intent, right?
right.
She's mainly saying that it has to be a specific intent, even though she doesn't say it in there, but that's what she's gearing up
Yeah, and
to.
I can agree with that
And go ahead.
because you that's unfortunate that a person has that, and I'm quite sure that man didn't want to. I don't think he got it. I mean, but that's just another, not to bring that up, but I don't think he intentionally wanted to give that to nobody. Shit, somebody gave it to him.
Right, right. But what I'm
Somebody
saying
gave it
is,
to him.
but that's not what the law requires for you to prove. It doesn't require for you to prove that you intentionally gave somebody the herpes.
Hmm.
It's that to prove that you knowingly had herpes and you exposed somebody to herpes when you were having, sex. And then there's the other parts to it about interstate commerce, going across state lines, and all of that. But
Yeah.
the knowingly part, she is saying that the standard should be specific intent, meaning you knew you had it and you intended to give it to her. She
I,
said the prosecution is having, which is more in line of the law with regards to that, is that it's general intent, meaning um I have it and I got a reason to expect that if I have sex with you, you may or may not, I
get it.
may or may
Get,
not
get it.
infect you with it.
Affect the
And the
person.
unintentional intent, it means that you infected somebody. If we just want to use herpes, you infected somebody, but it was really because you didn't know you had it. It was unintentional, and what have you.
It,
What I'm saying. It's not ain't got
it,
nothing to do with remorse, but it
yeah,
has something to do with just the mindset.
it makes sense. It makes sense because I was listening to you, so I just wanted to pop in at you and just you know, mm, mm, mm. What you watching good on TV?
Girl, I'm watching Vanderpump Rules.
Love it.
You like Vanderpump Rules?
Yes, I do.
Girl, don't play with me. I
You,
love me some Vanderpump Rules, child.
you I like it. I'm down a season and a half. So what I do is when I get down that far, once I go take me a couple of days off, I go on the marathon. But I just ain't been on no marathon lately. But I on YouTube I look at the highlights. But she's rich as green, baby. See,
Mm,
I've been following her ever since. Remember when they all first came out? It was
Real
it,
Housewives of Beverly Hills.
yes, yeah, what, yeah. I like her, and I like I like that dang on Huntsville. I like them.
Oh yeah, Love and Marriage in Huntsville. Yeah, I
Yeah,
watched that.
I like that show, and I was so glad that that girl is winning her battle with cancer.
Yeah, Kimmy. Yeah.
Yeah, I just started watching that, so I got to go back because it looked like it's four season. I didn't know nothing about, so I've
Mm-hmm.
been trying to catch up on that. But I like reality TV too. I look at your wall and stuff. I say, I wonder what Miss Angie watch.
Girl,
Do you
yes,
watch?
honey.
Hmm.
I love that.
I love me some reality TV.
Yes, I do.
Hmm. When you coming back on?
I don't know. I gotta get off here because I gotta get up in the morning. I
All right, I do
don't
too.
know though.
I do too. So I appreciate you. And just know I hit them likes and I do replay them videos. And if I
Thank you,
and
ma'am.
if I don't watch it all, I'm still gonna hit the like and I'm gonna leave me a comment too if I want to.
Yes, ma'am.
All
It's
right,
always
I thank you. I thank you so much for having me.
no problem. Anytime, ma'am. Anytime.
Okay, thank you.
All right. Bye bye.
Bye bye.
Y'all so nice and sweet. Ugh, and civilized. But y'all, that's my time. Sorry to hold you so long. But I got to be out. I will get with y'all later. All right. Peace out, y'all. Love you. Be safe. And make sure you do something good for somebody.